Permitted, my lord, to mention the matter. Your lordship has fixed this suit at 2 p.m. tomorrow. So out of embarrassment, I'm mentioning it. My witness has come, but he wants to try to be examined on commission. So my lord, we have made an
For the other side.
Mr. Shumon Dutt is there. I really wanted to inform my lord's officer that that 2 p.m. slot, let it be there tomorrow. We'll be filing the application today. It might not come tomorrow. That is why. So I don't want to waste that slot.
Okay.
Because the witness is saying that if I can do half here, half, I said, no, you decide. If the commission is allowed, then, my lord, because he'll have to come from Pune, etc. This is only to inform, my lord, that tomorrow's 2 p.m. slot at least, but let the matter remain there. We'll move our application.
Good that Mr. Sharma is not there today.
Which-
My lord, may I be permitted to mention one matter of the monthly list, item number 208 for upgradation, as because we want to file, we want to get that issuance of citation.
What is the number?
PLA 319 of 2024.
May
Your lordship's kindly manner to mention by this matter. It's a testamentary matter. And man already dated 21st August, Justice Patnaik has ordered that affixation and publication will be done and general citation be issued. However, my lord, in the case details where it is showing that the case has been disposed of, so the matter is not being able to be listed, my lord. It is ready for grant of probate.
What you want?
The matter to be listed or
If it is disposed of, what can be done?
at least the matter
Inadvertently.
be, it's out of inadvertence, my lord.
To be
It is
mentioned.
not disposed of. And
May I have your lordship?
this is a testimonial matter, my lord. This is a key application. Key application. Application of paper publication.
Why all the before that citations were issued? What has happened? No notice was not served.
One notice was written.
Ah.
Sufficient of it.
May I have your lordship's kind leave to mention item number 72 of your lordship's today's list, my lord?
Commercial.
I'm mentioning upon notice, my
Commercial.
lord. This is an insurance suit, my lord. This is an application filed by the other side, my lord, for extension of time to file the written statement.
Ah.
And your lordship was pleased to fix this matter on 11th February.
Ah.
My lord, I am humbly praying, my lord, the matter is inadvertently appearing under the heading suits instead of adjourned motion, my lord. In the list. So, my lord, if it is appearing under the heading suits, the possibility of the matter
72.
72, my lord. IFB Industries Limited.
My lord, may I be permitted to mention?
What application they have filed?
Application for extension of time to file written statement. Pleadings are complete, my lord. The matter is ready for hearing.
My lord, may I be permitted to mention one
Right.
matter for inclusion in the list testamentary in uncontested matter? The departmental scrutinization is done.
What is the urgency?
My lord, the executor shall leave India.
They will you.
My lord, kindly.
It will become in the list. If only urgency, it can be taken. No urgency. Yes.
May I have the kind leave to mention, my lord? This is a PLA matter. This is ready for this matter is ready for disposal.
Hmm.
So that it can be listed.
What is the urgency? Ready? All the matters are ready. What is the urgency? Tell the urgency, I will put. Otherwise, all advocates will come. My matter may be taken. What is the urgency? Tell me.
It's all
Yes.
ready for disposal.
I am mentioning, my lord, draw up and complete the order, my lord.
Huh?
To draw up and complete the
When
order.
the order was passed.
Order passed on 24th January and one, two matter, my lord, and one same way, and 24th January, two matters. Draw up and complete those.
Mention a letter of administration matter, my lord. Here, my lord, the department did not accept our affidavit of consent because, my lord, it was not of this time. By my lord's order, my lord had allowed the department to accept it. Thereafter, we have made the corrections. My lord, we need directions to put in the surety and bond, my lord. Otherwise, my lord, this will never be taken up. Therefore, my lord, I was
Put
mentioning.
in the surety and bond.
Yes, my lord, because it's letter of administration 10% or whatever.
So that is the order is passed.
For that order.
So final order is to be passed.
For
Then
that order, my lord.
it is in the list.
So it is not in the list. Not for inclusion, but it's a 22 matter.
My lord, may I be permitted to mention, my lord, this is a testamentary matter. I am paying for inclusion for final grant.
For what? What is the urgency?
My lord, there are supposed to be amendment to be done by our side in the affidavit of asset, and we have ended up that.
Amendment has been carried out.
Yes, ma'am.
Good.
Lord, may I have?
May I be permitted to mention, Lordship? Lordship, by a judgment dated 28 to 2025, your Lordship was pleased to return my plain, Lordship, but the court fees has not been returned, Lordship. I'm just very
At what stage?
maintainability point of
Yes, maintainability point, how the matter in the court fee may be reissued. It
Lord,
got
may I-
married, it was decided.
But may I have your Lordship's kind leave to mention, my Lord, item number 98 from your Lordship's list, my Lord. It's a non-contentious PLA. My Lord, I've taken out a master summon, which is GA1, praying for certain interim reliefs in view of the financial year ending, my Lord. If your Lordships could kindly list my application.
What interim relief you prayed for?
My Lord, I have to safeguard the estate of the deceased. For that, I have to make certain statutory payments, my Lord. The demands are being raised upon me. If your Lordships may kindly keep it under the heading to be mentioned. I'm grateful.
Yes, call the
May I be
next.
permitted to mention, your Lordship, item number 82 of your Lordship's commercial list. Your Lordship, 120 days of filing the written statement is expiring on this Thursday. My Lord, everything is ready, my Lord. I'm praying for short service of the application.
Where is your written statement?
It is ready, my Lord.
Affirmed?
Affirmed.
Leave is granted. When the 120th day is going to be, when you receive the writ of summon?
I have received the writ of summon on 19th November, on or about 19th November.
So your 120 days is over.
No, your Lordship. 19th November, your Lordship, 120 days is coming to 13th of March, 13th or 14th of March.
Leave is granted to file the same in the court in course of the day, subject to acceptance by the.
My Lord, may I be permitted to mention, my Lord, item number 27 of the non-commercial list of your Lordships. Now, my Lord, this is a suit, my Lord, challenging the conduct of elections and the electoral role in an association. Now, my Lord, the reason for urgency is that the elections may be conducted anytime after 31st of March. My Lord, it's a Section 8 company. Once the accounts are prepared.
Item number?
Item 27. There is the Eastern Krishna Daga versus Eastern India Motion Pictures Association. Now, the urgency is that after 31st of March, anytime until August, the association can hold its election. We are challenging the conduct of elections as well as the electoral roll which was prepared for the last election.
If the notice has
my
not been,
Lord, everything is there, my Lord.
Sir, my Lord, that the election, my Lord, is due in September.
It's the last
Might be,
date.
my Lord, in August it might take.
That is
place.
the outer limit.
if the notice is not been issued for the election, how?
No, my Lord, my point is, my Lord, the trial has to commence. The judge's brief has been filed. Everything is ready. Trial has to commence, my Lord. We will be praying for a commissioner to be appointed so
So
that
it
the
is
trial.
the 27 in,
Item 20.
under the heading.
Last week it did not get taken up, my Lord. It was it got 19 and then
adjourn motion, it will come.
Very
It will
good.
come. It will not
Very
be
good.
then mentioned.
Very
Yes.
For inclusion of a probate application, Your Lordship, the scrutiny is complete. I'll just be praying for issuance of citation in this.
Huh?
Issuance of citation in this.
Citation?
Citation. Your Lordship, because one of the legal heirs, she is not traceable. She is the
PLA.
PLA. Your Lordship, she is the daughter from earlier marriage. Grateful.
Yes, call the matter.
Your Lordship, may I be permitted to mention a matter, Your Lordship? Your Lordship, I'm renewing my prayer. On Friday, Your Lordship, I have mentioned one matter, PLA matter, Your Lordship, wherein, Your Lordship, I have applied for a loan. But, Your Lordship, due to the pendency of this probate, Your Lordship, I am not able to proceed for that. I had mentioned it before Your Lordship on Friday.
So what do you want?
Your Lordship, I am praying for upgradation, Your Lordship.
Upgradation? What will be a prayer? What is a prayer? Upgradation? The court will upgrade. What order you seeks for? What order you are praying from this court?
Your Lordship, it has to be decided by Your Lordship. It has to come before Your Lordship. I mean, if you please.
What? My Lord, I do appear for the plaintiff.
Yes.
My Lord, I will just present a plaint, my Lord. Suit for recovery of money lent and advanced. The plaintiff is a NBFC which is engaged in the business of lending out money. In 2018, the plaintiff has lent out 73 lakhs to the defendants for a period of 5 years on the promise that the defendants will pay interest from time to time and the principal as well as whatever the overall amount after the expiry of the loan tenure. Now, all these loans, this 73 lakhs was paid in 3 parts. All these payments were made from the bank account of the plaintiffs situated Axis Bank, Shakespeare Shawnee Bank, situated within the jurisdiction of this honorable court. All these 3 payments. Now, so interests were paid by the defendants. some interest was paid at this branch itself, at this Axis Bank Shakespeare Shawnee branch within the jurisdiction of this Honorable Court. Certain interest have been paid to another bank account of the plaintiff, which is at Skoshba branch, which is HDFC bank, which is situated outside the jurisdiction of this Honorable Court, my lord. Now, certain cause of action has arisen outside, certain has arisen within. So I am seeking for a leave.
How
And
cause of action within and how cause of action outside?
My lord, will kindly see para 3. No, no, 3 outside.
Your office is outside.
My office is outside, but my bank accounts are within the jurisdiction.
Defendant number 1 is also outside. All
the defendants are outside.
All are outside. So
All
how the cause of action within?
Within is within. I have received payments that your lordship will see. Para 6 is the transfer was made within from within. Different sums of money. 14 lakhs, 9 lakhs was made within. 50 lakhs within. All this payment, and I have received payments on account of interest. That's also within.
So appearing for the plaintiff. The plaintiff has filed the plain suit for recovery of an amount of rupees 92,08,370 along with interest at the rate of 12% per annum. Counsel for the plaintiff submits that though the parties to the suits are outside the jurisdiction of the court, but transactions have been made within the jurisdiction of this court. As such, part cause of action arose within the jurisdiction of this court and part cause of action arose outside of the jurisdiction. According to counsel for the plaintiff, prays for leave under clause 12 of the latest patent, 1865. But the learned counsel for the plaintiff perused the plaint and the materials on record. This court find that part cause of action arose within the jurisdiction of this court, part cause of action arose outside the jurisdiction of the court. Accordingly, leave under clause 12 of the latest patent 1865 is granted. Plaint is admitted subject to his proof.
As my lord has seen, all the defendants are outside. They are all in Haryana.
That is stated. All the parties are outside of the court.
No,
But
only I want to serve them by way of email in addition to the usual courts.
go to the master. Master will do that.
Again, master, one application. Very well, my lord. I'm really grateful. One more application. Grateful.
Lordship, I appear for the plaintiff, Lordship. Lordship, in light of the recent judgment passed by your Lordship, I'm seeking leave to withdraw and file before the non-commercial bench, Lordship. Suit for damages and declaratory relief, Lordship.
Damages and what order passed?
Lordship, in a similar matter, Lordship had held that it's not a commercial dispute and the plaint was returned, Lordship. Same suit we had filed for recovery of damages, and Lordship, court fees may also be returned, Lordship.
Supreme for the plaintiff. The matter is fixed today, the presentation of the plaint. When the matter is called, counsel for the plaintiff submits that the plaintiff has inadvertently filed the suit before the commercial division. And as such, he intends to withdraw this present suit with the liberty to file the suit before the appropriate court, as the dispute is not covered under the Commercial Code Act. Consider the submission made by the counsel for the plaintiff. Plaintiff is granted liberty. Full stop. Consider the submission made by the counsel for the plaintiff. The plaint is returned to the plaintiff. The liberty, along with all documents, with the liberty to file before the appropriate court. The court fee be returned to the plaintiff, be refunded to the plaintiff, and the plaintiff has the liberty to use the said court fee if the plaintiff intend to file the same suit before the appropriate forum. Police, the department is directed to keep the copy of the plaint along with the document, Xerox copy of the plaint along with the document for the purpose of record of this court. CS Comp 2025 is dismissed as withdrawn with the liberty to file before the appropriate forum.
Highly obliged, Lordship.
I appear for the plaintiff, my lord. This is a suit for specific performance and, my lord, damages the property situated within the jurisdiction of this court, my lord, and the
It
defendant.
has come to you.
My lord, the only issue is
Call
that
you.
is, my lord, we have paid the court fees, my lord, by, my lord, the electronic mode. The difficulty is that, my lord, it was affirmed on 24th of February 2025. The court fees was paid, my lord, if your lordship see on the bottom, at 1841 hours. The department is not accepting, my lord, unless the leave is granted, my lord, to accept the court fees because it was not paid within the office hours.
So and so appearing for the plaintiff. Though the matter is listed under the heading presentation of the plaintiff, but this court find that the plaintiff has not paid any leave from this court. To the counsel for the plaintiff submitted the matter is listed before this court only on the ground that the plaintiff has deposited the court fee on the online mode on 25th of February 2025.
24th of February.
24th of February 2025 at 18:41 p.m. As the plaintiff has paid the court fee after the court hours and as such the court fee deposited by the plaintiff has not been accepted by the court, and the counsel for the plaintiff raised leave to accept the court fee paid by the plaintiff through online mode on 24th of February 2025. In view of the submission made by the counsel for the plaintiff, the department is directed to accept the court fee paid by the plaintiff on 24th of February 2025 on online mode on 1841 hours.
Item number 4, I am appearing for the
Appear for
petitioner,
defendant number 6 and 7.
being led by Mr.
Your
Thakkar.
Lordship, I'm
appearing
appearing on
virtual.
behalf of defendant numbers 11 and 12, Your Lordship.
May I beg to appear for the petition on virtual mode? Please permit me to appear.
Yes.
Now, my lord, I appear for the petitioner. Am I audible, my lord?
Yes, yes.
Now, my lord, your lordship remembers the facts. I'm not troubling your lordship with the facts.
Yes.
And initially, an ad interim order was made. The matter was heard. None of the respondents chose to file an affidavit. Then they went up in appeal from the specifically recorded in your lordship's order that opportunity given to file affidavits not to be filed. They went up in appeal. The appeal court was not pleased to interfere with your lordship's order because it proceeded on the basis that whatever is stated in the plaint is to be true and correct, since they have not used an affidavit. Now, after that, the respondent number 6 has used an affidavit. In its affidavit, the respondent number 6, apart from the legal argument that there is no privity of contract, makes 3 factual submissions. One is that it was not aware of the existence of the plaintiff till the FIR was filed. This I've shown your lordship to be false. The second was that it was not aware that the goods which were being supplied to it by it to the defendant number 1 were intended for use by the plaintiff, were meant for export to the plaintiff. That also I've shown your lordship to be false. Now, the third statement which it makes is when the plaintiff states, my lord, that the defendant number 6, the sales manager of the defendant number 6 and the defendant number 7, who's the director of the defendant number 6, told the plaintiff's director that you pay monies to the defendant number 1 and we will supply the goods to you. That statement has not been denied because the affidavit is sworn only by a power of attorney, as against my affidavit sworn by the director of the plaintiff to whom these representations were made and who came from Italy to swear the plaint and the petition. And here we have a company who's in Calcutta whose, my lord, director does not come forward to deny these facts on oath. So these are the factual statements. Now, my lord, to show your lordship the fraud perpetrated by defendant number 6 in collusion with the defendant number 1, kindly permit me to place before your lordship 2 charts. Please hand over chart 1, please, Mr. Gupta. Now, my lord, the allegation of the defendant number 6 is that whatever payments we have received from the defendant number 1, we have supplied goods. In other words, they say that if defendant number 1 has paid me rupees 500, I have supplied goods worth rupees 500 to defendant number 1. Now, this is premised on certain invoices which they disclose. They disclose certain invoices and purchase orders, that these are the purchase orders placed by defendant number 1 on defendant number 6, and defendant number 6 says that I have supplied goods according to these purchase orders and these invoices.
Yes.
I sent them 2 letters, my lord. One, and they filed a written statement also in which this is the same stand and same documents. So I send them first, I give them a notice that give me inspection of these documents which you've relied upon in your affidavit. They refuse to do so. Then I give them notice, please produce the documents for inspection in court at the time of hearing. This
Correct.
also they refuse to do so. Why I do say this, my lord, is because I reasonably apprehend that these purchase orders and invoices are fabricated. These
Okay.
are fabricated documents brought into existence for the simple reason that the defendant number 6 want, and in collusion with the defendant number 1, they want to show that whatever payment defendant number 6 has ultimately received, goods have been supplied. So these invoices, my lord, are at an inflated value. They do not reflect the correct transaction between D1 and D6. Now, for this, to establish this, my lord, I rely on 2 charts. Kindly hand over, Mr. Gupta, kindly hand over chart number 1.
Yes, I've
That is
already.
given here.
Yes, now your lordship kindly takes chart number 1. The first column of this chart, my lord, has the invoices. I'm sorry, my lord, the price of the sales contract between me and the defendant number 1.
Yes.
Your lordship will see first contract, high carbon ferro manganese, and I've given the equivalent conversion rate between euro and rupees. Now your lordship sees the defendant number 1 enters into a contract with me at 795 euro,
Correct.
which works out to approximately 65,000 rupees.
Yes.
Now, to supply me these goods, he enters into a contract ostensibly with the defendant number 6 at 852 euro.
Correct.
So therefore, my lord, on each contract, he's suffering a loss of 5,000. And this is common in all contracts. Now, your lordship sees second contract enters into with me at 700 euro and ostensibly with the defendant number 6 at 776 euro. So in
Yes.
each and every contract, your lordship, the defendant numbers 1 and 6 would have your lordships believe that defendant number 1 is incurring a loss.
Yes.
And the invoices which they rely on, of course, there's nothing in evidence on that. So your lordship, defendant number 1 is a commercial entity. Its whole intention is to make profit. And in 5 contracts, all 5 contracts, he is making a loss. Now I tell your lordship why the rates in the second column are not to be believed. That is the rates between, the third column, the rates between D6 and D1 are not to be believed. I tell your lordship why. These, my lord, goods are export commodities. There is a duty which is charged by the customs as export duty. That export duty is worked out on the basis of the sale price.
Correct.
Now, my lord, the government of India has framed the minimum sale price under which these goods cannot be exported from India. Therefore, the government says, my lord, that I will charge duty at, say, 500 rupees a ton. And even if your invoice says 400, the duty will be charged at 500. So according to the
remain same.
Duty will remain same. Duty will remain same. Irrespective of the invoice value of export, the duty will be at 500 rupees. So therefore, my lord, the government is of the view that the minimum selling price of these goods cannot fall below 500 rupees on an export transaction. Now, your lordship kindly takes the third chart number 3. Mr. Gupta, please hand over chart number 3.
Yes, I'm handling.
Now, my lord, kindly sees what is the customs duty? What is the rate at which customs has fixed duty?
Yes.
Kindly see so I have given the commodity, which is the first contract. Then I have given price under the sales contract, which is my contract, is 795.
Correct.
D1 is ostensibly buying from D6 at 852 euros for local sale in India.
Correct.
Whereas the government prescribes a export price of 819 euro. So, my lord, the defendants would have your lordship believe that their transaction inter se is even more than the government fixed price.
Correct.
And this your lordship will see in each and every contract, because their inflated invoices are even more than what the government feels is the reasonable selling price of these goods.
Okay, that if it is so, it is with regard to the department. You are
Yes, my lord. I am trying to show the fraud, my lord.
Okay.
I'm sorry. Is there some disturbance at my end, my lord?
No, not your hand. ये क्या हो रहा है? ये अच्छी. हाँ? Background thing.
There's some
It
it's
is from your background, Mr. Thakkar?
My lord, kindly give me a minute, my lord. I'll just change my place, my lord. Kindly give me half a minute, my lord. Kindly give me half a minute. Am I audible, my lord?
Yes, yes. Till such time my learned senior joins, could I try and assist your lordship? But if your lordship kindly sees the chart, this one which I had handed over, kindly sees the last column. Your lordship would find the index price. Now kindly takes a look at the affidavit in reply which we had filed. To the different number 6 is application. I'm sorry, the opposition. Yes. Kindly takes a look at page 78, my lord. Now, these are the indices of the commodities from the Ministry of Commerce and Industries website for the particular period. We'll kindly have a look at the nature of the commodity at page 78. Your lordship would find that it is ferro-manganese carbon. Yes. And kindly sees the HSC code. Your lordship would kindly take a note of this. The HSC code in the second column, 720-21100. Has your lordship got it? Yes. Now, from this, this calculation, 78 is the total quantity which has been exported. The total amount. This is page 78 for that particular time. And page 79 is the total quantity. No, this is a export quality.
This is the export. This is for the export. Your lordship would kindly see the heading export commodity wise. There's a heading in both the pages, 78 and 79.
Yes.
It is export commodity wise.
Correct.
And values in lakhs divided by, the values in lakhs your lordship would find at page 78. Then divided by, your lordship would see the quantity.
Values in like where it is.
Kindly see page 78 at the top right.
Acha.
Your lordship would see values in rupees then lakhs.
Correct.
So, quantity of this much of product, and kindly sees the period, that is, this is May.
Yes.
When the first contract was executed, May 2020, your lordship would find that on the second column. There is May 2018, then 2020.
Correct.
And kindly turns over to the next page, page 79. This is quantity. Your lordship would see the right hand top. The previous one was value in lakhs. This is quantity.
Correct.
And your lordship would find May 2020 figures is 16,160.
16,160. Yes.
So, dividing the quantum at page 78 with this the quantity
16,160.
Yes, this is the index price, which is 819.
So 16,160 or it is a 0.00.
Yes, 0.00.
0.00. 16,116 is to be divided.
The previous figure 22,317. I'm sorry, 14,561,915.
Correct.
Is to be divided by
this
16,160.
Yes. So it will come 89, 819.
819. 819 into 82. So this would be the price of euro.
That is a euro.
Yes, this is rupees. Then we have to convert it into euro. So that is why the chart we had shown 60.
So euro at that point of time 82.14.
So this calculation comes down to 67,158, then divided by euro price at that point of time, which is 82.14. This comes down to
817.
817.
Here we 819.
It's around that.
Page 78 is 79. Okay.
Yes. So it's firstly, we are this page 78 is the total quantity for that month, the total rupees for this month. Then divided by page 79 is the quantity. We get the per kg price of this this commodity in rupees.
So you are
then converting it.
You are taking into consideration of the total value of May 2020 or May
2020.
May 2020.
May 2020. Not 2019. The reason being the first contract is of May 2020.
14,56,000. No, 14 crore. 1 crore 45 lakh 61,950.
1 crore, yes.
1 crore 45 lakh.
45 lakh 61,950. Yes, grateful. Grateful. So this is in lakhs. This is into lakhs, my lord. This
915.31 divided by 16. 79 is 16 is the total quantity. 16,160. Okay, then.
So, this way, we are arriving at the figure of the index price. So, if this is 819 euros, the plaintiff, the defendant number 1 has got the plaintiff to enter into a contract for a sale price of 795, which is less than the index price. It's an export. Even then, below the index price, the defendant number 1 has induced the plaintiff to enter into the contract. But he is in a domestic transaction.
How you can say the index below the index price?
819 was the index. Now kindly see the second column 795.
But Mr. Thakkar has argued that the government of India has fixed the rate of 500. Where from you get?
No, he was giving an example. He was giving an example that say 500 and
Okay.
you cannot sell it. This is for this, that 500 millet is 819 for this millet. He was, but I think he has joined. Millet.
Yes.
I'm so sorry, my lord, for the interruption. So,
Mr. Gupta continued with that. No problem.
I'm sorry, my lord, for this. Now, my lord, so your lordship sees from this chart that the transaction between me and defendant number one, which is at an arm's length transaction, is at a certain rate which is slightly below the customs price. The government will always fix, my lord, the highest point. The government will not fix the rate which is below what it which it thinks is below the rate.
Correct.
So, my lord, so for export, now your lordship says the rate fixed by between D1 and D6, the ostensible rate as I call it, the second column of that is a rate which is even higher than the government rate.
Correct.
So, if this rate were to be correct, then my lord, the index government is suffering a loss of revenue on every sale which is taking place, because the D1 and D6 sale is much higher than even the index price, which would result in loss of revenue to the government, which the government also will not allow. Because your lordship, this is almost, I can say, if your lordship permits me to say, common sense, that the government duty rate will always be at the highest. For example, the registry office, the circle rate which the registry office fixes on stamp duty for immovable property transaction, that is always on a higher side because government revenue is involved. So even if the per square feet rate is say 20,000 rupees fixed by the government, the market rate will be 10,000, 12,000, 15,000, whatever. The government will not lose out on revenue, my lord. It will fix the highest rate. So
because
two things come out.
Government will take the maximum value, not the minimum value.
Please.
Correct.
Please, my lord. So now the maximum value which according to the government for this commodity is 819 euro.
Correct.
But the defendant number 6 is selling to defendant number 1 at even the highest values fixed by the government, my lord, 852 euro.
Correct.
This shows, my lord, the fraud that the price between D1 and D6 is an inflated price and these invoices are fabricated. They brought this into existence to show that whatever money D1 has paid to D6, D6 has supplied goods of that value. Because otherwise, my lord, my clear case would be that, see, you have got you have got at say 780 per euro and you have not supplied that much commodity. So please return my money to me. So to overcome that, my lord, they inflate the prices between themselves. Yes. That is why, my lord, this price is inflated. For example, my lord, in a normal transaction, your lordship kindly contemplates 795 euros, defendant number 1 is selling to me.
Yes.
So I would take it, my lord, any ordinary businessman of reasonable prudence would be buying from the defendant number 6 at a price less than 795 euro. See, even 794 euro. So he pays the defendant number 6 at 794 euro.
Yes.
So accordingly, defendant number 6 would have to supply the contractual quantity worth 794 euro to defendant number 1. Defendant number 6 has not supplied this quantity. Defendant number 1 has not supplied me the contractual quantity. Yes. And what now defendant number 6 says that I have supplied whatever I was supposed to supply at 852 euro. Yes. So that is where the fraud comes in, my lord. You inflate the price and you reduce the quantity.
Yes.
So this is the fraud which D6 and D1 in collusion have perpetrated upon me. Okay. Now, my lord, we are at the stage of affidavits, at the interlocutory stage. Correct. This fraud can be further established in trial when, my lord, defendant number 1 is, I call upon defendant number 1 to make disclosure of the contracts which it has entered into during that period. Because this contract cannot be at 852 and the normal and the other contracts which it has entered into at 700, this fraud will be clearly established. Okay. So at this stage, my lord, this evidence is prima facie evidence of the price between D6 and D1 being inflated. And for this reason, my lord, D6 does not give inspection of the invoices and purchase orders. Okay. Now, my lord, in a civil trial, your lordships have always held that it is a case of preponderance of probability. Unlike a criminal trial where, my lord, it has to be proved to the absolute. In a civil trial, we go on preponderance of probability. And fraud, my lord, now your Supreme Court has held, my lord, that fraud is a secret device. If a person who has been defrauded can never establish with exact mathematical accuracy what is the fraud perpetrated upon him, He cannot join all the links which are necessary in a criminal trial to bring home guilt. That, my lord, standard of proof is not high as a criminal trial. For that, kindly hand over Mr. Gupta. 1950 SCC, page 766. This is a larger bench decision of the Supreme Court, my lord, delivered by.
My lord, we'll
Nine-
kindly take this. That is both side print, my lord. No, 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 no.
Yes.
1950 SCC 766.
Yes.
For bench decision of 4 honorable justices of the Honorable Supreme Court. Now, kindly come to paragraphs 9, 10, and 11. Here, the case was of a Benami sale. Kindly come to paragraph 9, 10, 11, and the fraud perpetrated therein. Kindly see paragraph 9 onwards, my lord, at page 775.
Yes.
There can be no question that the conduct of the respondent was fraudulent within the meaning of section 48 subsection 2 of the Civil Procedure Code. Though Benami transactions are common in this country and there is nothing per se wrong in a judgment debtor purchasing property in another man's name, we have to take into account all the circumstances attending the purchase and his subsequent conduct for finding out whether it was part of a fraudulent scheme on his part to prevent the judgment creditor from realizing the fruits of his decree. So, Mala, there was a decree against Mr. X. Mr. X bought a property, but in someone else's name, as a Benami property, because otherwise that property would have been attached for the satisfaction of the judgment debt. Now, kindly see paragraph 10. Fraudulent motive or design is not capable of direct proof in most cases. It can only be inferred. The facts before us leave no room for doubt that the true object of the judgment debtor was to prevent the execution of the decree against the Probate newspaper which he had purchased. Probate newspaper was a concealed asset, my lord. Other persons were shown as the printer and the publisher of the newspaper, while Abhyankar was mentioned as the proprietor. So this was the Benamdar, my lord, Abhyankar. The judgment debtor was, however, operating on these accounts for his own benefit. In the insolvency court, he set up the plea that he was an agriculturist by suppressing the truth about his ownership of the paper and pretending that his income was mainly, if not solely, from the family lands. He kept up this show till April 1944, when probably he felt that he was safe from the reach of the judgment creditor. That is a 12-year limitation period, my lord. Even in his answer to the execution application out of which this appeal has arisen, he had the hardihood to assert that he was not the owner of the paper till April 1944. It should also be remembered that he did not, kindly note this, my lord, it should also be remembered that he did not get into the witness box to explain what other necessity there was for all this camouflage, except it be to cheat the appellant of his dues under the decree. Mr. Setalwa, the learned Attorney General who appeared for the respondent, pointed out that there was no Benami purchase and the holding out of Abhyankar as the proprietor of the Probate did not amount to any false representation or misrepresentation to the judgment creditor, as the accounts on which reliance was placed were accounts opened in the banks and were not ordinarily available for inspection by third parties. This line of reasoning is hardly convincing. What we kindly see this, Malad, what we have to consider whether what is attributed to the judgment debtor does not amount to a fraudulent scheme or device for preventing execution of the decree that has been passed against him for a very large sum of money. And this is the next paragraph, next sentence I rely on, my lord, very strongly. In the very nature of things, fraud is secret in its origin or inception, and in the means adopted for its success. Each circumstances by itself may not mean in much, but taking all of them together, they may reveal a fraudulent or dishonest plan. So, my lord, the fraudulent scheme which has been hatched by D1 and D6 is secret to D1 and D6. I cannot know the full details, my lord, because only these two parties are privy to this. But from the surrounding circumstances which are there, my lord, I want to convince your lordship that this is fraud perpetrated by D1 and D6 of taking huge monies from me and not giving delivery of the goods to me. First fact your lordship will consider D1 buys from D6 at rates which are substantially higher than the rate which he sells to me. Second fact your lordship will consider, D6 selling to D1 at higher than the index rate prescribed by the customs. Third fact your lordship will kindly take into consideration, D6 refuses to give inspection of the purported purchase orders and invoices which I say are fabricated fraudulent documents. These are, my lord, all the circumstances which put together show that this is a dishonest plan hatched by D1 and D6 to defraud me.
So what has happened to these materials? What has happened to these materials?
This material I never got delivery of, because what happened, my lord?
So
D6 said
what
that
is
very
the
well,
contact?
you may have.
What is the contact between what you have shown the price and all these things as per the document of the dependent number 6? So whether this material was supplied to you?
Yes, my lord. Part of the material was. So, my lord, may I just give an example? Kindly don't take the figures as I say them. I paid 1,000 rupees to D1. I paid 1,000 rupees to D1 at a price of, for 10 kgs at 100 rupees. 10 kgs, 100 rupees, 1,000 rupees I paid to D1.
Correct.
D1 places an order. Now, what D1 does, he places an order on D2 at 200 rupees a kg. And D2 supplies him 5 kgs. That 5 kgs D1 supplies to me, he does not supply to me the balance 5 kgs, which he is supposed to supply to me at the rate of 100 rupees. So that is where the fraud comes in. D2 takes the full 1,000 rupees, which I have paid to D1. D1 pays 1,000 rupees to D2. I am sorry, D6. D6, I'm sorry, my lord, D6. So D6 gets my 1,000 rupees, but gives me only 5 kgs. And he says that this is what that 1,000 rupees which you have given me. I am not obliged to give you anything more.
Okay.
That is how it is devised, my lord.
Thank you.
So next, that 5 kg comes to me, but not the balance 5 kgs. That is how the fraud is perpetrated. Now, my lord, this is on the factual part of the matter. Now the legal argument of D6, which all the defendants take, my lord. All of them say there is no contractual privity. There is no privity of contract between the other defendants, the supplier defendants and the plaintiff. And they say that you have entered into a contract with D1. We are not concerned with that. You have not entered into any contract with us. You have no contractual privity with us. We are not liable for you for any amount. Whatever excess money you have paid, that you have to take from D1. This, with the greatest of respect, my lord, is incorrect in law. Why I say this is, my lord, what is my case? May I just recapitulate for half a second? My case is that I met defendant number 7. I interacted with the manager of defendant number 6. Both of them told me that we are aware that you propose to enter into contracts with defendant number 1. We are also aware of the rates at which defendant number 1 is selling you. If you pay monies in advance to defendant number 1, defendant number 1 will give us those monies. We will have back-to-back contracts with defendant number 1, and we will supply the goods to defendant number 1, who will onward sell them to you.
Yes.
In other words, my lord, defendant number 6, who was a manufacturer, induced me to enter into a contract with defendant number 1 on the representation that the contracts which I enter into with defendant number 1 will be honored by defendant number 6. That is a specific representation because of which I entered into contracts with defendant number 1. And all this, my lord, I have pleaded, to which there is no denial because the manager nor the director have come to give evidence.
Okay.
Now, this brings out, my lord, a collateral contract. This contract between me and the defendant number 6 in law is called a collateral contract.
Okay.
Collateral for the main contract between between the plaintiff and D1.
Yes.
And these collateral contracts are recognized in law.
Yes.
And persons who enter into these collateral contracts, that is, my lord, D6 enters into a collateral contract with a plaintiff, they are held liable for any breach of the principal contract between the plaintiff and D1.
Yes.
That is my legal submission. Now, apropos this, your lordship will kindly have, please hand over Mr. Gupta, 1965 Queen's Bench, page 170. I'll show your lordship two English authorities which have been cited with approval, and our Supreme Court has followed these authorities. May I just show your lordship first the parent English authorities?
Yes.
Now kindly see the action, my lord, at page where the facts are summarized at page 171. Both these cases are identical with the facts of our case.
Yes.
Your lordship has page 117. Well, kindly see the facts. The plaintiff, Wells, were chrysanthemum growers, and the defendants, Buckland, carried on the business of selling sand. On so-and-so date, the plaintiff's nursery manager, Russell, visited the defendant's sand pits, where he told the defendant's manager, Clark, that he wanted a fine sand for propagating chrysanthemum plants. Clark suggested that the defendant's grade B Buckland washed sand would be suitable and handed Russell a sample and an analysis which showed that the sand was being well washed, had a low iron oxide content, and would be suitable for the plaintiff's purposes. Clark assured Russell, that is, my lord, defendant assured plaintiff that deliveries could be relied on as confirming to the analysis. On December so-and-so, the plaintiff ordered through their parent company 3 cubic yards of the sand. On another date, December 28 and January 17, they placed further orders for 6 cubic yards of the sand. Now, my lord, kindly see those orders in order to save transport costs being placed with another company, which often bought sand from the defendants. So this order was not placed on the defendants directly.
Yes.
There was no indication that the defendants were informed that the company required the sand for horticultural purposes. In fact, all the sand had an iron content, which it could not have had it been properly washed, rendered it unsuitable for the propagation of chrysanthemum plants. And as a result of using it, the plaintiffs sustained a loss in their propagation, which was agreed at 2,500 pounds. So, the sand which was supplied by the defendant to the plaintiff was unfit for use. The plaintiff claimed that amount as damages, alleging that in breach of warranty and condition of sale, the sand did not correspond with the analysis, sample, or description, was neither suitable. Now, the defendants contended otherwise. Now, I'm not troubling your lordship for the arguments which were advanced by the parties. Kindly come to Placitum B at page 173, please, my lord.
Yes.
Further, I'm sorry, Placitum B, kindly see further. Your lordship has a sentence further in the fifth line.
Yes, God.
Further, since all but the first load of sand which was delivered by the defendants were in fact ordered by the plaintiffs from a third party, the defendants are in no way liable to the plaintiffs for the alleged damages. So, my lord, the purchase was in 2 lots. One lot which the plaintiff placed directly, second lot which came through a third party. So, they say that for the supplies made to the third party, we are not liable. Then kindly, I'm not troubling your lordship with the reply. Kindly come to the judgment, which is at page 174.
Yes.
Kindly come to paragraph, the next page where the judgment starts, my lord. Before considering the legal arguments, your lordship will kindly come to 175.
Yes.
Now, they consider the facts which are there on the damages. That paragraph deals with damages. So, all this damage assessment the court does. Then kindly come to the next page where they consider the legal argument. The next page is also on legal arguments. Now, kindly come to page 177. All these legal arguments they deal with on damage apportionment. Then kindly come to no order was actually placed. Kindly come to Placitum C at page 177.
Yes. Yes, continue.
No order was placed on 13 December, but 6 days later, they bought sand from the defendant number 3. They did this to their parent company, who were clearly acting merely as their buying agent, and it is agreed. Now, kindly see the next, but not so the later deliveries, to which I must now refer. Now, this is the argument on the supplies made through a third party, but not so the later deliveries, to which I must now refer. On December so and so and so and so, the plaintiffs placed further orders of sand. They did this not directly with the defendants, but with Hall and Company of Red Hill, a firm dealing inter alia with building material, who often bought sand for various purposes from the defendants. The plaintiffs again did purely to save money, for they had ascertained that Hall and Company would sell the sand to their nurseries at an inclusive price of 19 shillings a cubic yard, which was cheaper than it would be for the plaintiffs to pay the defendants 16 shillings 3 dimes ex pit and provide their own transport, as they had done in the case of the first load. Having received these orders, Hall and Company's driver went to the defendant's pit, and although there is no direct evidence on the point, it is accepted that on each occasion what was required was these yards of sand. There is nothing to suggest that the drivers informed the defendant that the sand they were collecting was destined from the plaintiff's nurseries, or that it was needed for horticultural purposes. Kindly pause here for a minute, my lord. In our case, defendant number 6 knew fully well that the goods which it was supplying to D1 were for supply to the plaintiff. Correct. I've shown your lordship the bags, I've shown your lordship the purchase orders, everything. In this case, that was not so. Then Hall and Company paid the defendants for these 3 loads and debited Hancock, etc. I'm not troubling your lordship with. In these 3 cases, accordingly, kindly see the last sentence. In these 3 cases, accordingly, the contracts of sale were, for the reasons as stated above, not between the defendant and the plaintiff, but between Hall and Company and the plaintiffs.
Correct.
Now, kindly see the law. These are the facts which give rise to the present proceedings. As the legal consequences which follow in relation to the first direct sale between the plaintiff may be different from those flowing from the later sales between Hall and the plaintiff, counsel have commendably agreed that out of the total 2,500 pounds total loss, 550 should be apportioned as to what was attributable to the condition of the first load, subject to the issue of liability. So first sale, 550 admitted, no dispute. Then comes the second sale, which was to the third party. That the plaintiffs were induced to buy and use the sand by reason of Clark's statement and his production of the analysis is clear. But there is no suggestion that Clark was other than honest. He was wrong in assuring Russell that the constituents of sand were as the analysis indicated, and in promising in that sand was always measured up to that analysis. At most, he should have said sand would confirm, but his misstatements were innocently made. So even if there's an innocent misrepresentation, that being so, if they are to be regarded merely as statements inducing contracts to buy the defendant's stand, they clearly cannot provide the basis of an action for damages, for it is a fundamental rule that none may be awarded for innocent misrepresentation. My case is, my lord, is a fraudulent misrepresentation. Correct. But kindly read further, my lord. But the plaintiffs submit that the statements made by Clark went far beyond this. By these proceedings, the plaintiffs seek to recover the whole 2,500 as damages for breach of an express warranty by Clark that the defendant's sand contained only these ingredients, that is the quality. They rely, kindly see placitum F, they rely, in other words, upon what has in many of the reported cases been called a collateral contract. And they have themselves, on the well-known words of Lord Moulton in Helbert, Sims and so, it is evident both on principle and on authority that there may be a contract, the consideration for which is the making of some other contract. So in my case, my lord, contract between D6 and plaintiff, consideration is the making of contract between plaintiff and D1. If you will make such and such a contract, I will give you 100 pounds, is in very sense of the word a complete legal contract. It is collateral to the main contract, but each has an independent existence, and they do not differ in respect of their possessing to the full the character and status of a contract. The law reports contain several illustrations of the applications of these observations. Notwithstanding Lord Moulton's warning, that such collateral contracts must from their very nature be rare. They must be proved strictly. Not only the terms of such contract, but the existence of an animus contrahendi on the part of all the parties must be clearly shown. So this is the only caveat. Collateral contracts can be there, but they must be pleaded and they must be proved. So
Yes.
that is, my lord, that is what I've sought to do in my pleadings. The
Yes.
topic is illuminatingly discussed in an article, Collateral Contracts. Fundamental to the conception of a collateral contract is an intention of the part of either or both parties that there should be a contractual liability in respect of the statement. But in this connection, it was well to bear in mind the cautionary words of Lord Denning J in so-and-so. It is sometimes supposed that the tribunal must look into the minds of the parties to what they themselves intended. That is a mistake. The question whether a warranty was intended depends on the conduct of the parties, on their words and behavior rather than their thoughts. If an intelligent bystander would reasonably infer that a warranty was intended, that will suffice. And this, when the facts are not in dispute, is a question of law. Approaching in this way the facts as I have found them, in my judgment, a warranty was here intended and expressed, that the constituents of the sand were as set out in the analysis supplied. And on that basis of that warranty, the plaintiffs entered into contracts by that sand. Much has been sought to be made by the defendants of the point that when the various loads were collected, I'm not troubling your lordship with this, kindly see the next. Then does it make any difference, classitum G, the warranty having been given to the plaintiffs, all the purchases other than the first were made by the plaintiffs from a third party? If that question demands in law an affirmative answer, the results would not be justice, for as I have said, it was purely fortuitous that all the roads were not sold by the defendants direct to the plaintiffs. But in my judgment, such an affirmative answer is not required, as several reported decisions indicate. So this is the settled law on this. The warranty given by the defendant was held enforceable, notwithstanding that the main contract was subsequently entered into between the plaintiff and a third party. As McNair Justice said in the second case, if as is elementary, the consideration for the warranty in the usual case is entering into the main contract in relation to which the warranty is given, I see no reason why there may not be an enforceable warranty between A and B, supported by the consideration that B should cause C to enter into a contract with A, or that B should do some other act for the benefit of A. If Clark gave the warranty, I have found he did it. It would be absurd in the circumstances of the case to regard that warranty as being impliedly restricted to orders placed directly between the plaintiffs and the defendants. As between a potential seller of goods and B, a potential buyer, two ingredients and two only are in my judgment required in order to bring about a collateral contract containing a warranty. A promise or assertion by A, who's the seller, my lord, as to the nature, quality or quantity of the goods which B may reasonably regard as being made animo contrahendi, and B, acquisition of the goods in reliance on that promise or assertion. That is all that is required, my lord. As so-and-so said in Cambridge Law Journal, the consideration given for the promise is no more than the act of entering into the main contract. Consideration is no more than the act of entering into the main contract. Going ahead with that bargain is a sufficient price for the promise, without which it would not have gone ahead at all. And a warranty may be enforceable, notwithstanding that no specific main contract is discussed at the time it is given, though obviously an animus contrahendi, and therefore a warranty would be unlikely to infer unless the circumstances show that it was within the present contemplation of the parties that a contract based upon the promise would shortly be entered into. In my case, my lord, the principal contract was already being discussed, and D6 came and said, you enter into the contract with D1, you pay D1, we will supply you the goods. Yes. Furthermore, the operation of the warranty must have a limitation in point of time, which is reasonable, etc. My lord, in our case, it is immediate.
Yes.
And therefore, my lord, the court in this case awarded the full damages of £2,500. Your lordship will see the last line. So in this case, matches on all fours with our case, my lord. Direct representation by D6 to D1, D6 to plaintiff, induced plaintiff to enter into a contract with D1, part with monies, in the hope that D6 will supply goods to D1, which would in turn come to the plaintiff. These goods did not come, D6 is liable. There is another English decision, my lord, on this point. Kindly hand over 1951 to King's Bench 854.
How much time will take, Mr. Thakkar? 11:30, my matter is there. Other
My lord,
matter.
then, my lord, kindly only make a note of this decision. I'll cite one Supreme Court case, my lord, and then close the matter where both these are relied upon. So we complete this.
In this, which paragraph you are relying upon?
My lord, it's a very short decision. Kindly see paragraph at page 855, the first paragraph. This case raises an interesting and comparatively novel question whether or not an enforceable warranty can arise as between parties, etc. And then your lordship will see the paragraphs are not numbered, my lord, but kindly only make a note of this decision. Facts are similar to ours, and it's a very short decision.
Okay.
I'll show your lordship, my lord, the Supreme Court has relied upon this decision also. But that will take some time, my lord. May I come back on a next date, please, my lord? The Supreme Court will take time if your lordship has another matter.
Supreme for the friendship. For the defendant number 1, 2, 3, and 5. Supreme for the 6 and 7. Supreme for the 10. And Supreme for the 11 and 12.
So different number 10, minute, I'm appearing.
Counsel for the argued at length, but due to paucity of time, hearing could not be completed. Tomorrow 2 p.m. Mr. Thakkar, you will be available?
Yes, my lord. I will be available, my lord, at 2 p.m. Kindly only permit me to argue on virtual mode, my lord. I am not in Calcutta. I'm sorry for this, man. I'm sorry for this. Grateful, man.
My lord, Mr. Aurik Banerjee is appearing for defendant number 1 and 2 and supposed to address your lordship. He is engaged in courtroom number 26, my lord. I'm praying for a short passover, lordship.
Could have been not.
Yes, lordship, it was.
Which matter?
Or any day, tomorrow, day after.
Lord, this is with regard to the restaurant, Lordship room members. Lord.
Yes. Praying for an accommodation, my
We
lord.
have Lord, our application was ad interim
My lord,
reliefs.
12:30 today, if it can be taken up. 12:30, my lord. I humbly beseech, my lord.
I will take at 4:30. You know this court fixed the matter, then you're telling the 12:30. You're not going through the cause list of the court.
No, lordship, I have, my lord.
Part-heard matters must take priority over all others.
That's why the court is fixing the time and date. As per the and this court is not fixing the time and date of the court of his own, taking the consent of both the parties.
Yes, my lord.
Okay, I am adjourning with the cost.
Lord, in fact, your lordship was to take it last week. Mr. Banerjee said he is in difficulties. Whole day matters are fixed in different courts, which is why your lordship kept it today. On a commercial day, your lordship kept it because of our urgency of getting ad interim relief.
On 5th March, it was.
My lord.
Lord, kindly pass an order of injunction and keep it
my lord,
whenever Mr. Banerjee wants.
My lord, half an hour passover, that is all, lordship.
Can't be half an hour, then my other fixed matter will be taken. Your senior knows the matter is fixed at 11:30.
Lordship, if tomorrow, my lord, will take up any time, lordship.
Tomorrow, Lord, we have actually left our other matters because part-heard has to be priority. That's what we've been taught by our seniors. Mr. Banerjee had argued on the question that it is not a commercial dispute. He had argued that
That is the only question which he has to reply with regard whether it is a commercial or not.
Yes, lordship, will not take more than half an hour, my lord. Will
That's
lordship
correct, but
kindly...
what can be done? It is urgent matter. It is fixed matter.
Yes, lordship.
Okay, then I will pass. I will keep.
My lord, kindly, lordship, kindly grants one chance, lordship.
Sorry.
Lordship,
Fixed matter,
kindly.
this court is not allowing the adjournment, madam.
Lord, I'm seeking an interim injunction, Lord. I'm seeking mandatory injunction,
My lord,
Lord, in
anytime,
terms of
lordship, 12 o'clock, my lord.
Sorry.
My lord, then kindly will allow me 2 minutes. May I just seek instruction otherwise?
Yeah, take instruction.
Lordship.
Otherwise, I am passing an order.
My lord, 1 minute will be granted to me. I'll seek instructions.
Page 22, prayer B, if your lordship kindly considers. আরে লাইব্রেরিতে বসেছিলাম, অন্য কোথাও যাচ্ছিলাম না, 11 নম্বর করে মামলা করা হচ্ছে। হতে পারে পাঠার কোথাও তো কোথাও তো বসে থাকতো, যেত না অন্য কোথাও। পাঠার মানে অন্য কোথাও যাওয়ার রিস্ক করেছে। আগের দিন ডায়েরি দেখাচ্ছে, আমার সারাদিন ধরে মামলা আছে। Argument of commercial dispute was on the basis of a judgment which has been overruled by the division bench.
Correct. Yes, what is your submission?
I had made my submissions on the last day. I had indicated 3 letters, my lord, from the my lord application.
Yes.
My stand is very clear that I have surrendered position because I could not run the restaurant. And my lord, this was taken, my lord, the position has been taken. And I also said, my lord, the allegations in the application are not specifically directed against me. So if Mr. Sen is otherwise entitled to an interim order, it should be restricted to D1 and D. Those were my submissions and I relied on 3 letters, my lord.
Unfortunate. Fixed matter, lawyers knows, every bar member knows, fixed matter, it is very difficult for this court.
But that is what we are taught in our chambers. If a matter is part-heard, you can't go anywhere else. However, many other matters one may have.
My lord, may I start Mr. Banerjee's honor?
My lord is, I have the instructions to appear, my lord, on behalf of 16 employees. My lord, this is a restaurant which is being run. Now, my lord, the difficulty is that, my lord, we are the employees. My lord, we are, my lord, some month we are being paid the, my lord, the salaries, some month are not. Now, my lord, if my lord,
How you are connected with the possession of the property?
yes, because my lord, I am,
the salary, go to the different number 3.
Yes, my lord, I am, my lord, my instructions are that, my lord, I am being paid by, my lord, defendant number, my lord, 1 and 2. Now, my lord, those are the, my lord, I have the salary slips and all those things. Now, my lord, if my lord kindly keeps it a weekend,
No question.
I can come back, my lord, I can come back with
Absurd.
an application.
Absurd.
Sorry, yes.
Well, I know, my lord, I have intervened at a wrong time. When my lord,
No, fixed matter, you all bar members
yes,
know.
yes, I know, my lord, I know, my lord, I know. That's the reason I'm saying that I'm intervening in a wrong time. So, my lord, I was praying, my lord, if can, my lord, kindly keeps it next Monday.
No question.
No, you go.
My lord, I can,
you
my lord, come
ask
back,
the-
my lord.
You ask the salary
It's
from
not-
the defendant number 1 and 2. What you will get from this suit?
My lord, I want to intervene.
What? For what?
My lord, I want to intervene, my lord, to, my lord, for my protection.
Sorry.
My lord, for my.
In the property of the plaintiff, you will protect
I am, my lord,
by
we-
giving you to go and run the business.
No, my lord, we are running. My lord,
You are running.
My lord, we are running. My lord, the
Okay.
employees are running. Now, my lord, the difficult.
Employer are running or the employer, the defendant number 2 have been engaged you to run the business.
Engaged.
Then
But the thing is that, my lord, our
okay.
my lord, we are also prejudiced.
Sorry. Yes, madam. Yes, let you continue.
Wait a minute, I'll take a chance.
My lord, kindly takes up their application first.
Yes. The only question Mr. Banerjee has raised that is this is the not it is commercial. satisfy this code, it is a commercial.
Lordship, I wish to make submission with regard to whether a mandatory injunction at the interlocutory stage can be granted based on the prayers that they have made and on the pleadings and the materials that are on record. The injunctions that they are seeking has to be on a prima facie case. The question arises whether or not there are even materials on record for them
Have
to
you gone
seek.
through the interim order, interim application?
Yes, Lordship.
Where is the prayer for the mandatory injunction in the interim application?
May I just submit as I've prepared, Lordship? It is their case that on 4th of July 2023 that they have parted with the possession of the property. Celica has executed a lease deed, parted with the possession of the property, and has given it to the defendant number 3. Defendant number 3 was supposed to run a restaurant business from the said premises. They even started running the said premises, but because of certain financial crunches, they could not. They approached me. They took an accommodation of 1 crore rupees from me and said that it will be repaid back to me. However, they
Who
failed to
approached
do
you?
so. Defendant number 3 approached me.
Correct.
They took a friendly accommodation of 1 crore rupees. I have bank statements to such effect. They took 1 crore. They said they're going to use it for starting up the business because they don't have the financial wherewithal.
Correct.
I gave them 1 crore rupees. They were supposed to pay it back to me as per an MOU that was executed between us.
Between you and defendant.
Between me and the defendant number 3.
Correct.
They failed to honor their obligations, Lordship. Thereafter, a second MOU was executed between us where it was agreed that because they have failed to pay me back the money, they are going to hand over possession of the restaurant business and also they will transfer the ownership, the shares of the defendant number 3 company. So I am out of 1 crore. I am supposed to run the restaurant business. Possession was handed over to me. Now, the defendant number 3 and the plaintiff have colluded amongst themselves and trying to dispossess me. It is their own admission that on 4th of July, they have parted with the property. And on 16th of January 2025, simply a letter was given that I will hand over possession to you. But what documents have they produced to show that in fact possession was handed over to them? I have documents. What documents have they produced? What is on record right now to show that they are in possession? In my very humble submission, they have filed this instant suit in the garb of a declaration to evict me from the premises. If today an injunction is passed or any order is passed, which allows them to have unfettered access to the suit premises, the suit goes. Because
Okay.
I will
Let
be
us-
dispossessed, my lord.
Litigator seniors, let us complete.
With regard to the point of maintainability, I will deal because your lordship is hearing on merits as well as on maintainability. Now, firstly, your lordship will consider on the basis of the case made out whether they are entitled to an ad interim order or mandatory injunction in the nature.
That's why I'm asking you, where is
Give
the
access.
where is the prayer for mandatory injunction in the interim application?
That is what he's asking for. I will
Can you see this?
kindly first take their prayer in the suit.
Suit whatever it is. Now court is considering now
Ad interim, yes.
your submission is that mandatory injunction cannot be
granted.
Kindly see the interim application.
Yes, page 22, kindly see.
Correct. I am there only.
My learned friend has made specific submission that I'm seeking for an ad interim mandatory injunction. Now, apropos to this, what is asking today, prayer B. Order of interim injunction restraining the defendants and on main agents from unlawfully obstructing the entry or access of the plaintiff and or its main agents, representatives and officers in the suit property from wrongfully interfering with the right of the plaintiff, lawful and peaceful control. I think this is the prayer what he's facing today. So kindly see today. It is in the garb, interim injunction, restraining me is in the garb of a mandatory injunction because what they're seeking is an access. They never had any access to the property. That is what we will show. Mandatory injunction is to protect the status, uncontested status of the parties as on the date of filing of the suit. It is not for establishing a new right, which he never had as on the date of filing of the suit. Today, what he is asking for, this plaint and the injunction has been really artistically drafted. Now, the main relief in the plaint I will show, declaration and injunction is in the garb of eviction.
today, if the release which is asking for the declaration injunction, if granted, it will amount to my eviction. The eviction decree that they have not paid for because they do not want to admit that I'm in possession.
Yes.
The moment they seek an decree for eviction, they will admit that I'm in possession. Then they cannot ask for an order of ad interim mandatory injunction, because that will amount to changing in the status of the parties. Now, prayer B is that I should be restrained from giving them access. What does that mean? If that prayer is granted, that means they have an unhindered access to the property. I won't be able to stop them from having access. So today, this is in the nature of a mandatory injunction, because they are seeking a status quo ante. Mandatory injunction is in the nature of status quo ante. They have to establish, your lordship, whether what status they had with regard to the property. I am not disputing the ownership. Ownership and possession are two different concepts altogether. My learned friend might be an owner, being a landlord, but somebody else is in possession. Does that mean that he has possession? No. He might be an owner, but on pen and paper, possession, the actual possession is with me. Why I say so? Kindly take their lease deed first. What is lease? It's under a license agreement. Once you execute a registered lease, you part with possession. You have no control over the property till the lease is determined in accordance with law.
Party entered lease agreement, the party between the lease agreement and he has surrendered the possession. What will be the effect of that?
He has never surrendered. That is what I want to show.
If they surrender,
yes. If somebody else is in possession,
if the lessee has surrendered the possession,
yes,
what would be the effect?
Surrendering possession of the lessee is only surrendering their possession. It is not that
you are the party to the lease agreement.
No, but I have been put into possession. I will show.
So,
I will show.
Where is the privity of contract between the you
privity of contract is not required, your lordship. Suppose a stranger is in the possession of the property.
Show me the document that you have put the possession with the knowledge of the plaintiff. Show me that.
1 second, your lordship, kindly hear me out. Your lordship has heard Mr. Sen for a consultation.
Yes, I am hearing you.
Yes.
I am giving the hearing to you, sir.
Correct. Now, let me tell you, lordship.
If you tell that the court will not ask the question, then
no, obviously
put the mouth shut and I will hear whatever you.
I am not saying
that's
that.
why I am asking. Show me how you have been put in possession of the property. Show me.
Kindly come to the.
You are in possession of the property.
Yes. First, they have to establish. Kindly say, I will come to.
Leave aside there.
They have established they were in possession.
You have taken note of all what the submission, Mr. Now you have making out the case. You are in possession. The third party possession cannot be disturbed
by granting a mandatory
injunction. Show me your possession over the property.
Our agreement. MOU. Let me just tell you, your lordship, what are the facts which has been suppressed with their knowledge. The defendant number 1 and 2 wanted to set up a restaurant in the property of the plaintiff. A lease deed was executed on 4th of July 2023 for a period of 9 years. Now, in the month of August 2024, the defendant number 1 and 2 realized that they are not in a position to run the business and they have been facing losses. And they are also not in a position to pay the lease rentals. Now, what they did, they brought in my clients, defendant number 1 and 2 as investors, saying that we are not able to run the restaurant. You pay the lease rents on our behalf along with the arrears, and they have taken a loan of 1 crore from us. That is under a MOU of 2023.
Who has taken loan?
The defendant number 3, who is the lessee. Now, 1 crore was to be repaid within a certain period of time by the defendant number 3. Defendant number 3 failed to do that. Entered into a second MOU saying that since we are not in a position to pay the money, I am handing over the entire company with the restaurant to you and the possession of the property. But that is how we have come into possession. Pursuant to that, what the plaintiff has suppressed, we have paid 24 lakhs to the plaintiff. The money has gone from our account to the plaintiff. I will show that. Kindly see the bank statement first. Mark Lordship, can I give the mark? It is easier for your lordship to realize. Lordship will kindly see the first statement. 2,64,000. 2,60,000. You are aware of this?
How am I? Don't be stupid.
No, you have accepted the money.
As counsel, you're saying you're aware of this.
Your client is
You
aware.
will not give me a copy, you're saying you're aware of this.
See, you have suppressed this
What
fact.
sort of courtesy is
You have
this?
suppressed this fact in your plain, sir.
Is this the courtesy expected in the Bar Library Club? Sorry.
If you don't want to make the submission, so you can make this
Terrible
interjection.
conduct.
But kindly see, your lordship, 11 December 2024.
You're aware of this.
4,71,000.
তোরা শিক্ষা পাচ্ছিস?
ঠিক আছে।
In this, how much amount? In this, the first document which you handed
First
over?
document, your lordship will see 2,65,000. The
2
second
lakh?
document, your lordship have marked.
2,65,000.
Yes. Then your lordship will see the second page which I have handed over. Your lordship will see the.
This is to the plaintiff.
Yes.
By you.
Yes. Celica name is there mentioned.
Okay. So
পুরো তোরা একবারে দিতে পারিস না এটা সেট করে পুরো সেট দিয়েছিস Now Lordship will see the next bank statement. Lordship will see the money has gone from the different number 1 Pio Feng Chi, who is my client. Next document your Lordship will see it is marked, that is on 20th September 2024. TMK's Entertainment Private Limited. This is also a company of the plaintiff only. They have accepted money from me in name of a different company, 4,95,000. The next payment your Lordship will
4,95,000, 4,71,000.
Your Lordship is looking at the statement of 20th September.
Yes.
Your Lordship is not has found an amount of 4,95,000.
No, 4 lakh. You have marked 4,71,000.
Yes, sorry, this has not been given. Sorry, very sorry. Your Lordship will see 4,95,000. And thereafter, on the same date, 12,44,000. So if your Lordship adds up this amount from September 2024 to December 2024, we have paid a sum of rupees 24 lakhs to the plaintiff. Plaintiff has literally suppressed this fact in their plaint. Why did they receive payment if I had no relationship with the plaintiff, if I had no relationship with the property? 24 lakhs have received. Now kindly see the agreement. That agreement a copy though.
So 4,95,000, 4,75,000 and
yes, your Lordship, sorry, your Lordship has seen that?
First you complete your transaction, then
No,
the court will.
I am only handing it to the other side. Your Lordship will see this.
4,95,000, 4,75,000 and 2,65,000.
12 lakhs, 12 lakhs. 2,65,000 and 12 lakhs.
Where is the 12 lakhs?
Your Lordship on the same statement, your Lordship after 4,95,000, your Lordship will see another figure down on the same date. 12 lakhs, 44,000 paid to Celica. The name is there, Celica.
Okay. Yes.
Your Lordship will now look at the agreement. Lordship, pursuant to this payment and agreement, after this payment were all made after this agreement was executed. Though Celica is not a party, but kindly see the memorandum of understanding. We have handed it over to the other side. 7th September 2024.
Yes.
And your Lordship will note down the payments date 20th September, November and 11 December 2024. All payments made after this agreement.
Yes.
So Lordship will see page number 2. Protabaditya Lairi is the defendant number 2 party, and Seok Jing, your Lordship, is the person who is the lessee.
No, Protapaditya is the defendant number 3 or 2.
Defendant number 2 is Protabaditya Lahiri.
Okay.
Page 2.
Okay.
And your Lordship, the another name Seok Jeng. He is the promoter and director of the defendant number 3 company.
Yes.
Seok Jing. Now your Lordship will see the same page, the last paragraph. Whereas the second part have taken a unit.
Prashant Khanna.
Prashant Khanra, your Lordship, is the confirming party. He was one of the directors.
He's not here.
No, he's not here, but he's one of the directors in defendant number 3, admitted position. Last paragraph, whereas the second part have taken a unit forming a portion of the 5th floor of the building known as Park Center, containing covered area of 4,645 square feet, equivalent to super built-up area of 5,574 square feet, less lying situated at 24 Park Street, by way of DW is executed between the second part and Koldan Bush. DW is the document on the basis of which they are claiming, they are saying that Celica was given the lease. Whereas the second part was facing financial problem.
The DW is?
DW is by page 58. Basis of which Celica is given the property to Seokjan. And whereas the second part was facing financial problem and approached the first part for friendly advance to start up the Barkam restaurant, and whereas the first part has agreed to give the friendly accommodation advance to start up Barkam restaurant business, and whereas the second part has given a proposal to the first part to perform the some activities regarding the startup of the Barkam restaurant and activities on behalf of the first part. And whereas the second part is a businessman and willing to run the Barkam restaurant in the name of Seoul Story at 24 Park Street. And whereas both the parties have entered into a MOU dated in the year 2023 setting for the services provided collaborative. And whereas according to the previous MOU, this is important, Your Lordship. The party of the first part have provided, that is, we have provided a sum of rupees 1 crore as friendly accommodation advance to the second part. And whereas according to the terms and conditions agreed between the first part and the second part, herein, in the previous MOU, the second part has agreed to pay back the said amount within a period of 9 years in installment basis. And according to the previous MOU, the second part has agreed to the first part a part amount of rupees 1 crore at the rate of rupees 4 lakhs per month, only to be given for a period of 2 years before getting the license of the said part. Now, Lordship, this is how the amount has been paid, has been set down thereafter in the table. Now, Your Lordship will take page 5. And whereas now both the parties have agreed to enter into the instant MOU as present MOU, this party of the second part and the confirming party has agreed to transfer absolute right, title, and interest of the said company, namely Siokjang Hospitality, who is the defendant number 3 herein, along with the possession of the said Barkham restaurant, namely CO stood in favor of the parties of the first part in equal share, 50-50. Mr. Protabaditya Lairi will hold 50% and Leo Ching will hold 50%. That is the defendant number 1 and 2 will hold 50%. So it says that along with the company, the possession of the Barkham restaurant is handed over. Possession means with regard to the property which is the subject matter of the suit. The second part and the confirming party has agreed to call an extraordinary GN meeting. This is how the company, these steps are to be taken. Roman 4, to transfer the physical possession of the leased property being situated all that a unit forming a portion of the 5th floor of the building known as Park Center, covering area 4645 square feet. Then Roman 5, page 6, the second part will remain and continue with the said company as an employee managing director and will run the business to earn profit. So the defendant number 3 herein, he will continue, the company will be transferred, he will continue, he will act as an employee to run the business. Then Your Lordship, 3, the party of the second part has a due remaining to rupees 16.50 lakhs, which has to be paid to Celica Commerce Private Limited. The parties of the first part have agreed to clear the dues amounting to 16.5 lakhs on behalf of the second part. That the parties of the said part, in return to the aforementioned due, agreed to pay back the aforesaid outstanding of rupees 16.50 lakhs within 6 months as a monthly installment basis. Minimum amount will be rupees 2,75,000. The party of the second part agrees that if the party of the second part fails or neglected to clear the outstanding amount of 16.50 lakhs within 6 months, the party of the second part will hand over the monthly income of one of the outlets of the company, named King's Bakery. Your Lordship, apropos to this agreement, Your Lordship, this is how we have got the possession of the company as well as the possession of the property which is the subject matter of the suit.
Yeah.
And Your Lordship, this has been done in consonance and consent of Celica. Why? Because this 16.5 lakhs was due from the defendant number 3 as lease rentals. We have paid that. Over and above that, we have paid another 8 lakhs more with regard to the other areas. That is the bank statement which I placed before this court. The Lordship will see they have accepted money on the basis of this agreement executed between the parties. And this is how we have come into possession. And we have been running the restaurant from then. Now, Lordship, what the dispute which has occurred now with my dispute is mainly with the defendant number 3. Is that what the defendant number 3 has done? Defendant number 3 was to return the 16.50 lakhs within a particular period. And the other balance 1 crore which we have paid earlier. Now the defendant number 3 is not returning the money to us. Now I am in a deep soup. I have been placed with the possession of the company. I am running the restaurant. Defendant number 3 has taken loan, has not returned the money. And in the meantime, what I found after the suit has been filed, there's an internal arrangement entered into between the defendant number 3 and the plaintiff to take away my possession by issuing a surrender letter when I am in actual physical possession of the property. But defendant number 3 is not paying my money. Now to evade that payment, I believe they have entered into an internal arrangement saying that I am not in a position to pay. I am not in a position to run the restaurant. You take possession. So I am handing over possession. Ignoring the fact that I was already put into possession pursuant to this earlier agreement of 7 September 2024 on the basis of which I made payment. Now Lordship will see this is just a matter of mere collusion to take my possession without filing an eviction suit. Yes. Kindly take Your Lordship page 113. And plaintiff accepts this fact in his letter at page 113 that I am the incoming lessee of the property. Kindly see. I am going by their own pleadings, admitting them to be true, their own contention. Then also, Your Lordship will see they are aware of this arrangement. Page 113, volume 2.
Yes.
21st of September 2024.
Yes.
sorry, 21st of November 2024, Your Lordship, this plaintiff is writing to Seokjin.
Yes.
Kindly take from the first paragraph. Subsequent to the email sent by Mr. It will be Seok Jang, written Jang Seok, on the 30th July 2024, expressing his inability to continue the running his business from the said unit in the name and style of Seoul Story. We replied thereto on 2nd August 2024 for a meeting to convey and finalize the due process, including concerns towards outstanding dues, which would naturally be as per the covenants of the lease deed entered into. However, thereafter, a meeting was held on 6th August 2024, wherein it was conveyed to us that due monthly rent for July and August 2024, along with the electricity dues, would be cleared by one Pratap Aditya and Freddie Liu. These are the defendant 1 and 2, so they're aware of this. It was further requested of our representative at the meeting that after making such payment, a deed of revocation is to be made for the subsisting lease agreement, and a new lease agreement would be entered into with the incoming lessees, Pratap Aditya and Freddie Liu, who would then continue to pay the lease rent as before, which due discussion were to be held with the management of Celica Commerce Private Limited for their approval. Your Lordship, now I will kindly pause here for a moment. They say that defendant number 3 is not in a position to pay, not in a position to run the restaurant. I will clear their dues, and the plaintiff will enter into a deed of revocation with the defendant number 3 and execute a fresh lease, because we are the incoming lessees.
Correct.
Now, is there any deed of revocation executed? Nothing has been placed. In spite of this assurance, the plaintiff has refused to enter into a new deed of lease with me as well, though I am an incoming lessee, which is what they admit, and they have accepted payments of 24 lakhs. Then, next para, on 21st September 2024, an email was received from Jiok Sang with details of 2 payments having been made towards part of our dues. So these dues were paid by us. Thereafter, on 21st October, another email was received from Jiok Sang informing us that Seokjin Hospitality has been taken over and was now having 2 directors, being Pratap Aditya and Freddie Liu. So they are the defendant 1 and 2, to which we requested for the respective DIR forms for appointment of directors. The respective DIR forms have not been shared with us till date, and in the meantime, multiple reminders have been sent for making payments of our due lease rent, to which we have conveyed by Jiok Sang that the company has been handed over to Freddie Liu and Pratap. Now we find from the official website of the ROC that Jiok Sang ceases to remain a director as on 16th November 2024, and there is no induction of new directors as claimed. In the premises, we give notice for non-payment of rent for the month of September 2024. Part payment only received for 4 lakhs on October and November, amounting to a total sum of rupees 14,71,000. This is the admission that they have received in October and November. Only in terms of clause 18 of the lease deed for making all due payments within 30 days of notice, following which the lease deed shall stand determined, and we shall take back vacant possession of our property without prejudice to our rights to the antecedent breach. And also, fact is that after this notice as well, we have paid a sum of more than rupees 14 lakhs. As on date, a sum of rupees only 10 lakhs were paid. Subsequently, 14 lakhs paid after this notice. The bank statement which I have handed over, that they have not admitted here, neither in the plain.
This notice is of 21st November
2024. Your Lordship will see the last payment made on 11 December 2024. Right?
11th December 2024 and January 11th December. Yes.
11 December 2024. Now the fact is that they were aware of this fact, that defendant number 3 is not in a position, he is leaving the lease, leaving the property.
Yes.
And I am the incoming lessee, he will execute a lease deed with me.
Yes.
And I have shown the MOU pursuant to which I have taken possession of the property. They have accepted money, so they were aware of this fact. Now, plaintiff only to enter into some internal arrangement that I will take possession of the property, even though I will not execute any fresh lease deed with my client, even though they have admitted. So somehow he managed the defendant number 3 to got a letter executed, and that is how they have come before this court to claim possession. Now, Your Lordship will see the next letter at page 116. They also say that they will only take possession once the surrendered deed is executed. There is no surrender deed on record. Kindly take page 116. 28th December 2024, second paragraph. As you have put across your extreme financial distress and considering your willingness to clear all the outstanding rentals till 31st December 2024, including the dues towards utilities, subject to your handing back possession, vacant and feasible possession after removing all the installments by 15th January, we would consider terminating the lease deed. We would consider to take the same forward, we would be disconnecting your electricity connection as well as other utilities being availed in the premises so that there is no further billing for the same on and from 1st January 2024 after receiving vacant and peaceful possession and execution of the surrender deed. We would refund your residual security deposit after adjusting your dues till 31st of December, including the balance, if any, towards utility deposits by the concerned service provider. Subject to the execution of the surrender deed, within the month of January, we would refund the balance security deposit. Else, we would take that you continue to be in possession and bound by all the covenants of the registered lease deed, and we being at liberty to take action for recovering of our payments and not take any further legal action as required to protect the interest. So kindly see first what they are saying, they have disconnected the electricity to get rid of my possession so that I am not in a position to carry on my business. They have disconnected the electricity first. They being aware that I'm in possession. Next, they say that without surrender deed, possession cannot be taken and security deposit will only be refunded once surrender deed is executed. As the defendant number 3 come forward, Your Lordship, Mr. Dotto was appearing. He has not made any submission that he has got back the security deposit or any surrender deed has been executed. The plaintiff has not produced any surrender deed. Now, the next page 117, this is the premise on which the suit has been filed. This is the main crux of their argument, page 117, 15 January 2025. You have been unable to clear all furnitures and installation from the subject premises in terms of your letter of 20 December. However, in order to stop further losses, we would like to surrender the possession of the premises on as is varies basis. So he's surrendering the premises on as is varies basis. So whoever is in possession, he's surrendering the property like that only. We would further not make any claim and or insist on handing over any of such remaining installation from you, which would be free to deal within any manner you so desire. We would request you to please accept the possession and absolve us from any further payment of rent and other charges. We would comply with all the requirements of your letter. We request you to confirm the above and accept the premises. This is thereafter the subsequent letter, page 118. The plaintiff says that yes, we have hereby confirm and accept possession of the subject premises on as is varies basis. So kindly see the apparent collusion. First, it is being said at the letter section that surrender deed will be executed, security deposit will be given back. There is no surrender deed executed, no security deposit being given back, though 33 lakhs has been paid as a security deposit. That is what I find from the lease deed. Now, one day, suddenly, the defendant number 3 gives a letter that we are not in a position to carry on any business. We are surrendering on as is varies basis, and the plaintiff takes the possession on as is varies basis. Yes. In spite of the fact that they have received a sum of rupees 24 lakhs and I was already in possession on and from September 2024. Till date, I'm in possession. Till date, I'm in possession. Okay. Now, Your Lordship will see on these facts and circumstances whether any addendum mandatory injunction can be granted or not. Now, Lordship sees the principles of addendum mandatory injunction is that the plaintiff has to meet the case more than a prima facie case. The situation is much more grievous. Now, Lordship, today, first they have to establish that the plaintiff was in possession, and that is an uncontested status as on the date of filing of the suit. Correct. Have they shown, apart from mere pleadings, Your Lordship knows that even for a prima facie case, when Your Lordship passes any order on the basis of prima facie case, Your Lordship has to hold that these are the materials on record, evidence on record to substantiate the prima facie case on the basis of which an ad interim injunction is being granted. Now, what are the materials on record apart from mere pleadings? Only pleadings. There is no documentary evidence showing that as on 16 January 2025, plaintiff was in possession, or as on before the date of filing of the suit, plaintiff was in possession. The plaintiff could have produced photographic evidence saying that yes, they are opening the padlock with the personnel of the lessee, Seokjin handing over the keys. They could have produced photographs before Your Lordship that they are in possession of the property. They have taken photographs of the inside of the property. Nothing has been produced. Only a letter. Your Lordship knows possession are of three types: actual, constructive, symbolic. Now, today, the plaintiff might be, at best, if I take their arguments assumed to be true and correct, plaintiff might be at best in constructive possession on the basis of a letter. But is the plaintiff his actual physical possession? Mere pleadings will not do. He has to show evidence, materials on record.
Okay.
Those are not there. Now, Lordship, I will cite 3-4 judgments on the ground when ad interim mandatory injunction can be granted, that the status with regard to the possession of the plaintiff has to be uncontested as on the date of filing of the suit. Now, here the status of the plaintiff is not uncontested. I am disputing his possession. He is disputing the fact that I am in possession. So whether the plaintiff is in possession, your Lordship has to come to a prima facie finding before granting an order of ad interim injunction on the basis of materials record placed. Your Lordship will take the first judgment.
Just a minute before Mr. Sen, as you are disputing this agreement.
This is not with us. We are not a
No,
party
not
to this.
with us, but with regard to the transaction made between you and the defendant number 1
But
and 2.
in our plaint and in our application, we have made a specific pleading that they are the financiers. They are receiving, they have made financial accommodation in favor of defendant number 3. Monies have been lent in advance to them. Number payments on account of rent and payment on account of electricity that we have received from the defendant number 3 can be from any source of its loans. One of the persons from whom he has taken loan is the defendant number 1 and 2. Now, in our accounts, I immediately, the moment these were placed, I asked the client to get their accounts. In the accounts, we have given credit to the defendant number 3 for these payments. I'll just hand over to your Lordship and Lordship will find out. Today, my lord, my son is staying as a paying guest accommodation in Delhi to study law in Delhi. He is staying there. Who is making payment of his rent? I am making payment of his rent. I am not the tenant. My son is the tenant. Today, I am making payment of my son's life insurance policies. I am not the person assured. He is the person assured. Payments can be made by third parties on account of somebody else. Question is in discharge of whose debt? It's in discharge of the debt of the defendant number 3. And that we have said so. Lord, please see this. Lord, if I may just indicate to your Lordship. The Lordship, please comes to the second page. Your Lordship will please see this is the ledger account of Citation Hospitality Private Limited in our accounts. Defendant number 3. Lord, these are the payments that we have received till a particular date, which immediately in 2 minutes they could get. Please come to the second page, the last entry. Your Lordship will find 12,44,526.
Yes.
This is the amount which my learned friend showed your Lordship from HDFC Bank.
Correct.
Exact amount.
Correct.
Now, Lord, please turn the page over. Lord, please come to 10th December 2024.
Yes.
4,71,000.
Yes.
Your Lordship will find this is the entry of 11th of December, my learned friend has shown.
Correct.
Lord, the third entry, my Lord, my instructions are, because it is the ledger account of Citation Hospitality, the third entry, my instructions orally, is that was on account of electricity. Lord, now these payments are being made to us by the defendant number 3 in discharge of their liability to pay rent and electricity. From whom the defendant number 3 gets the money is inconsequential to us. They are the financiers. Naturally, the money will be from them. Who is writing the check is inconsequential. We are receiving the money in discharge of the debt of defendant number 3.
Yes.
It is an admitted position that they are financiers. Naturally, they are making payment.
Yes.
I'm not, so far as this agreement is concerned, if your Lordship will come to page 5, the first 4 pages are recitals. Though that gives the background. Lord, please ignore that. Page 5, clause 1, 2 things. In clause 1, that second party, which is Mr. Doctor's client, has agreed to transfer the absolute right, title and interest of the company. How? In terms of clause 2, the transfer of shareholding and the transfer of directorship. No answer from my learned friend whether this has been done, whether the shares of the company have been transferred, whether the directorships have been transferred. This is condition precedent to this memorandum coming into effect.
Yes.
And this was what was represented at that meeting, which I faithfully reproduced in my plaint and I've submitted on the previous day. That
Yes.
this was the understanding, it was not worked out. We took out documents from the master data to show that nothing has been done.
Yes.
Lordship, to
And
this,
in fact, we have the master data right up to date, which shows that there has been no transfer. Secondly, my lord, again, if your lordship goes back to
I
page
think
5,
we should give
if your lordship
Let-
goes
let-
back
let-
to page
let-
5,
let me-
clause 1,
Because
1
why I asked the question, if with regard to this agreement, then your first maintainability question has to be decided first with regard to this.
Yes, yes.
That is the only thing.
But
Let me
this-
see whether this agreement is to be considered as the contract between the plaintiff and you. That is, if
no,
it
it's
is,
not a contract between plaintiff and
so if it is not, then how?
How does it bind me?
I am
And
not saying it is
And
binding.
in any
I am
event,
saying
this
that
has
they
not
are.
been given effect to
Okay,
today.
I am
Not a single document has been shown as yet to your lordship to show that possession has been handed over by defend number 3 to defend numbers 1 and 2.
Okay.
How does
I
it
will-
look at they are
And
in
there is a
possession?
specific
Let-
restrictive covenant in the lease deed that it cannot be sublet.
Let me complete.
How does his argument show that he is in possession of the property as of the date of filing of the suit, apart from one letter on record? And your lordship, I have never said that this agreement is between me and the plaintiff. I have never said that.
Correct.
I am saying that this agreement is between me and the lessee. I have been put into possession by virtue of this agreement. The plaintiff is aware of this fact. That's why they have accepted. Your lordship, I have shown that letter of 21st November. They have admitted that they will enter into a fresh lease agreement with me. So I am not an outsider. I am the incoming lessee.
So whether the company's shares have been transferred with the company.
It's in the process of being transferred. Your lordship, this cannot be a ground. This is a dispute between me and the defendant number 3. Whether the shares will be transferred or not. This is in the process of being transferred. But the fact is that I have been put into possession by the defendant number 3. The plaintiff is aware of the fact the plaintiff has been accepting money.
That's what, see, you are making two submissions. You are telling that their document with regard to taking possession by way of a letter that cannot be taken into consideration by way of a letter.
At the ad interim stage, yes.
At the interim stage, because they have not shown any document. You are claiming that you are in possession of the agreement. So that is also the document.
Yes, correct.
So,
but your lordship, kindly see
so
today.
whether the court can neglect one document and court can consider one document which is not on record. Now you are submitting before this court, and
this is not on record because
this is not the, and you are admitted and the plaintiff has admitted this is not the contact between the plaintiff and the defendant number 1 and 2. It is the you and defendant number 3. With regard to the payment, let the court consider what is to be taken into
Your lordship,
consideration.
kindly see today. If your lordship ignores whatever I produced today, your lordship, at the ad interim stage, your lordship is considering, I have not filed my affidavit. So your lordship has to consider their case on the basis of pleadings made out.
Correct.
Your lordship, their pleadings and materials to substantiate that pleading. It is not only the pleading.
Okay.
Today I can come and say that he is creating third party that kindly.
That much the court knows, sir. That much the court knows. You need not to teach the court what is to be considered at the time of ad interim injunction, because you 10 times you have reported this submission. This court knows what is to be considered at the time of ad interim injunction.
Absolutely.
Correct.
Absolutely.
Please mind it.
Yes, your lordship. Your lordship is relying upon that letter. That's why I am saying that.
No, I have put the question to you. You have submitted that letter cannot be relied upon. And you are telling that your agreement is to be relied upon. If one document is not to be relied upon with regard to the possession, how your document is to be relied upon with regard to the possession? Question is that.
I have said that document is on record. I am saying that document does not prove that he is in actual physical possession. That is what my submission. Correct. That is what my submission is. And it is not the fact that I am a total outside stranger. In their own letter, they have said that they will execute.
I take a note, sir. I take a note of it.
Your lordship, with regard to the principles of mandatory ad interim stage, when it can be granted, your lordship will first take the judgment of 1990 volume 2 SCC 117. Your lordship will see paragraph 15 onwards. In one of the earliest cases, in Rasul, your lordship has got it. Para 15 onwards. In one, para 15 onwards. In one of the earliest cases in Rasul Karim versus Piru Bhai, Amir Bhai, Justice Beeman was of the view that courts in India have no power to issue a temporary injunction in mandatory form, but Justice Shah, who constituted a bench in that case, did not agree with Justice Beeman in this view. However, in a later division bench judgment in Chamsi Bhimji and Co. versus Jamna Flour Mills, two judges bench of the Bombay High Court took a different view from Justice Beeman, and this view is now of the prevailing view in the Bombay High Court. In M. Kondasamy Chetty versus P. Subramaniam Chetty, a division bench of Madras High Court held that courts in India have the power by virtue of Order 13 and Rule 2 of the CPC to issue temporary injunctions in a mandatory form, and differ from Justice Beeman's view, accepting the view in Chamsi Bhimji and Co. It was held that the High Court was competent to issue an interim mandatory injunction in mandatory form. It was held that in this case, that in granting an interim injunction, what the court has to determine was whether there was a fair and substantial question to be decided as to what rights of the parties were, and whether the nature and difficulty of the questions was such that it was proper that injunction should be granted until the time for deciding the same should arrive. It was further held that a court should consider as to whether the balance of convenience lies and whether it is desirable that status quo should be maintained. While accepting that it is not possible to say that in no circumstances will the courts in India have jurisdiction to issue an ad interim injunction of division bench, was of the view an interim injunction of a mandatory character. In Nandan Pictures versus Art Pictures, a division bench was of the view that if mandatory injunction is granted at all on interlocutory application, it is granted only to restore the status quo and not granted to establish a new state of things differing from the state which existed at the date when the suit was instituted. So, Lordship will kindly, I pause here for a moment. My case is that the plaintiff could not prove that he was in actual physical possession. I am saying that I am in possession. Now, this issue has to be decided on materials. Now, today, if your Lordship grants an interim injunction granting them access without giving any proof, giving any proof that they were in possession, this will create a fresh right in their favor by having access to the property. And if that access is granted, then I am dispossessed. This amounts to my eviction. So, new right cannot be established. 16. The relief of interlocutory mandatory injunctions are thus granted generally to preserve or restore the status quo of the last uncontested, non-contested status which preceded the pending controversy until the final hearing, when full relief may be granted, and or to compel the undoing of those acts that have been illegally done, or the restoration of that which was wrongfully taken from the party complaining it. But since the granting of such an injunction to a party who fails or would fail to establish his right at a trial may cause great injustice or irreparable harm to the party against whom it was granted, or alternatively not granting of it to a party who succeeds or would succeed may equally cause a great injustice or irreparable harm, the court has evolved certain guidelines. Generally, the plaintiff has a strong case for trial that it shall be of higher standard than a prima facie case that is normally required for prohibitory injunction, more than prima facie case. It is necessary to prevent irreparable or serious injury which normally cannot be compensated, the balance of convenience. 17. Being essentially an equitable relief, the grant or refusal of interlocutory mandatory injunction shall untimely rest in the sound judicial discretion of the court to be exercised in the light of the facts and circumstances. Though the above guidelines are neither exclusive nor complete or absolute, there may be exceptional circumstances needing action. Applying them as prerequisite for the grant or refusal of injunction would be such of excessive judicial discretion. So there has to be exceptional circumstances.
Is there any document that you have run the business?
You
have run the business over the premise?
Your Lordship, we have got the documents with regard to the Zomato billing from our restaurant as just 2-3 weeks before the suit was filed. The restaurant was being run. There is a Zomato billing. Your Lordship knows that through Zomato they come and take
Zomato billing in the name of whom?
In the name of the restaurant. Seoul
Restaurant
Story.
Name Seoul Story.
Yes.
Story, that is with
Seoul
regard
Story
to
was.
You have any document that you are running the business? Seoul Story is the defendant number 3.
That is an admitted position that the Seoul Story, that the defendant number 3 has handed over the restaurant to me.
Okay, see.
That is an
you
admitted.
paid the amount, you go for the recovery and against the defendant number 3.
No, it's not. Your Lordship, is not that. Your Lordship, the fact is that I cannot have the billing in my name because the billing has to be in the name of the restaurant.
Correct. So this is in the name of the Seoul Story. Seoul Story.
The Seoul
agreement
Story
is with the, as per the prima facie with the plaintiff and the defendant.
Plaintiff is not running the restaurant.
Plaintiff and the defendant surrendered that.
Defendant number 3 was running the restaurant. Defendant number 3 has allegedly surrendered the restaurant on 16th of January. I am saying that before that there is a billing in the name of the restaurant which was being run by me. That is an admitted position. From August they could not pay the rent.
Okay.
I came into the picture.
Okay. Next.
Now she sees in ad interim stage the onus is on the plaintiff to prove that he was in possession. Just on the basis of a mere letter that does not prove that he is in actual physical possession. The next, your lordship, which I will rely upon is 2004-7,
How much time it will take?
Lordship, I have 4 or 5 judgments to place.
That is the problem here. Giving an opportunity, then never the injunction application will be heard before a month. First time I am surprising in the interim application, month together hearing is going on. In the interim application, what the judgments you want to cite?
Lordship, this is on the point that if any interim mandatory injunction is given, which amounts to final relief in the suit, that should not be granted. It's a 3-bench judgment. Lordship, the similar relief.
Okay, I am passing an order, status quo, you argue the matter. No problem.
Yes, your lordship, I will argue the matter.
Status quo means that he will continue to disturb and not allow me to run the business. Lord.
Not restraining him.
Yes.
Restraining him, your lordship, from running the restaurant.
Yes. Not
From
restaurant, restraining him to interfere with the position. That's all.
No, I am in
This
possession.
court is not going to pass any order with regard to who is running the restaurant. The only restraining.
No, that is not the issue.
Restraining any of the parties for interfering in the possession of the plaintiff or the suit premise.
That means your lordship is granted ad interim injunction.
Whatever it may be. What can be done? For the last 3 days of the court is hearing, but you are not going to complete 1 hour. You have argued the matter. You have not completed the argument.
Has taken more than half
No,
an
he has argued only 1 day.
Yes, 1 day.
One session.
Less than an hour because preliminary point went on for such a long time.
The lordship is not willing to hear me, then you.
What can be done? How if the interim order will continue, how the court will proceed further?
I am only on the point that they could not prove their interim case because they have.
You with regard to the on facts you already argued, and again you are citing the judgment 10 and 15 judgments you are citing. How the court will give the judgment on that? If the interim stage you wanted to rely upon the 15 judgments or 10 judgments, how the court will pass an order of the interim order?
I only relied upon 1 judgment.
Give the judgment, I will pass an order.
Then your lordship, I will not make any submission. Lordship is not willing to hear, I will not.
No, this court is not telling not willing to hear. This court is telling that if at the interim stage, if the party intending to rely upon several judgments, how the court can pass an interim order?
Lordship,
the court has to go into all the judgments, is to read all the judgments.
He has made out he's trying to make out an interim case. I am saying that on what grounds it cannot be granted. So that's why I'm relying upon judgment. If your lordship will fix it tomorrow, I will take half an hour and finish.
No question of tomorrow. Again,
no.
Day.
Problem is the fixing.
I am not.
Problem is the fixing of this court by the time, because this court is running short of time.
Lordship, today it was fixed at 11:30. So
you have wasted 15 minutes.
Lordship, I got stuck before.
So you know on 5th March this court has fixed at 11:30. You could have been make arrangement either that court or this court. This court cannot restrain you not to appear, but you could have been managed with the court has fixed the matter. You have wasted about 15-20 minutes.
The fault on
your
my
junior
part,
friend
that
call you, then she has argued some matter. 20 minutes you lost that. If the 20 minutes you utilize, the matter could have been
apologize
completed.
to your lordship for getting stuck before a division bench. I'm sorry for that, your lordship. But
please mind, if your matter speaks, please appear before this court, or to make necessary arrangement, you are not able to appear before this court.
I'm very sorry that I could not appear. I tender my.
Court is getting the time because all the advocates are not getting the opportunity of the time. If the court is fixing the time, please make the convenient to this court, the matter can be heard.
It was not within my control, even though I apologize for that, your lordship. It was not within my
suffering for the plaintiff, suffering for the defendant, counsel for the defendant number 2 and 3, 1 and 2 has argued the matter at length, but he submit that he has to cite some other judgments accordingly. Hey, कल कुछ है? कितना बजे? हाँ? 11-12 नहीं है? 12 को? That is the problem.
I'm very sorry, your lordship. It was not within my control, but I still apologize.
11:30. 13th October, 13th February, March at 11:30. it is made clear that no further adjournment shall be granted on that day.
Time. 11. Lordship will kindly don't take me amazed. I was just
No,
trying
not
to.
amazed, because if the matter is fixed and this court is fixing the matter with the consent of both the parties,
Yes.
then if you know that the matter is fixed and that to the interim order,
My lord, item number 63, my lord, there's a talk of settlement of the parties, my lord, is going on between the
For
parties.
the other side.
My lord,
item number
63.
63 of
Approach has
commercial
been-
matter.
Yes.
Approach has been come from their end.
Yes.
We are talking, if Mala settle.
No,
then
not from our end, but
Very well.
both
If we
both
settle-
parties sat, my lord, is
My lord.
a-
Mala, if we settle, come with a term of settlement.
yes.
Come, let it be in the list. Let it be in the list. It is
My
not going to
Kindly
take.
adjourn it for the time.
Adjourn it for
For the time being. Otherwise, in accordance with
least-
law.
Which one? Rani Santi? Rani
No,
Santi?
63, my lord.
Of the
Chitra-
commercial matter?
In the goods of Chitra.
Commercial matter?
No, not commercial.
TS 2 number, TS 2
Testament,
number 25.
Testamentary.
my lord.
Testamentary number 2 of 25. 63, দেখুন।
Yes.
Chitra Biswas.
Chitra Bish.
In the goods of Chitra Vishwa, my lord.
Well,
I am for the propounder, my lord.
So and so appearing for the plaintiff. So and so appearing for the defendant. It is informed to this court that the matter and the parties are going to settle the dispute and accordingly press for adjournment. In view of the submission made by the counsel for the parties, the case is adjourned. How much time?
8 weeks or 10 weeks?
My lord, 6 weeks time.
Adjourn for
8
8 weeks. Adjourn for 8 weeks. Let the matter appear on March. April. Let the matter appear on 15th May.
My lord. Under the same heading, my lord. My lord.
ये क्या है यार, ये क्या कौन है? बुलाओ उनको, कोर्ट मैनेजमेंट को बुलाओ.
Thank you, thank you.
Yeah.
My lord, I'm the petitioner in person, my lord.
Yes.
I would like to pray for a citation, special citation to be issued, my lord, and also a general citation.
Item number 28.
32, my lord.
32. Yes. You are for the
I'm the petitioner in person. I'm the executor of the will, my lord.
executor.
Yes, ma'am. Yes.
You are appearing in person.
Yes, my lord.
So many legal layers.
There's one legal error,
Where it is?
my sister. So she had given a consent in the form of several letters and against each asset, but she's not coming forward to do the affidavit right now.
Consent.
Yes.
So we
So I would
want to-
just request a citation.
So and so appearing for the the petitioner. What's the good name, sir?
I'm Mukul Vijay Singh, sir.
Petitioner, Mr.
My lord.
Mukul Vijay Singh. Appeared in person. He submit that he is the sole executor of the last will and testament of the deceased Rohini V. Surya, Suraiya. Counsel for the petition submitted. The deceased died on 18th October 2010, leaving behind the petitioner and a daughter as is left behind, the petitioner being the son and daughter Bhavna Bilani. Counsel for the petition submitted. The daughter has this sister slash daughter of the testatrix has not come forward to give consent or to file affidavit or affidavit in support of filed caveat or affidavit in support of caveat. Accordingly, he prays for issuance of general and special citation. General and special both.
Yes, my lord.
General and special citation. Consider the submission made by the counsel for the plaintiff. Considering the submission made by the petitioner in person, prayer B and C is allowed.
My lord, I would like to just give you some letters that she has given in consent earlier.
On the next.
Okay. Thank you, my lord.
Next.
Grateful, my lord.
My lord,
Your
this is
me here.
this is my probate application.
Yes.
In this matter, executor died. I have to come with a appropriate application for the letters of administration, madam. I need 3 weeks time to.
Executor died.
Yes, my lord. There were 2 executors. Firstly, one of the executor, he died. Now the nephew also died.
Both executors died. So and so appearing for the petitioner. Counsel for the petition submitted. In the will, there are 2 executors, and both the executors are passed away, and as such the petition prays for time for taking appropriate steps. In view of the submission made by the counsel for the petitioner, the case is adjourned for 4 weeks. Let the matter appear on 17th April.
It has come at my instance, my lord. The whole executor died, madam. I have taken out an application in GA number 1 of 2025 that was disposed of by your lordship by order dated 16th of January 2025. Madam, difficulty is due to the amendment. The department has further pointed out certain clarification, and my lord, and time to carry out the amendment is also over because of the or since the amendment was not carried out in proper form. I am seeking the lordship's leave to file the supplementary affidavit by a amendment that idea and are prescribed by the department. And I am for extension of time to carry out this amendment.
So now what is the problem?
But problem is this: the original executor died. There is sons and daughters and wife are there. One of the son is before your lordship represented on by way of a power of attorney. Other they have given consent, and the recording of death was also there in GA number 1 also, and that lordship was allowed that. Difficulty is this: in some the amendment portion we have already earlier we have incorporated. In some portion, the letters of administration portion has to be incorporated to the grant of probate is there. And my lord, the manner of writing this, they have suggested that has not been done in the manner suggested by the department. By this supplementary affidavit, my lord, has incorporated annex the amendment, suggested amendment given by the department. The name of the Rajastham original, according to them, original first title will be remain unchanged. But it is my fault, my lord, that has been changed by me in GA number 1 in annexure C as the proposed amendment sought for by me. Number 1 has been disclosed of by the that annexure C was there. In the annexure C, lordship will find.
Yes, what do you want?
I am just praying for people lordship by the supplementary affidavit. Lordship will allow the supplementary affidavit. And what I have prayed for for an amendment being annexure C to the supplementary.
Sir, you have to file an application. By way of supplementary, it will not do. Once you have filed an amendment application, that court has allowed. But at the time of carrying out, it was found that the amendment the proposed amendment which you wanted to carry out, that is not in accordance with law. Correct?
No, according with law, according to some typographical error is.
That's why you all persons, the senior members of the bar, you are going with the word of the master and the department. The court cannot say anything. That's why I'm telling all the advocates are going with the words of the department, leaving aside keeping the law by the side. I don't know what is the reason on that.
We are helpless.
So helpless. If so, you are the advocate. You have to apply your mind. If any correction has been made, if the correction is required, what step you have to take? They are not the lawyer. If you find yes that the proposed amendment was not correct, so the correct amendment is to be brought on record by way of what? Supplementary affidavit or by way of an amendment application further. Because that application has been disposed of. How the supplementary affidavit the court can allow you to file a further amendment? Unheard of. You come with the take this, stating what you stated, state the fact, and come with an application for modification, for accepting the instead of accepting the earlier proposed amendment, accept this proposed amendment. That's all. Supplementary, where is in the supplementary affidavit?
Paragraph 3.
In the supplementary affidavit, you can make a prayer. Tell me.
Although I cannot. But
You cannot. If the supplementary affidavit you cannot make the prayer, how the court can allow? Yes, so and so applying for the petitioner. The counsel for the petitioner submit that after the order passed by this court dated 16 January 2025, wherein this court has disposed of GA1 of 2025. Subsequently, the department has found that the proposed amendment made by the petitioner is not correct, and the proposed amendment has to be appropriately correct, is required to be corrected. Accordingly, counsel for the petitioner prays for time for taking appropriate steps. In view of the submission made by the counsel for the petitioner, the case is adjourned. How much time? 1 week?
Yes.
Let the matter appear on 25th of March.
Wait, please, Your Lordship.
Yes.
This is my application for grant of probate.
For probate?
The deceased died and she gave everything by virtue of a registered will to her own husband.
What is the name of the deceased? Vatsala Roy.
Vatsala Roy. She is a South Indian, and Your Lordship will be knowing this. Trivedi and Roy is a very famous pathologist in Calcutta.
Yes.
So everything has been left to Dr. Subhendu Roy. Consent affidavits.
But again, you will face problem. In the will, Vatsala Roy. In the death certificate, Dr. Vatsala Roy.
No.
Kindly come. Page 10, Annexure A.
I'm just taking it out. Kindly see the page 10, my lord. Name Dr. Vatsala Roy. She's passed away.
Petition.
Yeah. She's the one who is deceased.
But it is here only Vatsala Roy.
I beg your pardon?
And you see, in the PLA, only Vatsala Roy. And the will also Vatsala Roy, but in the death certificate, doctor is added.
No, doctor has not died. What has been said is Dr. Vatsala Roy is gone. She's also a doctor, husband is also a doctor.
But in the will, that's the time. Again, future you will face problem from the department. Kindly come to the page.
Kindly come to Annexure B, page 11.
Yes.
I hereby appoint my husband, Dr. Subhendu Roy.
No, not that. First, this is the last will and testament of
Vatsala Roy.
Doctor is not there. And
that's why
kindly come to the first page of your petition, first title. First page of the petition, first title. You have to mention either alias or whatever, how the probate will be granted.
Lordship in an inherent power can do this. Man is very sick. The doctor himself is very sick. I should be very grateful for the kind indulgence. Otherwise, there is no difficulty at all. The sister, the brother.
No, that's correct.
Everyone has filed consent affidavits, one from Canada, one from Norway, one from son from USA. Those affidavits are on record.
And citation was issued that
Uh,
report is
so
also
and so appearing for the petitioner. Counsel for the petitioner submitted that the testatrix, the actual name of the testatrix is Dr. Vatsala, Vatsala, Vatsala Roy. But the will was executed by the testatrix in the name of Vatsala Roy.
My lord.
At the time of filing of the present application, the petitioner has filed the case by referring the name of the deceased as Vatsala Roy. Accordingly, the counsel for the petitioner prays for leave to correct the cause title by adding alias Dr. Vatsala Roy in the cause title of the petition.
Can I do that before your officer, my lord?
Police. The petitioner is the learned advocate on record of the petitioner is granted leave to correct the same in course of the day and let the matter appear tomorrow by putting his initial in the correction portion and put the matter tomorrow.
Deeply, lord. I'm sorry for this.
Lordship, this matter is appearing upon mentioning last week, Lordship.
Yes.
On 28 January, Lordship was pleased to pass an order for publication of general citation in 2 newspapers. However, the newspaper Sanmarg, your Lordship would recall, does not have circulation in Bombay, and accordingly, upon mentioning again, the order was amended on the 6th of February.
So what has happened now?
So when we approached the department for compliance of this order, because they were directed to supply the approved format of the notice which is to be published in the newspapers, they said that the time period has expired 2 weeks. So accordingly, Lordship, if the time period can be extended by a couple of...
So appearing for the petitioner. Counsel for the petitioner submits that by an order dated 28th January 2025, this court has allowed the petitioner to publish the notice of the probate application with respect of the property in English and Hindi newspapers at Mumbai. No name is given in Mumbai.
Lordship,
the Times of India and Sanmark. Full stop. By an order dated 6th February 2025, this court has modified the order dated 28th of January 2025 by allowing the petitioner to publish the notice of this application in Bombay in Hindi instead of Sanmark. It should be published in the Navbharat Times and Lokmat. 2.
Just one, Lordship.
Hindi newspaper, namely Navbharat Times and Lokmat. Full stop. Counsel for the petitioner submits that as the time has expired, accordingly the department is not furnishing the format to publish the notice in the said in the newspaper. Accordingly, time to publish the notice of this case in the Navbharat Times and Lokmat is extended for a further period of...
Lordship, also in Times of India, Lordship.
Times of India already published, I think. So
no, Lordship, not published.
Time to publish the notice in the newspaper Navbharat Times and Lokmat, as well as in English newspaper Times of India within
2 weeks, Lordship.
Within 3 weeks from date. Published Mumbai. Navbharat. If your AC work is going to put up
In this matter, my lord, I'm appearing for the executor, my lord, this executrix, my lord, Gurdev Kaur, my lord. She died on 27, she made a will on 27 November 2015.
Name of the testatrix is Gurdev Kaur Dillon.
Yes, alias Gurdev Kaur Dillon, my lord. I'm coming to the will, and she died on 11 November 2023. Now, your lordship will come to page number 20, in which will is there.
What is the death certificate?
Yes, my lord, there's after the will, my lord. She died in USA. At
11,
page
11,
13, my
20,
lord.
11, 11, 23.
Yes, my lord.
Okay, where is the name of that executor in the
My lord
will?
will come to the will, my lord, page 10. The para 4 is important. It will show the deceased husband has expired. She is having only 2 legal heirs, one son and one married daughter.
Residing in America.
And next page, your name of the executor is appearing, my lord,
I
para
appoint
5.
Surinder Singh, son of Sardar
Yes,
Amar
my
Singh,
lord.
religion Sikh,
Yes, my lord.
occupation. So, yes.
And my lord, I have to tell your before lordship something. And the will has been signed in Punjabi language. So that was read over and explained by in Punjabi by Kuldeep Singh, who is also he has filed 2 affidavits. One affidavit that as a attesting witness he has affirmed the affidavit. Another is an affidavit explaining that he has explained the deponent the contents of the will in Punjabi language.
Where is the legal heirs?
My lord, the legal heirs is at page, my lord. They have given all consent. I'm to tell you, lordship, it is at page 4, my lord. 2 legal heirs, one son.
One son, one daughter.
Yes, my lord. That is the name. Same names are appearing in the will.
Both have given.
Both are given consent.
Kuldeep Singh. Jagjit Kaur. Yes. So applying for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 27th November 2015 of the testatrix Gurdev Kaur Dillon alias Gurdev Kaur. Counsel for the petition submitted. The testatrix has executed her last will and testament while possessing good health and fit state of mind in presence of 2 attesting witnesses by appointing the petitioner as sole executor of last will and testament. He submits that the testatrix died on 11th November 2023, leaving behind 2 legal heirs, that is one son, namely Kam Singh Dhillon alias Kam Dhillon alias Karamjit Singh Dhillon, and one daughter, Mrs. Jagjit Kaur Lehal, Lehal, Lehal. Counsel for the petition submitted. Both the legal heirs have filed their affidavit of consent, stating that they have no objection for grant of probate of the last will and testament to the petitioner. Counsel for the petitioner submit that the testatrix has signed her last will and testament in Punjabi language, and the same was duly read over and explained by one of the attesting witness, Mr. Kuldeep Singh. Mr. Kuldeep Singh, being one of the attesting witnesses, has filed 2 affidavits. In one affidavit, he has stated that he has read over and explained the contents of the will to the testatrix in Punjabi language. And another affidavit, he has stated that the testatrix has executed her last will and testament in his presence and in presence of another attesting witness, while possessing good health and fit state of mind, by appointing the petitioner as sole executor of the last will and testament. Consider the submission made by the counsel for the petitioner. peruse the original will, comma, death certificate of the testatrix, comma, affidavit of consent of both the legal heirs, and affidavits of the attesting witness, namely Kuldeep Singh. This could find that both the legal heirs have filed their affidavit stating that they have no objection for grant of probate of the last will and testament. The attesting witness has categorically stated in his affidavits that the testatrix has executed her last will and testament in his presence and in presence of another attesting witness while possessing good health and fit state of mind by appointing the petitioner as sole executor. He has also stated that the testatrix has executed her last will and testament in Punjabi language, and the same was read over and explained by the petitioner, by the attesting witness in Punjabi language. Considering the submission made by them, considering the above document, this court finds that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate of the last will and testament dated 27th of November 2015 to the petitioner on compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate.
And may not let the order may not
The
be drawn.
department is directed not to draw and complete the order.
Deeply.
PLA number 189 of 2024 is disposed of.
But I appear on behalf of the petitioner, my lord. My lord, this is a will dated 17 June 2018, my lord. My lord, it's in the page 18 of the petition.
17 June?
17 June 2018.
Yes.
My lord, and date of death of the testator, which is my father, is 10 July 2020. My lord, I have been appointed a joint...
Where is the death certificate?
My lord, page 17, my lord, and it should be.
10th July 2020. What is the date of the will, sir?
My lord, will is 17 June 2018.
2018. And when the application was filed? 24, after 4 years.
My lord.
Okay. Where is the name of the executor in the will?
My lord, page... My lord, page 21, my lord. At page 21.
Who has put the number in the original will?
My lord, the will was like that only, my lord.
How it can be?
My lord, the running pages, that was already there in the will by which it has been filed. I have put, my lord, the petition's page numbers are
Can't
different.
be, because
My lord, the will starts.
Your petition ends 17 after the death certificate.
Yes, my lord.
Death certificate. Then 18 to
18 to, my lord, 22.
18 to
23.
22. How it has
23.
been numbered?
My lord, it was already there in the will. It was not. This has not been numbered.
Can't be. How it can be numbered? Because will is having the type number 1, 2, 3, 4. Type number. Yes, where is the name of the executor?
My lord, page 22, my lord. 21.
I appoint Sajal Mukherjee.
And I am the joint executor alongside
Dr.
with my...
Sonali Chatterjee as joint executor and executrix. And who has filed this petition?
My lord, the son, my lord, Shojal Mukherjee, my lord. My lord.
What about the other?
But there are two heirs, my lord, my mother and my sister.
Now, what about the other executor?
My lord, she has given us given an affidavit of consent, my lord.
Filed?
My lord, no, my lord, she has... Both the heirs have given, my lord, affidavit of consent.
Mother, son, daughter. Wife, son, daughter. What is this?
At page 8,
You are
my lord.
filing a वकालतनामा. ये वकालतनामा क्यों ले रहा है? Affidavit of consent of
My lord,
Manjula.
Sonali Chatterjee and Manjula Mukherjee. Manjula Mukherjee is my mother and Sonali Chatterjee is my sister.
And what about the Sajal is you?
Sajal is me.
So why you are filing here? Why you not filed earlier?
My lord, because, my lord, at the inception, my lord, they were not interested to give any affidavit of consent. But as time went by, my lord, they showed their interest, so that affidavit of consent has been given. But because my prayers, my lord, if you see, my lord, if kindly sees, my lord, it was initially for ABs for general citation and special citation.
What about the attesting witness?
My lord, the attesting witness has given, there is a affidavit, my lord, Saurav Mukherjee. On page 22, my lord, his name appears. He has given a affidavit.
So suffering for the petition. The petitioner has filed the present application for grant of probate of the last will and testament of the testator Swapan Mukherjee, dated 17th June 2018. The testator died on 10th of July 2020, leaving behind 3 legal heirs, that is wife, son and daughter. Son is the petitioner before this court, who is the one of the executor. As per the will, the testator has appointed his son and his daughter as joint executor and executrix of his last will and testament, but only the son has filed the present application and the daughter has given her no objection for grant of probate to the petitioner. Full stop. Counsel for the petitioner submit that the testatrix submit that the testator is executed her last will, and the testator has executed his last will and testament in presence of 2 attesting witnesses while possessing good health and fit state of mind. Out of 2 attesting witnesses, 1 attesting witness also filed an affidavit stating that the testator has executed his last will and testament in his presence and in presence of another attesting witness while possessing good health and fit state of mind, by appointing the petitioner and the daughter of the testator as executor and executrix of the said will. Consider the submission made by the full list. Counsel for the petitioner submitted the wife and the daughter have given their no objection, stating that they have no objection for grant of probate. Consider the submission made by the counsel for the petitioner, peruse original will, death certificate of the testator, affidavit of consent of the wife of the testator and the daughter of the testator, and full list of affidavit of the attesting witness. The legal heirs, that is the wife and daughter of the testator, have categorically stated that they have no objection for grant of probate to the petitioner. The attesting witness in his affidavit has stated that the testator has executed his last will and testament in his presence and in presence of another attesting witness while possessing good health and fit state of mind, by appointing the petitioner and the daughter of the testator as joint executor and executrix of his last will and testament. Considering the above document, this court finds that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate to the petitioner of the last will and testament dated 17th June 2018 on compliance of all formalities. At the time of grant of probate, copy of the will be made part of the probate. PLA number 76.
The order may not be stopped.
The department is directed to not to drawn and complete the order.
I am briefed.
My lord, may I be permitted to appear online in this, my lord?
Yes.
Yes, ma'am. This is an application for letters of administration. The deceased is my aunt. My lord, I have stated in paragraph 4 that me and my brother, who are the 2 nephews, are the only legal heirs of the deceased. And the husband of the deceased, my lord, is already, my lord, had predeceased her. My lord, I have been able to ascertain that the requirements of the department was that a genealogical table be provided along with a copy of this application.
Correct.
And a paper publication be made to this effect.
Correct.
Yes. So only, my lord, these two would be my only prayers before your lordship.
So and so appearing for the petitioner. The petitioner has filed the present application for grant of letters of administration to the estate of the deceased Shamali Mukherjee. Counsel for the petitioner submit that, and counsel for the petitioner prays for leave to file the genealogical table of the heirs of the deceased Shamali Mukherjee, and also prays for leave to publish the notice of the case in the English and Bangla newspaper newspaper. Accordingly, leave is granted to the petitioner to file the genealogical table showing the legal heirs of the deceased within a period of, by way of supplementary affidavit, within a period of 2 weeks from date. Full stop. The petition is also granted due to publish the notice of the instant case in the English daily newspaper.
Any newspaper, my lord, because she was a resident of Calcutta only, one Bengali and one English.
Times of India and Bangla newspaper.
Anandabajar, my lord.
Bartaman. That petitioner is directed to take appropriate step for publication of the notice within 2 weeks from date.
Grateful, so grateful.
Yes, next.
I am appearing on behalf of the petitioner, executor, and who is also the advocate of the deceased. I am appearing for the petitioner, executor, who is also the advocate of the deceased who prepared the will, and he's the executor, so he's also the advocate of the deceased. So, may I be permitted to submit this no objection, fresh wakalatnama?
No objection from?
No objection from the erstwhile advocate.
Who are you? You have
I'm
been
the-
engaged in the matter. Okay. You file in the department. Yes.
I seek the testator died on.
Where is the will?
The will is on in the page number 13.
What is the name of the testator? Testator, testatrix.
Testator is
Tripurani
Tripurani Mollik.
Testatrix.
Testatrix.
Where is the name of the executor in the will?
On page number 16, lower end.
Inner page?
Page number 16, Lordship.
Page number 16.
Lower end, I do hereby appoint my
Page number
advocate.
16 can't file. Where is the inner page? What is the inner page of the
Inner
will?
page 3 of the will.
Paragraph. I do your appoint advocate.
Sri Karunashish Chakraborty, Advocate High Court, as my sole executor for this last will and testament.
Yes.
The testatrix has already given her share, her property to the 2 legal heirs who happen to be her sons.
In the will?
In the will.
Where is that? All movable and movable gold ornaments to my Sridhan equally 50% each to my sons Jyotirmay Mollik and Gyan Mollik.
Gyan Mollik.
So you are only the executor. They are the beneficiaries.
They are the beneficiaries, and there is a predeceased daughter also.
I know that Bedanath Devar and Devasita are friends and my deceased daughter have sold 1/4 share in the premises by making of mischief and how the will pages are changed, madam?
I've just been given it today, so I'll recheck and do the pagination properly.
Okay, then
In the there is
how many when she died?
She died on
18 January
18
2023.
January
23.
2022.
Where is the legal heirs?
The legal heirs are on page 3.
Jyotirmay.
Jyotirmay Mollik, Gyan Mollik, alias Gyanendra Mollik, Shri Boidyanath Dhar, Shri Debraj Dhar, and Debashmita Dhar. The 3, 1, 2, and 3 are the son-in-law.
So they are not given the consent.
Granddaughter.
given the
They are
consent.
not given the consent.
So what do you
I
want now?
I want to pray for issue of the citation, special citation.
Who has not come forward for giving citation? 3.
3, 1, and
3 serial.
3 serially.
All three.
All three.
Vaidyanath, Devraj, and
Devasimita.
Devasimita. So bring for the petitioner. Petitioner has filed the present application for grant of probate. Counsel for the इससे पहले करो learned counsel appearing for the petitioner prays for leave to file wakalatnama. Accordingly, leave is granted. Let the wakalatnama be filed in the department within a week from date. Counsel for the क्या बोला? The petitioner has filed the present case for grant of probate of the will, probate of the last will and testament, dated 8th October 2013. So the counsel for the petition submitted that the legal heirs, some of the legal heirs have not come forward either to give either to file affidavit consent or to file caveat or affidavit in support of caveat. Accordingly, prays for issuance of special and general citations in terms of prayer B and C of the present application. Consider the submission made by the counsel for the petitioner. Prayer B and C of the present application is yes.
Lordship, the testatrix lordship died on.
Where is the will?
Lordship will is annexed.
Gita Gupte.
Gita Gupta, death certificate is annexure A, page 12, and thereafter the will starts, my lord.
When she died, 24. What is the date of the will, sir?
Will 2020 November, 20th November 2020. 28th November 2020 is the date of the will.
Yes. Where is the name of the executor?
Executor, page 5 of the will.
Page 5 of the will. Which
I wish to-
paragraph?
In the
Narayan Kumar Khetan.
yes, I am wished to appoint Mr.
Sole
Narayan.
executor. Sole executor.
Sole executor.
Yes. When? Where is the legal heirs?
Legally, yes, my lord, she does not have any children. Lordship, her husband has predeceased her. I have also annexed the death certificate of her husband also, died at Canada. And
Where is the death certificate of the husband?
that death certificate of the husband is not after the will, not annexure C. To the will, it is annexed. He died in 2004.
I could not find the death certificate.
Lordship, just after the will.
Will. The registered will.
Registered will, my lord, the copy of an act of death certificate, annexure C, that is annexed.
Annexure C. What is the name?
Ishwar
Gupta.
Ishwar Gupta.
What is the date of death?
Date of death is 2004 on August.
Date of death?
2004 August.
1st August 2004. Yes. Then no legal heir.
No legal heir, my lord, so paper publication.
Made.
We paid for.
Paid for. So and so offering for the petitioners. The petitioner has filed the present application for grant of probate of the last will and testament dated 28th November 2020. The testatrix died on 15th April 2024, and the husband of the testatrix was the predecessor of the testatrix who died on 1st August 2004. Counsel for the petition submitted, and the testatrix died leaving behind no legal heirs, and as such he prays for issuance of citation in terms of prayer B and C. Consider the submission made by the counsel for the petitioner. Prayer B and C of the present application is allowed. Next.
I'm appearing for the executor. The will is at page number 10. The will is appearing at page number 10, my lord.
Ready matter?
Ready matter.
Page number 10. What is the name of the testator?
Samir Ranjan Ghosh.
Samir Ranjan Ghosh. Yes.
And the name
What
of
is the date of the will?
Date of the will
2nd May 2018.
2018.
Two witnesses. Where is the name of the executor in the will, sir?
It's on page, running page 11.
Running page, inner page, inner page.
Inner page 2 of the will.
I appoint the General Secretary Ramakrishna Mission. Can it be? General Secretary name is not there.
But the name changes according to the post, so he made post the executor actually.
But the problem is, have you gone through the judgment of the Supreme Court? In the name of the society and all these things, that it cannot be either in the name of the society. General Secretary Ramakrishna Mission.
Yes, present General Secretary Subirananda Swami. Swami Subirananda is a special.
It is not here.
No, no, name is not there in the.
What do you want?
I'll come back considering the judgment, my lord.
As per the prayer made by the counsel for the petition, the case is adjourned. Let the matter 1 week.
1 week.
Let the matter appear on 18th.
My lord, this is my application for grant of letters of administration as in case of intestacy. As in case of intestacy, the petitioner is the widow. The deceased died leaving behind his 2 sons and 1 daughter. The 2 sons and daughter has given their consent in favor of the petitioner being their mother. The assets of the petitioner.
Who is the petitioner?
Yes, Your Lordship.
Who is the petitioner?
Petitioner is Kamala Devi Mundra, the widow of the deceased.
Widow of the deceased. Widow and 1 son and 1 daughter.
2 sons and 1 daughter.
2 sons and 1
Manish
daughter.
Mundra, Ashish Mundra, and Rakhi Kothari.
Correct.
All of them have given their consent in favor of the mother, Your Lordship.
Where is the affidavit?
Affidavit.
Where is the date of death?
My lord, the date of death is 21st February 2003. I have stated in my paragraph 4, Your Lordship, that the petitioner had no knowledge of the assets very recently.
Okay. Then Manish Mundra.
Manish Mundra. Annexure B.
Who is the petitioner? Kamala.
Kamala Devi Mundra.
Manish Mundra.
Then is Ashish Mundra.
No objection. Then
last is Rakhi Kothari, daughter.
Ashish Mundra. Again, no objection. Rakhi Kothari.
Daughter.
No objection. Where is the affidavit of assets?
Affidavit of assets is there. The asset value is of 40 lakhs.
40 lakhs.
Yes. Shares.
So and so appearing for the petitioner. The petitioner has filed the present application for grant of letters of administration of the estate of the deceased Rajkumar Mundra, MUNDHRA, who died on
Paragraph 2, Your Lordship, of the petition.
There is a death certificate.
Annexure A.
Who died on 21st of February 2003, leaving behind the petitioner being the wife, 2 sons, namely Manish Mundra and Ashish Mundra, and 1 daughter, Rakhi Kothari. Counsel for the petitioner submitted. The testator died and the deceased died intestate. He submitted that both the sons and daughter have filed their no objection for grant of letters of administration to the estate of the deceased in favor of to the mother, that is the petitioner herein. Heard the learned counsel for the petitioner perused the no objection affidavit of consent filed by Manish Mundra, Ashish Mundra, and Rakhi Kothari. In this court find that all the legal heirs in their affidavit have categorically stated that they are no objection for grant of letters of administration to the petitioner. Consider the submission made by the counsel for the petitioner. This court finds that there is no impediment for grant of letters of administration to the petitioner. Accordingly, department is directed to issue letters of administration to the petitioner to the estate of the deceased, namely Rajkumar Mundra alias Rajkumar Mundra, upon furnishing the bond of rupees 4 lakhs with one surety. PLA number 77 will add full issue. PLA number 77 is disposed.
Lordship, one more indulgence. Let the department be directed to draw up and complete the order, Your Lordship.
Draw
up and complete the order.
The department is directed to draw and complete up the order expeditiously. Yes.
I am for the petitioners. The daughters have applied for letters of administration. A mother had died without leaving any will. Intestate succession.
Who is the petitioner?
Both the daughters, married daughters.
Srimati Sushmita Sengupta.
Smita Sengupta and Paramita Bosurai.
Pramita Basuroy.
Yes.
And who is the deceased?
Deceased
Meena.
is Meena Purkait. She
Where is
died
the-
on.
Where is the death certificate?
Yes.
Meena Purkait. Died on
Annexure
23.
B.
And husband?
Husband subsequently died. In respect of husband, I mean father, the petitioners have also applied for letters of that is item 50, my lord.
He died on 6th January.
6 January 2020.
They are the only two legal heirs.
Only two legal heirs, two married daughters.
Both married daughters. And who are this? Husband died.
Husband died on 6th.
And both
Husband
have
is
applied
Prabhas
for.
Chandra Purkait.
And both have applied for.
For both parents applied two separate letters of admission. But both the matters may be disposed. I mean,
So appearing for the petitioner. The petitioners. The petitioners have filed the present application for grant of letters of administration to the estate of the deceased Meena Purkait, who died on
14th September
14th September 2023, leaving behind her husband Prabhas Chandra Purkait and two daughters Susmita Sengupta and Paramita Basuroy, who are the petitioner before this court. Counsel for the petition submitted the husband of the deceased has also died on 16 January 2024. Counsel for the petition submitted the deceased died intestacy, and as such, the petitioners, being the legal heirs of the testator, has filed an application for grant of letters of administration to the estate of the deceased. Had the learned counsel for the petitioner perused the application, death certificate of the testatrix and the death certificate of the adjourned testatrix, this court finds that there is no impediment for grant of letters of administration to the petitioners. Accordingly, the department is directed to issue letters of administration to the petitioners. What is the total? 13 crore, 13 lakhs.
No, 13 lakh 51,000 for the mother.
Subject to furnishing of rupees 1,50,000. Furnishing bond of surety, bond of furnishing bond of with one surety. One surety. PLA number 77 disposed. दूसरा भी है उसका husband.
Item 50, my lord.
Item
50.
50. When died?
Died on 6th January 2024.
वही आएगा खाली वो होता है husband died. State of बोलना है कर देगा ना.
But for the husband, the total is 57 lakh 76,000 and odd.
57 lakhs है. So 57 lakh or 10%, 1 lakh. No, 57 lakh or 10%, no, 5 lakh. 5 lakh with 1 surety.
I'm deeply understood.
May I be permitted to mention? My lord, this application is pending inclusion in the list.
Mentioning come in the morning hour.
My lord, this lady is deceased of the husband and she's already 86 years old. So it's
Not a good time to say something. My lord, the item number 47. Everything ready. Letters of adjournment
It will
mentioning.
come tomorrow as a top, in the
will-
top. It will come tomorrow because today I reached 45, 46.
45, 46, 46.
Item number 46, my lord, I am appearing, your lordship.
Come.
I'll come tomorrow, your lordship. I'll come tomorrow. So it.
This is your lordship.
If you will not come, then it will be dismissed.
My lord, well done, my lord.
My lord, at the cost of being severely reprimanded, my lord, I'll have to seek for an adjournment today.
Huh?
My lord, at the cost of being severely reprimanded by my lord, I have to seek an adjournment today.
Hmm.
My lord, on two grounds, my lord.
Hmm.
One, my lord, this is an undefended commercial suit, my lord,
Hmm.
where, my lord, certain additional documents had come. We have to take out an application for disclosure of further documents.
Hmm.
And, my lord, and the second and the most relevant ground for this adjournment, my lord, is that the person who was supposed to come and give evidence,
Hmm.
my lord, the person who has verified and affirmed the plaint, my lord,
Hmm.
he has left the company, my lord.
Hmm. You persons could have been mentioned earlier.
My lord, we mentioned last month.
When? No.
My learned junior mentioned last Monday, my lord. I wasn't there at that point of time in the matter.
No, you pay the cost. I will adjourn. Pay the cost of 50,000.
My lord, kindly.
What the court will do now?
I
For 1 hour.
My lord, I absolutely understand, my
Sorry.
lord. That is why we had tried to mention
On that
it.
day, I already informed this court will not grant adjournment.
My lord, I do not know whether it was pointed out that the person had resigned, my lord. We have the resignation letter also.
Okay, no problem, sir. I have no problem. I will adjourn subject to payment of cost because of the time of the court. Nothing else.
I completely bow down. May I only request, my lord, to reconsider the amount of the cost on the basis of the claim in the suit.
Below
my lord.
50,000, it is very.
The claim in the suit is, my lord, 21 lakh.
Maybe what can be done? If the plaintiff is not interested to proceed when the matter was fixed.
My lord, it was fixed in January, my lord, quite some time ago. Quite some time ago.
Now we are in March.
My lord,
2 months.
may I seek it as a last resort, my lord?
No.
My lord, kindly fixes a short date within which we'll
No.
take
I will.
steps.
First of all, I will pass an order for cost. Second, it will be taken after the puja vacation. These are the two conditions. If the fixed matter you want the adjournment, I am fixing the matter after puja vacation subject to.
My lord, I tendered an unconditional apology.
Sorry, sir. This court is having so much burden.
I absolutely
This
understand, my
court
lord.
is not having the time. When the court is giving the time, you persons some the last moment are coming and taking the adjournment. Now 1 hour a court has to sit idle.
My lord, I've tried to inform the others, my lord.
No, what they will come say, they will say we are not ready because we thought that the matter will be taken at our matter will not be taken. Nothing will be happen.
My lord, my junior mentioned last Monday if that my lord could give consideration.
So appearing for the plaintiff. The matter is listed as to the matter is fixed as a specially fixed matter for witness action of the plaintiff. When the matter is called, counsel for the plaintiff prays for adjournment. This court find that the matter was taken up for hearing on 17th of January 2025 and 17th of January 2025 with the consent of the counsel for the plaintiff and as per the prayer made by the counsel for the plaintiff, the matter is fixed today for witness action. This court is already having several matters fixed, and if one fixed matter is getting adjourned, the total schedule of the court is being disturbed. Accordingly, the case is adjourned for this subject to payment of cost of 50,000 to the State Legal Service Authority within a week from date. If the plaintiff pays this said amount to the State Legal Service Authority, let the matter fixed. Give the date after vacation. 27th October at 2 p.m.
May it be after the summer vacations, my lord.
Okay, fix after summer vacation. 9th June 2025 at 2 p.m. for witness action.
Number 5 of the commercial.
Item number 5. My suit, Your Lordship,
Yes.
for infringement of copyright.
Yes.
Mr. Ghosh was presenting. If I may be permitted to continue, Mr. Ghosh is on his legs. Your Lordship, it's an injunction application for copyright infringement with respect to 2 books, Your Lordship. May I first place the injunction application, Your Lordship? Lordship would kindly take. There were 2 agreements, Your Lordship. The agreements are of 15th of June 2001 and 22nd of April 2002. Kindly takes paragraph 4 at page 4 of the injunction application.
Injunction application?
Yes, of the injunction application. Lordship is hearing the injunction application.
Yes.
The affidavits are complete. Lordship would kindly take paragraph 2 first.
Yes.
Yes, Your Lordship. Lordship, the petitioner is a renowned author and has published the book. So we are the holder of the copyright in the book. And the petitioner number 1 is the author, that is Mr. Paresh Chandra
This
Das.
already argued. Only you are in reply, na?
Your Lordship, in reply, if I may just briefly recapitulate the facts, Mr. Ghosh would just provide the reply. Just grants me 2 minutes time, Your Lordship. Thereafter, we shall be distinguishing the judgments which have been relied upon by my learned friend, and if anything else is required on the facts. Your Lordship, the petitioner, because Your Lordship, if Your Lordship recollects, this matter was heard last quite a number of days back. Yes. So the petitioner, Your Lordship, is the author. They have disputed the locus of the petitioner. So the petitioner is the author and the first owner of the copyright. That is stated in the injunction application. For 2 books, Your Lordship, the first being Applied English Grammar and Composition, Anglo-Bengali, and the second one being Beginners Applied English Grammar, Composition and Translation. Now, Your Lordship, what happened was there were 2 license agreements which were subsisting between the parties. During the COVID, the respondents, the defendants, felt that they could not proceed with the agreements. Therefore, what happened is they formed an agreement with a third party, that is Kotha O Kahini. That is also here. That is a coexistence. Lordship would kindly permit Mr. Ghosh.
Yes.
I'm grateful, my lord. I had no idea, my lord, this will be adjourned. Sorry. So, my lord, on the facts,
That's why time and again I am telling the advocates.
No, I post my juniors, my lord, or my
No, not you. If the matter is fixed, then be careful. See what is the situation. You otherwise, what will happen?
Nothing.
1 hour of the court time will be wasted.
Absolutely. Well, I apprehend. We both of us apprehended this in morning. My lord, I told him to be here. Unfortunately, I got late because I thought that's an important matter at 2 p.m. My lord, kindly, my lord, these are very important, my lord. I'll try to, my lord, not to, my lord, go to the facts. I'm in reply. Kindly look at, my lord, 3-4 dates in question. Date double. My lord, there are 2 agreements. First agreement is 15 June 2001, page 22.
Yes.
The name of the book, my lord, my junior will give us short dates, my lord. Applied English Grammar and Composition for High School. The second agreement is, my lord, 22nd April 2002, which is at page 26 of the injunction application. It's Beginners Applied English Grammar, Composition and Translation, Anglo-Bengali, page 26.
Yes.
So, my lord, these are publishing agreement. Under the Copyright Act, my lord, there can be 2 types of transfer. One is a license, one is a complete transfer, which is assignment. Now, my lord, if this is my learned friend says he has an absolute right, like an assignment, that's the argument case you can make out whether he says, whether he doesn't say. Then, my lord, it's after 1994, it is for 5 years. An assignment under section 18, Lordship will remember, it will come back to your Lordship's. Lordship gives extensive notes, can be by way of writing only. Section 18 and 19 of the Copyright Act. There is no agreement in writing after 15th of June 2006 in respect of Agreement 1. Similarly, there is no agreement in writing after 22nd April 2006. So 5 years have gone. So, Millard, if this was an assignment, Millard, it would have been writing extended by 5 years. It recognizes nothing but extension if no period is mentioned. In a case, parties can keep it as perpetuity, permanent, but these are not there, Millard. So, Millard, there are 2 types of causes. One is under the contract, and one is a contract coupled with an act. It's a contract, Mr. Thakkar says with deepest of respect to him, Millard, this is a misunderstanding of the subject. It's a contract coupled with act in question. So, Millard, 5 years gone. So, Millard, the parties continued. Naturally, good sense prevails. If, Millard, the relationship between me and Mr. Bishwarup Mukherjee and my learned friend is good, no one is saying anything. He is giving royalty. I'm collecting. It's the nature of a license which continues. That license got curtailed by a co-publishing agreement of 25th of August 2020, which is at page 30. This is very important, Millard. I am the author or his heirs are not parties to it. We are not parties. But how, Millard, we have been roped in by basis of a letter which is annexed to Millard and forms part of the co-publishing agreement. This is the admitted case of the parties, which Lordship will find at page 38. This is or 37. The author and his wife, Seema Das, are party. Now, Millard, whatever is reiterated here, I am not bound by it.
Yes.
Whatever is reiterated in page 30 to 38, 35 or 36, I am not signatory to it. Now, Millard, they come to us. The publisher is unable to publish the books. They come to us and write this, page 37. So, Millard, this consent letter, this co-publishing agreement has 2 books only in question. 2 books. Now, Millard, this consent is given on a particular terms and condition. Otherwise, there is no terms and condition of the consent. Millard, kindly take page 37. Consent letter of the author, copyright holder. This forms part of the agreement. No letter, 7 except this is forming part of the agreement. Consent letter of the author and the copyright holder. We do hereby give our consent to the new agreement between the publisher and co-publisher, Kotha o Kaini, etc., etc., on the following terms and conditions. The arrangement must be done between the publisher and co-publisher to be settled between themselves so that the copyright holder or the author heirs can get 10% of the royalty as per the original agreement. Clause number with NBCA, beginners, 2 books have been mentioned, etc., etc. I have read it in detail. I am not troubling. Kindly take 3. Clause number 3. As the author is the basic copyright holder, accepted. Mr. Millard, Thakkar not once, Millard, at least said 5 or 6 times there is no right to sue because, Millard, part entire estate is not there. That is part written. It's there in the
only request I would make is not to revisit the facts entirely.
No one was, Millard, I just said, Millard, on the first day.
If it is only to reply, Millard, I do not
That is
object.
giving the reply only to that.
The reply,
If the entire facts is
you have
revisited.
said something. My opposition, Millard, I'll
Yes,
say,
yes,
Millard,
yes.
I know my limitations, Millard. After wearing this jersey, I know how much I can speak, how much I can't speak. And he is the best person, Millard. I did not read the entirety. I
Yes,
just
yes.
showed the clause.
Continue, Mr. Ghosh.
I don't. He knows, Millard, me, Millard. I don't. Millard, page 37, Millard. As the author is the basic copyright holder and confers his wife to Seema Das as both are aged person, the author or the copyright holder, the author or heirs will have the right to take decision in the matter of publication. So, right given by them. It's signed, Millard, by Kotha Kaini and the copyright holder in respect of publication of the books after expiry of the period of the agreement. So, after the co-publishing agreement period comes to an end, the author or his wife, any of them will have the right, Millard, to, Millard, take decision in the agreement. Or it may be continued while 3 parties are satisfied. So, unless 3 parties are satisfied, there is no question of compelling me to satisfy. And both parties have signed this. This is the part of the agreement. That letter which Mr. Thakkar showed, Millard, that is not part of this agreement. Kindly make a note of it. It is not part of this agreement. If, Millard, the parties in their wisdom, if the parties in their wisdom had thought, Millard, to make that document a part of the agreement, naturally, Millard, they would have enclosed it with the part of the agreement.
Yes.
So, Millard, the author, Millard, in the reply I have given, there is no rejoinder to it, Millard. I have said, Millard, there are at least, Millard, for 20 to 30 books of the authors, Millard, with this publisher in question, or maybe less, maybe. This is not the only 2 books. So, Millard, if there are 2 documents in question, and Lordship can see, Millard, this type of 2 letters in question, one says all books, and, Millard, one letter, Millard, is specifically engrafted, Millard, to the agreement in question. Naturally, Millard, that particular letter cannot be meant to imply to all books because this is a exception carved. Okay. This was my argument then. This was my argument now.
Yes.
So this does not form part, Millard. My learned friend, Millard, thereafter, Millard, the agreement came to an end. Immediately the agreement came to an end. It was, Millard, a suit was filed in the City Civil Court. Millard, kindly take, Millard, the dates I only give. আমি শুধু এইটুকুই পড়েছি, আমি কোনো কাগজ দেখাই। Millard, notice of termination is, Millard, 18 June 2023. That's page 40.
Yes.
There is further, Millard, termination of co-publishing agreement, that is below 25th August 2023. That's page 42. The City Civil Court suit was filed because the agreement came to an end on that particular date on 25th of August 2023. So immediately the agreement came to an end, my learned friend Millard has filed a suit in the City Civil Court challenging these two letters in question. And Millard, surprisingly, that document which Mr. Thakkar has shown is not part of the City Civil Court plaint as on that date. My suit has thereafter been filed in this court. When Millard? In the month of September, Millard, of Millard, October 2023. These are Millard correct dates, Millard. My learned friend can take it from me, Millard. And when the application was moved, point taken, I take the point that look, this is not part of the City Civil Court plaint. Your entire plaint have annexed to my plaint. So where is the question of suppression? Millard, an amendment application, Lordship will take the note also, it has not been allowed till date, has been filed for taking that document on record on 16th of November 2023. Subsequent to my filing of the suit,
where it is filed in the City
Civil Court amendment application, when I take
in November.
On Millard 16th November 2023, date of filing of the amendment.
Yes.
So Millard, I said, Millard, you cannot say that I am guilty on suppression, because you are the person who is first on board, first in court, and there you have not raised this stand. So this was not material to you. What was material to you? Whom you have made a party? I have made him a party. If you have not made my second son a party, I have not made, despite he has issued a notice, because you know that he has no right in the agreement. Now, thereafter, you have filed an amendment in City Civil Court in 16 November 2023, which has still not been allowed. So, where is the question of suppression? So, the first thing, Millard, I want to point out. A, Millard, suppression is material when I move the matter ex parte. It's very material. Material suppression. If I move a matter ex parte without disclosing these minutes in question, naturally, if Lordship has been pass an order, Lordship will recall the order. Either recall the order or pass a fresh order, or Lordship may not reinstate. Lordship is hearing in the morning matter, which Mr. Thakkar is arguing, Millard. But, Millard, I have not moved it ex parte, first of all. I have annexed your entire pleading, first. Secondly. Thirdly, I am moving it on notice. Where is the question of suppression? It's not an ex parte order I have moved. It's a question of balancing the equities.
Yes.
So I am on the suppression, because suppression not entitling any. When? It should be material. Suppose if it is not material to you, can it be material to me? Why not material to you? Because you have not made it part of your plaint initially. Because you also know it is not part of the agreement in question.
Yes.
Secondly, Millard, legal point, which I argued, my learned friend has said, Mr. Thakkar, Millard, with deepest of respect to him, said, Millard, I cited a judgment of the Delhi High Court in question, division bench. Jeff Davis. Right? It's Jeff Davis case. Huh? Rajasthan Bureaus. There are two cases, that's on record. Mr. Thakkar said, Millard, it has been subsequently overruled by the Delhi High Court. It's not. It's not overruled. Rajasthan Bureaus, Millard. What is the case in question? That's Rajasthan Bureaus. If Lordship doesn't have a copy, Millard, I can give my Lord a copy, Millard. Since, Millard, I spoke last time, well, learned friend will also give me some, Millard, relaxation in the month I find, Millard, in July 2024. I ended my submission, subject to correction, my learned junior. So, otherwise, I don't do it at all. Because I heard, Millard, Lordship's what was indicating in the morning. So, I have, Millard, he has cited 11 judgment. 3 minutes is judgment. I try to, Millard, wind up. Well, I cited Rajasthan Bureaus. This is the judgment, Millard. This I cited 2000 volume 55 DRJ division bench. দিয়েছি তোর কত কপি আমার কাছে আর কপি নেই গো আমি কত কপি দেব বলো office copy 55 DRJ division. This Mr. Thakkar, I am giving my lord. Yes, DRJ page 55. This Mr. Thakkar has said that did not be distinguished because it has been subsequently distinguished by overruled by another division bench. That's not the case here. I have given it a separate, Millard. He has distinguished it also.
Rajasthan Beverly.
Yes, I will not, my lord, give any judgment or anything. This, my lord, has not been distinguished. This is a case, my lord. Lordship can take it from me. If, my lord, what the notice of my learned friend says, A and B are linked together, suppression, it says 1 year's notice. Suit is not maintainable.
No, the morning I mentioned ad interim. If you argue the ad interim order for the last 5 days, so it is very difficult to go to and at the time of ad interim order, if you give the 10 or 12 citations, so what is the meaning of the ad interim? With regard to the unmarried, it's okay.
No, it's all right. I know, my lord, but we have to also, my lord, cut ourselves, my lord, short. If a lordship takes, my lord, page 44, document suppressed.
Page
44 of the opposition.
Not this judgment.
Yes, judgment I'll come, my lord. With the opposition, I show it, my lord. This is part of his opposition. I'm not showing anything from my petition. This is opposition.
Reply.
Opposition is signed by, my lord. This is part of its opposition. 23rd April 2024 filed in this court. This is after the amendment, my lord, of the City Civil Code. They take this point.
Also the judgment.
Opposition done.
Have you filed in the court?
Yes, yes, they have filed it. They have
But we had argued and shown page 44.
Opposition 24 April 2023 affirmation date. একটা তোমাদের কপি থাকলে দাও, জজ সাহেব আনলে যে সময়টা নষ্ট করে কি হবে? সংকোচন তোমার কপিটা দিয়ে দাও না, ঝামেলা চুকে যাচ্ছে।
ये तो কিছু করার নেই।
এই তো কপি দেব
23rd April।
পেয়েছে জজ স্যার, দেখো কোথায়। Like page 44 is the document of an even date of the document.
Yes, it is there. It's not written as a GA. It is yes.
Oh, GA number
Page 37 of the petition.
GA number
Yes.
হাতে ঠিক করে দাও। Page 37 of the petition and
page 37 of the petition
and page 44 of the petition. Lordship keeps it side by side. Of the opposition, Lordship.
And page
37, 44 of the opposition and 37 of the petition.
44, yes.
Both are dated 23rd of August 2020.
Yes.
23rd of August 2020. Both are dated.
Yes.
Both are signed by Millard. One Millard is signed by 3 persons. Kotha Kahini, page 37.
Yes.
New Central Book, Kotha o Kahini, PC Das, Sima Das.
Yes.
So the copyright holder has signed page 37. According to them, copyright holder is the main one. Though in act it is not. Copyright holder has now Millard, page 44 of the opposition. It is signed by the publisher. There is no seal affixation. I'm not on that, which is there in page 37. And Millard, the author, Millard Sima Das hasn't signed it. It's also on the same date, 23rd of Millard, August 2020.
Yes.
So Millard, this is there, this is there. Look at Millard, the language, handwriting is of the author. This Millard, only the rubber stamp Millard, company Millard has to have an official seal Millard. That's not there. This Millard has
the signature is not there.
Signature is there. The person signature of the publisher A Z such and such Millard, that is there.
AZ publisher, but the Sima Das
is not there.
Not there.
So Millard, Sima Das not there. It is only the author vis-a-vis the publisher.
And Katha o Kahini is also not
also
there.
not there. নেই আরে বাবা 2020 কোথায় 23 কোথায় মারা গেছিল 23 তো 20 ডকুমেন্ট দেখাচ্ছি তো Sima Das, this is a document signed on 21st August 2020, both the documents.
Yes.
Sima Das was alive on that date. Otherwise, my lord, Sima Das could not have signed this document at page 37.
Yes.
So this is during the lifetime of Sima Das, both the documents.
Yes.
So, my lord, firstly, it is not part of the agreement in question. It's not. Secondly, Seema Das, the author, according to him, Seema Das, the copyright holder or author has changed. She has not signed it. Thirdly, not part of the city civil court plate. It presupposes this was not intended to be used in respect of these books in question. Maybe it's written all books, but an exception is carved out in page 37. Otherwise, this would have formed part of the agreement in question. Same date.
Correct.
It's written all books in the top, Mr. Thakkar Millard.
All books.
Mr.
All books.
All books. He said all books means these books. But when an exception is carved out by the copyright holder and Millard, three parties in question in respect of these three books, can this document be a relevant one for the purpose of these two books in question? When this Millard doesn't form part of the initial pleading of Millard, the defendant in a court of law. This is my answer to
Then the all books is to be taken into consideration of the agreement.
All books.
Agreement of 15 June 2000.
Yes, all books. This is divorce the agreement. This is with the agreement. All books, how can be Millard? This letter, unfortunately, is not part of the agreement.
Correct.
How can you construe this all books as part of the agreement? Then it should form part of the agreement.
No. This letter says it is clearly expressed here
that all books written by
of
PC
all the books written by PC Das.
Yes.
Correct.
Correct.
And published by Central Book Agency.
Can the all books mean, Millard? My question is, can the all books mean, Millard, that it is covered by also the agreement? That is my question. The agreement has also the books covered by the agreement. If that is so, Millard, then Millard, this naturally would have formed part of this agreement. This is not part of this is part of the agreement. This is not a separate, Millard, it's an annexure to the agreement. This is not an annexure to the agreement. This is part of the agreement in question. Yes. This is annexure.
Part of the agreement means that is
Millard, the
2000.
2000 is
August 2000
agreement.
August 2000.
Yes. This is part of the agreement in question. Kindly, Millard, takes. There are two letters I have. That's the reason, Millard.
Letter A, letter B.
Letter A, letter B, Millard.
Both are letter A.
Yes, both are letter A, Millard. Kindly, Millard, takes, Millard, the letter in question.
Publishing agreement is 25th August. This
Yes.
is 23rd August.
Yes.
No,
So this forms part of
this letter is, what is the date of this letter?
23rd
August 2020.
2020.
Correct.
And
the agreement which
is
you
25th. 25th. Thereafter.
25th August.
So my consent is taken, and only thereafter that agreement has come into.
And in the agreement, this agreement, co-publishing agreement, is there any mention?
Millard, letter A. Are Baba, ki dana na ki bolchis?
No.
Yes. Consent to publish annexed here to and marked A.
Where? Which?
Kindly take page 31.
31.
If you Lordship wants, I'll produce the original.
No, that's where it is.
Millard, page 31. Whereas the co-publisher at the request of the publisher agrees to engage the publishing book at the stage of distributing throughout the country upon the author, copyright holder written consent to act as the co-publisher agreement annexed here to and marked with letter A. This is letter A. Is this letter A?
Letter A.
This is letter A, Millard. So letter A is the exception to all books.
So
that's the reason, Millard. The
page 37 is described in paragraph.
Copyright holder's consent. And whereas, well, I really don't know. This is the A. This is letter A of the agreement. If Lordship wants, I'll produce. This is A.
This was not argued before.
I argued strenuously. It's noted, Mr. You are not there. It's marked, it's noted.
Yes.
Recital.
This is not the consent letter per se.
This is the consent letter of the author.
Very well, but I'll make my submissions as and when, Millard.
It's a consent letter. If Lordship wants, I can show the original. Whether, Millard, this forms part. Because I read it again. Whereas the co-publisher at the request of the publisher.
Okay.
So this is A.
So this is, and what about the B, 38?
38, Millard, annexed, Millard, separately, Millard, this document in question.
So 38 is connected with B.
38, Millard, is a consent letter A. Lordship finds A.
37 is also A. That is the
Yes,
problem.
that is how the agreement in question is.
So this agreement which you are mentioning, the referring the page 31.
Same,
Page
Millard,
31,
it's same. Kindly take my lord the letter in question. Ori baba. Eta 1 year নেই। আপনি দেখুন না, পাশ থেকে comment না দিয়ে। Page 38, I take it this is letter A, my lord, and the author is the basic copyright holder, and he confers his copyright to Seema Das, and both agreed person, the author or the copyright holder or the author will have the right to take decision in the matter and publication of the books after expiry of the period of this agreement, or it may be continued or satisfied till the parties are satisfied. This is letter A. It's written as letter A, my lord. Same. Are Darao, ek minute. The same letter. We have annexed it separately. In 37 also letter A is there. Lordship finds
No,
on
37 and 38
are same.
Are the same letter?
Are the same letter. These are two same letters. We have annexed it separately.
Yes. Then
this is, my lord, letter A, my lord. Lordship will find this page 44 doesn't mention letter A.
Page 44 of the affidavit.
Affidavit in opposition. It doesn't have letter A. Page 37, my lord, has letter A. 38, my lord, I have annexed separately.
Yes, 44. This is also 23rd August.
Yes, but it doesn't, my lord, mention that letter A. So it's not part and parcel of the agreement.
Correct.
This is I argued initially. I'm very sorry, my lord. I just went.
I have taken note of it. It is
Yes.
there.
This is letter A is written. So whatever was the part of the agreement, because parties are fighting under a statute, where, my lord, there happens to be a contract in between. So, my lord, this, my lord, could not have been material, if at all, my lord. It's not a suppression at all, because this is not part of the document in
So
question.
you mean to say page 37 is the part of the agreement and you disclose, and from which they rely upon the 44, they are alleging that this is a suppression, this is not the suppression, because that is not the
That is not the part of the city civil court. When I filed a suit, they went to city civil court on 23rd of November 2023, because my suit is prior and the injunction was being heard before the puja vacations. They filed an amendment application to bring in within the ambit of the city civil.
This letter.
Yes, this is not part of the initial documentation or the initial plaint. This is not even the case in the city civil court that, look, there is no notice of 1 year. So, my lord, the termination is bad. Now, my lord, if I, my lord, takes, my lord, the bull by the horns. Look, 1 year. First of all, it is not. It is not relatable to the agreement or related to the agreement in question.
So so how you are dealing with this document?
This 44. Well, I have other books. So, my lord, basically, a time will come. Both parties can, my lord. That is my explanation in the reply. There is no sir rejoinder to it. My lord, there is a document.
What is your reply to this?
Yes. This is not relatable to the books of the agreement in questions. I have other books in questions. There are many. I have not terminated it and I don't wish to terminate. This is not the two book. It could have been a case, my lord. If I had only 2 publishing rights with him, to him, my lord, I have various other books recital to them. Various other books. If I want to terminate it, I'll give him a notice. And I don't intend to terminate it because he's paying me royalty in those books in questions. The problematic books are these 2 books in question. My lord, I am an author. I earn my livelihood from getting royalty. Kindly have a look at page 34 of the reply in question. Josh সাহেব বলেছে বলে আমি দেখাচ্ছি, আমি কিন্তু নিজে থেকে দেখাচ্ছি।
Yes.
Page 34 of the reply. My lord, I have with him, there is one English book, various other English, 18 books, page 34.
34 of?
The reply. I have other books, he's giving me royalty. Where is the problem? Page 34. I have 18 more books with him. Only because I am in court, I have an issue in this particular 2 books. I have not terminated them. My learned friend's argument would have hold fort if I had only 2 books. I have 18 other continuing publication rights with him. He is holding the publication rights and for which royalty is being paid. And I have no intention to terminate him. And if I at all terminate him, I'll give him notice. If so, you realize I'm 86 years old. It may not be terminated. I may not live that long.
Yes.
Because Lordship will note, if the intention of the parties were to make it a part of the agreement, this should have been letter A. And my lord, documented which 37 would not have been letter A. Letter A would have found place here, my lord. Then, my lord, my argument is I preempted this argument that, my lord, if there is a termination clause, I have cited the judgment I don't want. My lord, judgment Rajasthan Brewery said if there's a wrongful termination, means what? My learned friend and me, my lord, are having an agreement between us. 6 months notice has to be given in contract. Or lordship will find the cases in service jurisprudence. I terminate him without giving him adequate notice. What is the law then? It's law, my lord, not Rajasthan Breweries is not saying nothing new. It goes from 55 Supreme Court constitutional bench. My lord, the remedy lies the party who has suffered termination or suspension or, my lord, termination of service. The remedy lies damages for the notice period. That's the law in the subject. Now, my lord, refusing an injunction today will be what? This agreement is an agreement which, my lord, needs, my lord, it's not specifically enforceable under section 14 of the specifically fact. My lord, if you don't pass an order of injunction, I have terminated. Indirectly permits specific performance. So this is my first answer on termination on facts. Okay. Now, my lord, let us go to the law in question. So, my lord, Rajasthan Breweries, Division Bench of Delhi High Court, of course, persuasive value. My lord, which, my lord, basically takes into account the old Supreme Court's case. My lord, that, my lord, damages for the notice balance period. Now, my lord, kindly have a look at, let us go to the judgments in question one by one. Because this was on suppression. Suppression is a question of fact. I have to meet it by fact. By law, I can't meet it. Now, my lord, kindly takes, my lord, the judgments in question. First, my lord, kindly have a look at
Yes.
Chitra Singh, Jagjit Singh case, my lord, where estate will be represented. What was the case there? First of all, it's not a case of so-called copyright infringement. It's a case of, my lord, breach of personality or wrongful interference with the case of personality. It was a case, my lord, I'll just tell in 2 minutes, they go to the, that, my lord, Chitra Singh opposed, my lord, a program to be held by Punch Media and others for the purpose of giving some type of honor, my lord, to the deceased Jagjit Singh, my lord, to honor. Now, lordship knows Jagjit Singh is a famous ghazal singer, my lord, and his song, they cannot manage the copyright in question. So what is done, my lord, under section 31, read with section 33 of the Copyright Act, there's a copyright society. My lord, there are 3 copyright society. One is IPRS, other is PPL, and there is now a singers society also. So they basically manage the copyright, the authors or the artist or, my lord, music composers assign the right to the copyright society in question, which is a statutory body constituted under section 33 of the Copyright Act in question. Lordship has a Copyright Act. Yes, kindly have a look at section 33 of the Copyright Act. No difficult. Section 33 is the Copyright Society. Lordship will find section 33 in question. At a Buyano copyright. Now, so the permission was obtained by Punch Media and others from the Copyright Society itself. So, beloved, he has a permission as on this date. I thank you. Either by the author or the composer or the copyright society. He has a permission from the Copyright Society in question. The wife went and, my lord, filed a suit saying that they have no permission. Now, in the ad interim stage, he is showing that he has some sort of permission, unlike the present case. Someone has authorized. PC Das may not have authorized you, but his son has authorized. But someone else has authorized you. Some other assignee has authorized you. Now, my lord, kindly take, my lord, the judgment in question, paragraph 2. There are, my lord, distinction between the author rights is the highest right. He has independent copyright otherwise than Millard. These are author's special and moral rights under the Act. Under the Act, the widow and sons will not get this right. If I write a book, I have my moral rights preserved. I have my beneficial rights preserved, irrespective of the Act. Because this is why the Copyright Act is, to protect the author. So Millard is just a reverse proceeding. Here the author is before your lordship with his one of his son. Here the widow only, the author has passed away. So in this context, it was said, the plaintiff is the widow of the renowned singer as Ghazal orator Jagjit Singh. She claims to be the owner of copyright as well as any other connected right concerning the works as well voice, name, picture, persona, goodwill of the deceased singer. Now, Millard, copyright is fair enough, but Millard, voice, name, picture, persona, and goodwill, like a defamation, Millard, like a goodwill of my goodwill, Millard, cannot go to my learned friends, Millard, if I am related to him on my death, because it's a personal cause of action. So this is how the suit was framed. Now kindly take the next one. It is submitted, paragraph 3, fourth line from the top. It is submitted that the deceased singer Jagjit Singh has enrolled himself as a member of IPRS, which is the representative bodies of the owner, music, composer, publisher, etc. It is submitted that society is the owner of the copyright of Jagjit Singh and has been granting license for use of the work. In the case of the defendant has duly procured the license from the society from payment of license fee from using the same to the defendant works of Jagjit Singh for the correct to be held on 18 February 2016. The defendant has produced various documents including printouts from the website as well as the relevant page showing membership of the singer of IPRS, the license granted by IPRS to defendant number 1 for making beneficial use of the songs of the deceased singer on the various licenses opted by the defendants for the performance to be held on 18 November 2016. Based on this document, it is submitted defendant has the authority to make use of the musical work of the deceased and accordingly has proposed the upcoming concert fee for the deceased singer as a tribute to the legendary singer. So it was a tribute. Correct. Secondly, Miller Lordship sees that the defendant had a license from the assignee, the Copyright Society, and he has paid fees and he wants to hold the program. So he is a holder of a valid license on assignment. It's not the case here. Here, Millard, where is the case, Millard, that he has not obtained? I am saying as an author and my first son, I have not given any consent. The second son, Millard, is not a party. He is also not coming. He is showing that any consent has been given by the second son in question. Rather, the second son has issued, he said, published a book. I assured that the book by the consent of the second son. Second son said, I don't give you any consent. I have no right to the books in question. Now, Millard, in this context, para 4. This is not even a case of copyright. Though the case is made out by the plaintiff in her plaint is mainly for breach of copyright, though other bundle rights are vaguely referred in the umbrella expression, namely any other rights, was argued by the court that the term of personal rights in the name of the deceased singer said to have been vested in the plaintiff, which has to be infringed by the defendant. Now, Miller, there cannot be any infringement in cause of action A because the Copyright Society has granted the defendant in that case a permission to conduct the program in question. And second was basically the case. Now, kindly takes para 7, issues. Yes. Whether by reasons of the body of work of an individual or his celebrate status acquired due efforts and endeavors, the right of use of his name and personality, voice and images come to inherit to the individual. So, the personal rights which the author has gained, can an individual claim after his death? That's the first issue. B, whether the rights has survived the individual and has come to be vested in the plaintiff who holds the same as on the date of the cause of action. Whether the defendant has made or threatened to make unauthorized use of the name, personality, voice, image to detriment of the plaintiff. Now, para 9. Coming to know of the facts, a part cause of action pleaded is a breach of copyright, though other rights are simply based on defamation, damage to the name, reputation, and goodwill of the celebrity. For these causes of action, defendant have a complete answer, at least prima facie. Defendant have acquired, this is most important, defendant has acquired a license to use the musical work of the deceased singer by payment of a price. The defendant have produced the material in support of such acquisition. the material is prima facie available and acceptable. On this material, it certainly cannot be said the defendants are making unauthorized use of the musical work of the late singer. As the case of defamation and damage to reputation of goodwill, there is hardly any material placed by the plaintiff before the court, 7 except bare allegation. No prima facie case has been made out for infringement of copyright or defamation to the damage and goodwill and reputation. So, Milord, he already had a license, may not free from Chitra Singh, the deceased, but Milord from the society who holds the assignment. Now, Milord, next paragraph. As far as the right of personality, is it a case of personality concerned here? As far the right of personality is concerned, so not copyright. I'm very sorry. There is no pleadings before the court, no materials is produced in support of the case. I have already noted above that various fundamentals have to be made out, namely the nature of the right in the indicia, which have to be inherent to the deceased singer, whether the right has survived the deceased. This is the argument. Well, defamation and goodwill and everything is a personal cause of action. Well, his wife or daughter will not get it. Whether the plaintiff actually holds the right as on the date of, and whether the defendant making unauthorized use, name, voice, image, a matter of fact which must be found on pleadings. The pleadings of the plaintiff wholly lacks of particulars. The plaintiff has, for example, not shown whether in what manner the plaintiff has come to the holder of copyright of publicity to be said belonging to the deceased center. It is the plaintiff is not only the legal heir, he plays that of the deceased is entitled to the rights of personality. Here the author is alive. He has deceased singer not assigned offer personality to any other third parties of the earlier. In other words, does the plaintiff actually hold the alleged rights as on days of cause of action? There is no material to show through any rights on the matter. On the other, defendant has produced material to show the right to the musical work, which originally inherited to the deceased singer, appears to be assigned to a third party from whom the defendant have acquired a license to the use, or how it applies to the facts of the present case. If the defendant proposed to make use of musical work of the late singer after duly acquiring right to, it is unconceivable whilst they hold their performance playing musical a late singer after obtaining license, they cannot announce the program will showcase such musical works, and that in connection the name or even the image in the matter. It is difficult to say that prima facie stage on the basis of the material produced by the plaintiff that such use by the defendant is unauthorized. In other words, none of the foundational facts which are noted above is made out by the plaintiff in the present case. The plaintiff has made a prima facie case for grant of and failed to make a prima grant of ad interim injunction. So, Milord, if there is a license from an assignee, where is the question, Milord, of Milord or a copyright? Where is the question of unauthorized use of a copyright infringement? It's a fair use and the definition of the section. Secondly, Milord, it's a right on personality, Milord. This is said, Milord, the heirs, etc. Heirs are not there. Milord, my goodwill, my reputation, Milord, whatever I do here, Milord, perish on my death. It's not transferable, Milord. So, Milord, if it is used in future, after my death, Milord, obviously, Milord, no one can claim a right on that. But copyright is concerned, Milord, first of all, if you want to exploit it, A, you should get it from the author, B, you should get it from the copyright holder, C, you should show prima facie that you have got it from a copyright society.
Yes.
On an assignment. So, Milord, the first judgment is out. He showed 8, Milord, 2 or 3, I'll do it together. Now, Milord, kindly have a look at the next judgment of my learned friend, Milord. volume 8 तो नेक्स्ट जजमेंट की देखिए बोला था बिहार स्टेट इलेक्ट्रिसिटी बोर्ड তোমরা দেখিয়েছো 2000 ভলিউম 8 এসসিসি 560 তাই তো দেখিয়েছো তো Now, Milord, kindly have a look at the next judgment my learned friend showed 2000 volume 8 Supreme Court cases 560 Bihar State Electricity Board UMI Special Steel Limited দেখিয়েছিলে তো আমাকে অ্যাটলিস্ট কপি তো দিয়েছো
Yes.
For the purpose of novation, etc., Milord, kindly take, Milord, paragraph 10. We have set out the letter dated 24/2/1975. As seen, there is no request for termination of the agreement as contemplated in the clause 9 of the agreement. In fact, there is no request for termination at all. Is it the case here, my lord? There are termination notice. My learned friend is saying, look, termination is not of the main agreement, but of the co-publishing agreement. Termination notice, there is a cease and desist notice. That itself cannot be a termination notice. There's a termination notice mentioning a different date of the agreement in question. But what is the intention of the party? I don't want to continue with you. But this letter, the respondent is asking the applicant to disconnect the supply. So electricity board case, my lord.
Yes.
By the said letter, the respondent is asking the appellant to do is disconnect the supply. The appellant pursuant to this request has disconnected the supply, but this does not mean that the agreement stood terminated. The agreement will continue until it is determined by the parties. The only method of determination was clause 9 of the agreement. As admittedly no notice in writing of 12 months was given, the agreement would terminate no notice the agreement would terminate as per clause 9 after the period after disconnection. So if at all the agreement continues, the agreement will terminate after disconnection. This is so. Therefore, the agreement subsisted till such and such. As the agreement subsisted since such and such, applicants were entitled to claim the minimum charges for the period such and such. The High Court has seriously erred in holding otherwise. So if the agreement is subsisting, I stop here for a moment, just for, if the agreement is subsisting, the case made out and he showed this judgment, merely saying, my lord, the agreement subsisting will not do. My lord, where in the pleading or where on the documents he has shown, my lord, his corresponding obligation, which is cast upon him under the agreement. What is the corresponding obligation, my lord, under the agreement? To pay me 10% of royalty from my lord, the date when allegedly, my lord, the agreement again resurfaced according to him. My lord, the pleading, there is none. There is no offer to pay any royalty. My lord, agreement, you may say the agreement has continued. I may say it's terminated. But on the conduct or on the affidavit on record, where is the statement, my lord, or where is the statement given, my lord, for this period I have offered him royalty, he has refused to accept the royalty.
Yes.
For the purpose, I am saying agreement, my lord, this is provided under the Contract Act itself. If the agreement is continuing, my lord, there must be something on your part, my lord, landlord, tenant, my lord, the lease is continuing. So there should be offer to tender, my lord, the royalty in question. Where is the offer? Where is the offer to pay me a 10% royalty? There is none. The agreement cannot continue in way. My lord, kindly, my lord, let us consider. As the agreement subsisted, the appellants were entitled to claim annual charges for the period such and such. I could erred in holding otherwise. Be it mentioned that this court by an interim order dated such and such clarified the order permitting the respondent to withdraw the amount of minimum recovered by them. The respondents were directed to furnish bank account to respond. Therefore, they are bound to pay the amount with interest at the time for 12% per from date of recovery of the recovery orders. So if something is continuing as per the agreement, there was a special clause that termination has to be in that clause of the agreement. First of all, between me and him, the agreement, my lord, doesn't have any sort of termination clause. Rather, my lord, the annexure A to the agreement says, my lord, I am entitled to take decision. I have taken a decision not to continue with it. Now, my lord, if he says the agreement has continued, the corresponding, my lord, right, my lord, comes, my lord, from the purpose of how the agreement has continued. By payment of royalty. By offering to make payment of royalty. He has to show, my lord, that I have refused payment of royalty. There is not a sentence subject to correction, my lord, or whisper, my lord, that any royalty was offered to me, my lord.
Yes.
Or the years in question. In respect of other books, yes, I have given the chart. Yes, he is giving me royalty. Now, my lord, kindly take the third judgment in question. (2018-10 SCC 707).
2018-10
SCC 707. My lord, kindly take, my lord.
2018-10.
10, my lord, he showed, my lord. 2018-10 SCC 707.
Yes.
A Suzuki, official liquidator, Justice Ranjan Gogoi, Navid, Justice Sinan, Justice Kurian Joseph.
Yes.
Kindly have a look at para 7. This is also not a copyright case. Even Jagjit Singh, Chitra Singh, not a copyright case.
Yes.
The earlier judgment was an electricity case on the electricity license. And this is, my lord, in relation to BIFR and the company rules. We have considered the submission on behalf of the parties that the unregistered MOU was without permission of BIFR. It was not disclosed to the company court while winding up order was passed on 19/4/2010. The assignment of debt of 160 crores by IFCI by 85 lakhs was admitted fact. The order dated 31/7/2005 passed by the company court makes it explicit that the appellant company had specifically sought substitution of IFCI as a secured creditor holding first charge consequent to the deed of assignment in its favor from IFCI in support of the relief sought. What was placed puris dated such and such, the tribunal reaffirmed, etc. The submission made before the company judge leaves no doubt as to the assignee of the debts from IFCI. The appellant was essentially sought to be substituted secured creditor under the SURFACI Act and the purpose to draw substitutions from the provision of Section 130 of the Transfer of Property Act. Therefore, the company judge opined the Section 130 of the Transfer of Property was not applicable to the facts of the case, leaving it open to the party to take all available contention before the appropriate court forum in the proceedings. In the nature of controversy sought to be raised by the appellant in the present appeal, we consider it to set out the extract from the order of the company judge. The only question which is required to be considered in this application is whether the applicant can be permitted to be substituted for in place of IFCI as a secured creditor of the company in liquidation. For deciding the question, certain provision of SURFACI Acts are required to be quoted. Now, para 25. I am of the view that the provision of the SURFACI Act, I am of the view that the appellant company is not a bank or banking financial for securitization reconstruction company. The applicant cannot be permitted to be substituted in place of IFCI as secured creditor for the purpose of SURFACI Act. The aforesaid provision of 130 of the Transfer of Property Act are not applicable in the facts and circumstances of IFCI transferred debts in favor of the applicant. The deed of assignment, therefore, in the case of applicant, may be permitted to proceed against the company in liquidation under the SURFACI Act. Secured creditor applicant is not entitled to get a benefit of the SURFACI Act. So, this was a case, my lord, when someone who is not a banker or a financial institution or a bank is seeking to be substituted by way of an assignment under Section 130 in place of a bank in a SURFACI proceedings. That's not permissible, my lord. Kindly, my lord, takes my lord paragraph 10. My lord, Placitame. No material has been placed before us with regard to orders that may have been passed by the tribunal on such application. After the claim of the applicant being secured creditor was rejected by the company judge, the appellant realized unsustainability of claim before the court of law. It was a complete volte-face from its earlier stand, surprisingly contrary to the pleadings, now content that has never sought the status of a secured creditor under the SURFACI Act. The contention of the appellant that is never been sought to be substituted as a secured creditor is additionally belied from the recital contained in the order dated such and such. Time and again, this court has held the recital of the order sheet with regard transferred before the High Court. A learned judge in the review jurisdiction has reiterated the arguments of the company judge. Now, my lord, kindly, my lord, takes my lord, the SURFACI, my lord, two contradictory stand in two separate proceedings. My learned friend says you have taken two contradictory stand by saying in the same proceedings that it is, my lord, novated and or stand superseded. Now, my lord, the judgment which he shows, my lord, are, my lord, two contradictory stand in two proceedings. This is on this context the Supreme Court has said. Now, my lord, kindly, my lord, takes, my lord, 712, the last page. Where this Supreme Court, my lord,
yes,
it is required to be noted that the learned advocate for the applicant in the said application, the same time of argument submitted, the appellant be substituted as security creditor and given benefit under the SURFACI Act. Therefore, the learned advocate Mr. Rao appearing for Bank of Baroda submitted in detail that after relying on the provisions contained in SURFACI Act, the applicant cannot be substituted as secured creditor and permitted to proceed under the provision of the SURFACI Act. A litigant cannot take different stands at different times. Yes. It's not different stand at different times. I have not filed only one proceedings. In the proceedings in the plaint, I have stated, my lord, novated and or, my lord, substituted or whatever. I showed the pleadings. Yes, my lord, saying so, I had relied on two Supreme Court, one Delhi High Court judgment, one Supreme Court judgment.
No, the litigant can
Cannot-
take different stands at different times, but cannot contradictory stands in the same case.
Same thing.
Yeah.
Millard, is this a contradictory stand? What is my stand, Millard? My stand, Millard, that agreement is no longer there. Either it's novated, whatever you say, or terminated. Millard, in the same proceedings, Millard, I have come and made Millard an alternative. It could have been mutually destructive when, in A proceedings, I say, Millard, that I have no right. In B proceedings, I say, no, I have a right because this exception was given to me. These are, Millard, mutually destructive stand. But, Millard, if I, Millard, even take, Millard, inconsistent pleas or divergent pleas in the same proceedings, Millard, that, Millard, does not, Millard, denude me of a cause of action for which I have cited a Supreme Court judgment, Millard, which my learned friend has not distinguished.
Yes.
Srinivas versus Mahavir Prasad, that is AIR 1951. I had Millard Srinivas versus Mahavir Prasad. I had cited that, Millard. And also, Millard, a subsequent 2004, I have cited it, that you can also take, Millard, different stand, but your cause of action doesn't go. So this, Millard, how it applies, it's in the... Now, he played, Millard, law is not a game of chess. Millard, kindly take. This court wants to make it clear that an action at law is not a game of chess. A litigant who comes to court and invokes writ jurisdiction must come with clean hands. He cannot pervocate and take inconsistent position. Millard, what inconsistent positions I have taken? So far with me, your position is what? That you have no right to publish. It's not a case, Millard, that I have taken royalty from you. I have persuaded you, Millard, to act A. Now I file a proceedings and Millard try to act you in a manner B. It's not a case, Millard. Okay. And my judgments on, Millard, contradictory pleading or doctrine, Millard, is, Millard, not, Millard, distinguished by my learned friend. Now, Millard, kindly now takes his, Millard, fourth judgment.
How much time will take?
Millard, more or less 4-5 more. He said, I'm only going by the judgment.
3 p.m. Other matters.
7, 7 আরে একসঙ্গে করে দিয়ে দাও ভাই।
Come.
7 more, আরো 7টা। ও 7টা আরো দেখিয়েছে বাবা। একটাও তো কপিরাইটের নয়।
So and so appearing for the plaintiffs, so and so appearing for the defendants. The counsel for the plaintiffs has argued at length in reply.
না না ও দেখিয়েছে।
But due to paucity of time, hearing could not be
আমার কাছে
completed.
আছে।
Fix.
এই ওটা ওর। তোমার নাই? এটা কার? এটা কার? এটা শঙ্কর। না। Oh, sorry.
The commercial matter, na?
It's a commercial matter. Except Thursday, any other date, I know.
On 18th. As part of
যেতে পারি
18th March.
Can it be, Millard, any? If I'm not there, Millard, kindly, Millard, gives it at 2 p.m. If I'm not there, Millard, Dunlop is fixed that.
Okay. Take your book.
I'll take my chance, Millard. I keep my juniors. Grateful, much of.
Yes, next. See, commercial, non-commercial. Item 2.
But there is a section 8 application by my client defendant. I think that has to be considered first. They have it is their suit and injunction application. I have a counter section 8 application.
Lordship, I'm just praying for some time, not today, in this matter, as I'm being led by Mr. Snehashi Sen. He's not available today due to ill health. With regard to the suit, Lordship,
I have made myself ready, my lord. Your lordship will know that I am appearing in the first day today in the matter. Now briefed, just now briefed. But since your lordship has fixed the matter.
No, after hearing his submission, I thought since morning the same thing is going on.
That is why specifically, that is why I made myself ready, at least so that the time is not wasted.
Lordship, I tender my apologies.
To deal with the matter, sir. It is fixed. When the matter is fixed? On 15 January, the matter is fixed today at 3 p.m.
Lordship, I'm not.
Ask your advocate how much cost he will pay.
Lordship, if only
that is the only way for adjournment. Otherwise, you start.
Lordship, I'm not briefed.
I don't know. If you not, then I will hear Mr. Sen and I will pass a appropriate order.
If your Lordship could
I am
just
giving three options. You take instruction. How much cost your advocate will pay? Second, if your advocate is ready to come and argue. Otherwise, third option, I will hear Mr. Sen and I will pass appropriate order. Because fixed matter is very difficult to adjourn. If I adjourn this 3 p.m. matter, where is the other advocates? What matter I will take?
I understand.
Then
just one indulgence, just one last opportunity, Lordship. This won't be repeated from.
No. I will not grant adjournment. I only given 3 options. You opt this 3 option. What option you want?
Then I can start with my Section 8 application.
Correct.
Because that is the defendant's application in any way that has to be proceeded with.
In that case, if your Lordship could kindly grant a short passover, I can take instructions.
Go and call your senior, whatever it is. What is your instruction? Tell your senior I will not grant adjournment. The simple way.
My Lord,
Fixed
if I could
matter,
just,
I will not grant adjournment to any.
if I could just get instructions, and Lordship.
The money suit, their suit is a suit for recovery of money based on purchase order. I have come up with a Section 8 application under the Arbitration Act saying that the purchase order contains an arbitration agreement. They are saying that there is no enclosure to the purchase order. So they are disputing the existence of an arbitration agreement. For that, they had filed a Section 16 application also. Now that difficulty is what the arbitration clause says that the International Chamber of Commerce is the institution who will appoint. So we have invoked the arbitration clause. We have given a notice to the institution. Institution has come back to both of us saying as per their rules, the fees are to be deposited. We have deposited our share. They have not deposited their share. That is why, my lord, their Section 16 has not been adjudicated. And it is still lying there. Now, question is, where even in their suit, they are saying that the issue is a non-existence of an arbitration agreement. Why shouldn't it be decided before the arbitrator? How can the suit proceed? Therefore, my lord, under Section 8, the second limb is accepted.
What is the ground in the 16?
The 16 has not been adjudicated. It is just, even the reference has not commenced because they have not borne the court fees. And I have they have themselves annexed the documents that the institution has called upon them to deposit the fees. Fees have not been deposited. Therefore, institution has not adjudicated their Section 16. Now, question is whether the suit can proceed. How can the suit? I could have understood your case is that the subject matter of arbitration agreement is different, suit is different. That is not your case. Even in your plaint, your case is that the arbitration agreement does not exist.
Yes.
Now, they are saying the question of fraud. Fraud because that second page has been inserted in our purchase order. It is not in there. Now, my lord, Supreme Court judgment, even issues of fraud can be decided by arbitrator. There is no legal bar. So what prevents them, my lord, from going?
Yes, what instruction?
Lordship, if only it could be made not today, tomorrow he'll be present due to a very urgent.
This court, you see the diary, you choose your date. My officer will give the diary of this court. Choose the date, any date before last week of May.
Most humble prayer, Lordship. Only if could be accommodated just today.
Pay the cost. I will adjourn, no problem. Come after in the month of June.
No, Lordship, cost
vacation.
if your Lordship could just accommodate one day, your Lordship.
So and so appearing for the plaintiff. So and so appearing for the defendant. The matter is fixed today. And the matter is fixed. Matter is especially fixed today at 3 p.m. for hearing. But when the matter is called from the learned counsel for the plaintiff, press for time. This court find that by an order dated 15 January 2025, this court has fixed the matter at 3 p.m. with the consent of both the parties. But when the matter is called today, learned counsel for the plaintiff press for time. Considering the above, this court, considering the above, the case is adjourned subject to payment of cost of 50,000 to the State Legal Service Authority within a week from date. If the cost is paid to the legal state legal service authority, let the matter appear. Give the date. Huh? 10th June at 2 p.m.
Obliged.
Partial list. 149 number 6.
RPF for the defendant number 2, right?
Yes.
I was in reply, my lord. I was to deal with few judgments, my lord, cited by my lord senior. The lordship will kindly first take note, Yamini Manohar. I have also referred to that note, and the plaintiff has also placed it. I only indicate 2 paragraphs.
Yes.
The paragraph 7, my lord, lordship will.
Para 7?
Yes, internal page 4. Lord, in the present case, it is an accepted fact that an urgent interim relief has been prayed for, and the condition that the plaint contemplates an urgent interim relief is satisfied. So there was, in fact, a prayer for an urgent interim relief in the plaint itself, which my lord Mazhar Hussain, my lord, our division bench has also held. But however, in our present case, my lord, in the plaint, there is no such relief at all which is prayed for. And paragraph 10, let's same that in that case also there was an urgent interim relief prayed for in the plaint. But that's one. Yes. Lord, Lordship will therefore thereafter kindly take, Lord, the Telangana High Court judgment, Lord. And in fact, I shall rely upon a few paragraphs of this judgment.
Yes.
Lordship will kindly take paragraph 4. May I just place it in short? The respondent number 1 plaintiff filed the suit for permanent injunction for restraining the defendants from infringing trademark dress.
Where from you're reading?
Lord, paragraph 4.
Paragraph?
4. Page 4, paragraph 4.
Yes.
It's an unreported judgment. Lordship has found it. Infringing the trademark, trade dress and copyright of the plaintiff, trademark packaging, Sadanand. I'm not reading or placing all that. And from passing of the defendants, the plaintiff claimed damages, rendition of accounts in the said suit. The plaintiff whether also filed an application for temporary injunction. So this also, there was an application. And thereafter, Lordship will kindly take 7 also, that there was an application. And thereafter, the paragraph 25, exactly when the application was filed after presentation of the plaint, that is also given.
Yes.
Now, thereafter, in paragraph 27, page 12, Lordship, Honorable High Court of Telangana has considered the nature of the suit, that in the nature of in the suit of nature infringement, it is by inherently it is urgent. And thereafter, most importantly, which I will rely upon, paragraph 30. Even otherwise, the urgency with which the plaintiff instituted the suit would also be evident from the plaintiff not losing any time before filing an application for temporary injunction. And that's most important paragraph, and I rely upon it. It is not a case where the plaintiff went into hibernation. In fact, it is just the opposite case. In this case, the plaintiff, in fact, went into hibernation. GA1 for extending returnable date of the date of summons was like filed 6 months or 7 months after presentation, and the GA4, that is for injunction, was filed 1 year thereafter. So I specifically rely upon this, and this is therefore the promptitude with which the plaintiff proceeds with the trial or with the suit and the application, my lord, has to be looked into, which, my lord, goes in my favor because in 1 year thereafter he has filed a suit. Lord, that's all. And Lordship will kindly take, Lord, on last occasion, Lord, Mr. Shah has handed over, Lordship, the judgment in Holdibari Tea Manufacturers
Which one?
LLP. Haldiwadi Tea Manufacturers LLP.
Haldiwadi, yes.
Yes, Manu, that's the most recent that we could
Yes.
lay our hands on. But this is one particular by such a small section, my lord, and see the amount of trouble that it has created. Highly see, my lord, the number of judgments, my lord, on this. It's
Correct.
the time for your lordships, my lord, to now narrow line and stream it down.
And that's why now we are trying now the commercial court, it has to be streamlined. Starts from the leave, filing of return statement, filing of the counterclaim to the return, filing of the return statement to the
My lord,
counterclaim.
I have always, my lord, I don't know, my lord, your lordship's experience is maybe different. I have found, my lord, that the laws which work in the West, my lord, they don't work in India.
That's absolutely true.
That is the problem.
Absolutely, my lord. These are all concepts, my lord,
That is the problem.
imported,
Imported from
which do not work here.
That's why now the what is the arbitration? International Arbitration Center.
Every day there is a
Very
new
difficult
judgment.
for India.
There
They
is,
know
every day
that
there is
the-
a new judgment
in India
explaining
it's
one
very
provision or
difficult to proceed with the arbitration, but pursuing that.
You know, arbitration, when I look at the state of section 34, I think the entire thing, the whole thing has failed.
No, total
Completely failed. If you had held the arbitrator to be the ultimate authority, then, but every matter.
What is the necessity of 34 and 37?
Well, the necessity is one of credibility, my lord.
That's true.
My lord, today, my lord, your lordships, my lord, even if your lordship pass a wrong order, my lord, one may be aggrieved because it, my lord, the order could be wrong, my lord, but at least, my lord, the credibility would not be in question.
That's good. Yes. Yes, which paragraph you are relying upon?
Yes, my lord. In paragraph 3, page 2, again, my lord, the same thing. It may be noted that the instant suit was filed on 15 March 2023 and simultaneously with the filing of the suit, an injunction application was in fact moved. In such circumstances, my lord, his lordship had ultimately, my lord, found kindly take paragraph 17, page 14. The other paragraphs which I will indicate in the note just for today's purpose, my lord, I'm just placing these. 17. Perusal of the statements made in the plain spells out that the plaintiff have prayed for urgent interim relief. Again, the test satisfied. From the order sheet filed in the case, it would transpire that simultaneously with filing of the suit on 15th March 2023, the plaintiff had also filed an application under Order 39, Rule 1-2. Admittedly, the suit was filed to seek urgent relief. The plaintiff has, however, failed to succeed in obtaining, and this is important, failed to succeed in obtaining any ex parte interim order. Simply because the plaintiff did not succeed in obtaining interim relief, the same cannot be a ground for rejection of plaint. But now the next line is premised on this finding. As noted above, even a weak case of urgent interim relief cannot be thrown out. The event subsequent to presentation, the contemplation of the Honorable Court was that he did not succeed in obtaining an urgent interim relief. So therefore, if you fail, that cannot be a ground for rejection of the plaint. It is in those, keeping on those facts in mind, those observations, this line, the events subsequent to presentation of plaint are not relevant. That is was made. That observation was made. Not because of.
See, with regard to 12A, this is the contemplation. The court has to judge at the time of grant of leave under section 12A whether the urgent relief is contemplated or not.
About
Correct. If the court finds that yes, urgent relief is been contemplated, it is not necessary. If it is the court will not allow the plaintiff to leave, then the plaintiff will suffer. So court grants. Subsequently, whether injunction filed, injunction not granted, that is subsequent issue. Now the court has to see whether the leave which has been granted as per your application now, whether any urgent contemplation was there or not.
May I just one second? In paragraph 93, I have indicated in my list, the Honorable Supreme Court in Party Law Automation has contemplated two stages at which this can be considered. Either at the stage during institution of the plain presentation, whether it was necessary whether leave can be granted or not,
Correct.
Or after issuance of summon, when the defendant can take this plea that although the suit was filed but there was no contemplation of urgency and
Correct.
therefore it should be rejected.
So that's it is not that the defendant cannot take plea.
Yes, that is all.
My thing is that my opinion is that the court has to see with regard to the urgent contemplation, because the court cannot say whether we cannot put the question whether you file an injunction application, whether at this stage you want the injunction. Court has to see in the paragraph, in the body of the plaint,
Whether it's been pleaded. It's a
been pleaded.
contemplation of
And yes,
urgent
that is
relief.
the contemplation, and whether that has been taken into consideration by the court, whether that contemplation is right or not, that is to be considered as per your prayer.
And paragraph 18, sorry, I'm reverting back to another judgment. Last Kohinoor Steel, Telangana High Court judgment. Not sure, kindly Telangana High Court judgment. Paragraph 18. That if
yes.
But may I just place it? Section 12A of the Act, read with the case laws cited on behalf of the parties, can be summed up thus. The plaintiff seeking to institute a suit under the provisions of 2015 Act must first satisfy the court that the suit contemplates urgent interim relief.
Correct.
If the suit contemplates otherwise, that is, interim relief can wait, the plaintiff must first exhaust. In this case, that is what has happened.
No. This what I am saying. That's why. See, you presented the plaint before this court.
Yes.
With the leave under section 12A.
Lordship does not know whether I am actually filing an application or not moving at that stage.
This. The court has to see whether the urgent relief which they have prayed, he can wait. It is not necessary at this stage the leave is to be granted. So no, we are not granting leave. You can wait. You go and process the pre-institution mediation. That is the court says that always. Now here the situation is otherwise. Here the situation court has granted.
Yes.
Now you and appeared. Now you are praying for revocation. Whether that revocation is to be considered by this court, whether the revocation, the leave granted by this court at the time of filing a presentation of the plaint, court has contemplated what urgency has been contemplated by the plaintiff or not.
This is not a 12-way grant. This is a 12-way revocation. That's the principle, my lord.
The grant which has been given, the dispensation.
This is not a 12-way grant. This is a 12-way revocation.
Rejection of plaint, in effect. Look, what I would say.
Well, I think we've covered your lordship enough.
I today, my lordship, will consider today come before lordship seeking for a 12-way leave. Although Yamini Manohar says that it is not required, there is no provision for even granting that leave in my humble submission has no relevance. That is one. Secondly, my lord, I come before lordship, my lord, I say that yes, there is an eminent urgency. If I don't file the suit today, then there will be something, my lord, they will dispose of the assets or something or the other. Lordship at that stage, my lord, will believe me, perhaps, my lord, in the facts, if I can satisfy your lordship. But at that stage, my lord, lordship may or may not know whether actually an application is coming or not. Whether I'm actually praying for an urgent interim relief or not, or moving or not, or this prayer or this my prayers before lordship to grant dispensation is just a ruse.
But what is your reply to the Gabriel?
Look, Gabriel, my lord, I had already, my lord,
yes,
distinguished.
My learned friend, my lord, has tried to distinguish, my lord. I have prepared a small note for your lordship's consideration, annexing the judgments. That's why it's become slightly bulky, but the note is, my lord, in double space. And
no problem.
Gabriel, even, my lord,
may I hand it up?
Submitted before your lordship.
My lord, with your lordship's leave, my lord, I am not, my lord, giving a copy to my friend. I am not, my lord, included any time bombs, my lord, any judgment which I have not cited, I've included. It's not
I
that.
believe
But my lord, I feel that, my lord, nowadays, my lord, when we exchange notes, then, my lord, that becomes, my lord, an affidavit in opposition sometimes. So,
Okay.
my
Yes.
lord,
that Gabriel Millard, Lordship has the judgment.
Yes, Gabriel, I am.
Paragraph 14 and 15.
Hmm.
No, sorry, 15 and 17.
15 and 14, 15 and 17.
17, right. 15 and 17 contemplates that if I go to mediation, that 3 months I'm stuck. I cannot come out of that mediation, and for 3 months, if I need an urgent interim relief within that 3 months, then I will have no other recourse but to complete the mediation. And the defendant can perhaps take this advantage and remove his assets or do something to defeat the decree. Now, firstly, Lordship will now kindly take paragraph 32. This is His Lordship Justice Chaudhary's view. What I want to really show is that the Honorable Division Bench was divided in opinion. So this really cannot be a.
No, it is not divided.
May I please this, Millard?
It is not divided in opinion. Justice, the second judge has given another judgment, but not.
May I just try and satisfy your Lordship? Pre-institution mediation is provided for the purpose of amicable settlement of the disputes prior to moving court of law. But such procedure should not be used by a defendant to delay the resolution of disputes and to defeat the lawful claim of the plaintiff. Any attempt made by the defendant to delay the matter in the mediation process would amount to abuse of process of law. The courts are empowered to pass necessary orders to prevent abuse of process of law. Even when pre-institution mediation has commenced and a plaintiff is aggrieved by the acts of the plaintiff in not appearing in the mediation process or delaying the matter intentionally to deprive the plaintiff of his lawful claims, the plaintiffs may withdraw from the mediation, which His Lordship, Justice Mukherjee has said in 15 or 17, then I am stuck for 3 months. I cannot come out.
Correct.
And in paragraph 32, His Lordship has stated that yes, even if there is a situation I can withdraw from the mediation, I can come before your court even before that 3 months. Hence the internal inconsistency. May I just try and read it again, Millard?
No, I got
even yes, Millard. That is why.
Millard, in this regard,
I'm not
just
stuck.
one small observation, subject to what your lordship feels. Millard, this mediation and 3 months spent in mediation, this was used as an example. The principle laid down, the ratio decidendi laid down in this judgment is, my lord, the same as in all the other judgments, that it contemplates, my lord, filing of an and, my lord, by way of example,
the court has given.
Court has said that, look here in mediation, for example, for 3 months, then you'll be stuck. So, my lord, the mediation angle in the Gabriel judgment, my lord, is only vis-a-vis, my lord, to provide an example.
No, but you come to the this paragraph 21, not 21. Paragraph 16 of the judgment. Paragraph 16. Court has interpreted the legislature
because 3 months is provided and there can be an extension of another 2 months. Because I was there, personal knowledge, I am aware of this. The Lordship had the Lordship specifically asked what is the time period for mediation. It was 3 months and it can be extended for another 2 months.
Okay.
So that minimum 3 months was considered.
Okay. Anything further?
Yes, Millard. Only Millard, the Shishi infrastructure also, Millard, in this judgment also, Millard, the application was filed immediately very well. Millard, in fact, setting this question of application being filed, even for a second, Millard, keeping it aside, Millard, the plaintiff has to come and at least pray for an interim order. Because if I am contemplating an urgency, that is because I want an interim order to protect or preserve my rights.
That
which
is,
absolutely absent in this present case.
That's what my lord Haldibari has held. My lord Justice in Haldibari, my lord Justice Basu Chaudhary, my lord, has refused to consider anything after the plane, saying that it's at the juncture of granting. Whatever happens thereafter is not important at all. So, my lord, whether, my lord, interim application is made, not made, he has said that that is not when you're granting the leave at that point in time, is it urgent or not urgent?
This code is only to
Only
consider on
that.
what the dispensation has been granted under 12A at that point of time.
At that point in time.
That is the only thing.
Very grateful.
Millard,
If you
about
like.
Gabriel Millard, just one.
Yes, yes, yes.
And regarding Gabriel Millard, even if Lordship considers that the test in 17, 15 and 17, there is no inconsistency, then also this 3 months, Millard, the test is not, Millard, satisfied by the plaintiff. He files an application after 12 months on the self-same grounds, Millard, paragraph 74, 75 of the plaint and paragraph 70, similar paragraphs on the same grounds. So the urgency that was there in July 2022, while presenting the plaint and praying for the urgency is the same as in the application for injunction 1 year thereafter. So if he could wait 1 year, so he could have very well exhausted the remedy and come thereafter. That is my submission.
No. That, Millard,
Millard,
I tried to cover in the note, Millard, because I've explained, Millard, that when I had filed, Millard, even 1 year before I filed the suit, I had come by way for section 9.
May I just take one leaf from your court, Millard, Lordship Millard? May I file the Millard written notes tomorrow morning, Millard? I'll mention it. Great.
Grateful.
When you file? Tomorrow?
Tomorrow morning.
I only, Millard, one thing. Millard, this entire argument is only, Millard, confined to, Millard, GA number
2.
GA number 2. Millard, the other GAs.
GA2.
Of course, Millard, if GA, lot will turn on the other, on whatever, whichever way you're only 2.
Sensation suffering for the plaintiff, sensation suffering for the defendant. Hearing concluded in connection with GA2 of 2023. Counsel for the plaintiff has filed written notes of argument. Let the same be kept with the record. Counsel for the defendant prays for a day's time to file written notes of argument.
If not inconvenient, can I file it by 12?
Huh?
Can I file it by 12 day after? If not inconvenient, otherwise I will file it tomorrow.
Prays for time to file written argument. Let the written full stop. Let the matter appear on 13th March as to be mentioned for filing written notes of argument by the
I'm deeply obliged.
Commercial 12th कर दो फिर. Commercial है.
Yeah, I can mention Miller on 12th, Miller Lordship. If doesn't also record that, I can mention and
come on 17. Give the 17.
Right.
17.
Great.
Yes, next. Item number 7. हाँ? 7 तभी हुआ ना?
6 and 7 same matter.
8.
Lord, Mr. Thakkar was to give his reply. The Lordship recalls this was our suit. It's a money claim. They had been taking adjournments on the pretext that there's a SLP pending.
Which one?
My Lord, item number 8.
SLP pending?
Yes, please. It's an order 8 rule 10. Lord, there was a SLP pending from a different order. But my order 8 rule 10 is on the pretext that he is supposed to conclude his submissions. Mr. Thakkar had assured us that if it's taken up, I'd mentioned in between, my Lord. I don't know. I can't see him. Neither do I see. I think he's there, my Lord.
I beg to appear for the defendant. Lordship, I am led by my senior, Mr. Thakkar. He's traveling now.
So he's addressed before this court today morning.
Yes, he's here. He's here. He's here. He's here.
He's here.
I joined, my Lord. I've joined. I was just waiting to be added as panelist, my Lord. I've joined.
He's here.
Yes, yes.
Mr. Thakkar, as he has assured us, he's here.
Yes.
Conclude his
Yes, my Lord. I will try to conclude my submissions today, my Lord. I cannot assure Mr. Ghosh that I will
there's nothing of the sorts. Mr. Thakkar, you can take your
You will get only 15 minutes, not even 15 minutes, 12 minutes. Okay, no problem. Continue.
Good for us, my Lord. Your Lordship remembers this was a partnership dispute.
Correct.
I am admittedly one of the heirs of the deceased partner. Now, this suit has been filed, my Lord. This is a suit for declaration and and mandatory injunction that for payment of certain amount which the plaintiff has assessed. Your Lordship has seen the facts. Then after an Order 7 Rule 11 application was moved, Your Lordship had kept the issue of maintainability open, especially with regard to the prayer of injunction which is sought, my Lord, prayers D and E.
Yes.
To that extent, your lordship, I said your lordship will decide at the time of final arguments.
Yes. As the
Now, my
preliminary.
lord, the final arguments have been advanced on behalf of the plaintiff, and yes, that was on the preliminary whether the suit is maintainable or not on press D and E. Your lordship had said that will be decided subsequently, not at the 7-11 stage. Now, the final arguments on behalf of the plaintiff have been advanced, my lord, and they have not advanced any argument on this issue. Perhaps they will do that in reply.
Yes.
But what they have specifically said, my lord, or order 8 rule 10 for a final decree.
Correct.
Now, I have shown your lordship, I have taken your lordship to the plaint, my lord, and I have shown your lordship how each paragraph of their cause of action is dependent on evidence being adduced. There is always no evidence on record. I have taken your lordship to the plaint, so I will not trouble your lordship again with the plaint. I have also, my lord, tried to distinguish in my own way the judgments cited by them. Now, my lord, if your lordship now kindly permits me to place some decisions for your lordship's kind consideration. Kindly first have 1999 8 SCC 396. My attorney must be there, my lord. Mr. Munshi is.
Yes, he's there.
Yeah, Mr. Munshi, please hand over 1998 8 SCC 396. This seems to be, my lord, the parent judgment on Order 8 Rule 10 and the scope of Order 8 Rule 10. Of a summary decree being made under Order 8 Rule 10, this seems to be the parent judgment, which is also relied on in the judgment cited by the plaintiff. (1998) 8 SCC 396.
Yes.
Now, my lord, kindly see paragraph 2. Just 3 lines are relevant, my lord, just to show your lordship what the suit was. At page 402, please, my lord.
Yes.
Sunil Madan filed a suit in the Delhi High Court against the appellants and respondent number 2 for specific performance of an agreement for sale in respect of this property. The suit was filed in so and so. Now, my lord, no written statement was filed in this suit. I need not trouble your lordship with the further facts. It was a suit for specific performance, no written statement filed. Now, my lord, kindly come to paragraph 3. Since the written statement was still not filed, the court decreed the suit for specific performance in favor of respondent number 1 under Order 8 Rule 10 of the code. The respondent number 1, who was the plaintiff, my lord, was directed to deposit a sum of rupees 3 lakhs being the balance amount of sale consideration, etc. Now, other facts, my lord, I'm not troubling your lordship with, the decree was made. Then kindly see paragraph 6. Since the suit has been decreed by the High Court under Order 8 Rule 10 of the code, we will first examine the provisions contained in various rules of Order 8 to find out whether the jurisdiction was properly exercised by the High Court in decreeing the suit under Order 8 Rule 10 of the CPC. This is the moot issue before your lordship also, whether the plaintiff is entitled to a decree as prayed for in this suit. Now, my lord, Order 8 Rule 1 provides that the defendant shall file a written statement of defense. It is further provided by Rule 3 of Order 8 that it shall not be sufficient for a defendant in his written statement to deny generally the grounds alleged, but the defendant must deal specifically with each allegation of fact which he does not admit. The further requirement as set out in Rule 4 is that the allegation made is denied, the denial must be evasive. Then Order 8 Rule 5 is noticed. Now, kindly see 9. Kindly see the next paragraph. The scheme of this rule is largely dependent upon the filing or non-filing of the pleading by the defendant.
Yes.
Sub-rule 1 of Rule 5 provides that any fact stated in the plaint, if not denied specifically or by necessary implication, or stated to be not admitted in the pleading of the defendant, shall be treated as admitted.
Correct.
Under Order Rule 3 of Order 8, it is provided that the denial by the defendant in his written statement must be specific with reference to each allegation of fact made in the plaint. A general denial or an evasive denial is not treated as sufficient denial, and therefore the denial, if it is not definite, positive and unambiguous, the allegations of fact made in the plaint shall be treated as admitted under this rule. Kindly bear in mind, these relate to written statement only. Order 8 is only related. Now, kindly see. Paragraph 10, very important. The proviso appended to this rule is important. in the sense that though a fact stated in the plaint may be treated as admitted, the court may in its discretion still require such admitted fact to be proved otherwise than by such admission. This is an exception to the general rule of evidence that the fact which is admitted need not be proved. So even where a written statement is filed and a fact is not specifically denied and therefore deemed to have been admitted, court need not make a decree, my lord. Court may still require the plaintiff to prove his case. Then, my lord, kindly see the next paragraph. Sub-rule 2 provides that if the defendant has not filed his written statement, it would be lawful for the court to pronounce judgment on the basis of the facts contained in the plaint. The rule further proceeds to say that notwithstanding that the facts stated in the plaint are treated as admitted, the court, though it can lawfully pass the judgment, may, before passing the judgment, require such facts to be proved. The rule is thus in consonance with a proviso which also requires the fact, even though treated as admitted, to be proved. Thus, the proviso and sub-rule 2, that is sub-rule 2 of order rule 10, my lord, read together indicate that where an allegation of fact made in the plaint is not denied specifically or by necessary implication or stated to be not admitted in the pleading of the defendant, or, and we fall in the fourth category, the defendant has not filed the written statement, such allegations of fact shall be treated as admitted. The court in this situation can either proceed to pronounce judgment on such admitted facts or may require the plaintiff, in spite of such admission, to prove such facts. So, my lord, it is not automatic. It is discretionary. It is not mandatory that your lordship will pronounce judgment in every case where there is no written statement. Even if there is no written statement, your lordship can direct him to prove the facts. In this case, my lord, that does not arise because he said, I will not prove. Then, my lord, kindly see 12. Sub-rule 2 quoted above is thus an enabling provision which enables the court to pronounce judgment on the basis of facts contained in the plaint if the defendant has not filed a written statement. What is important to note is that even though a written statement is not filed by the defendant, the court may still require a fact pleaded in the plaint to be proved. So your lordship may require the fact to be proved even otherwise.
Yes.
Then my lord, kindly see paragraph 14. This rule, namely rule 10, was also amended by the Code of Civil Procedure so and so. Prior to its amendment, it was held in a number of decisions that the rule can be invoked only in those situations where the court has required the defendant to file the written statement in terms of Rule 9 of Rule 8. A few other high courts had taken this view that the rule would be applicable even to those cases where written statement was required to be filed under Order 8, Rule 1 CPC. The conflict of decisions has been set at rest by providing specifically under this rule that where a party from whom a written statement is required under Rule 1 or Rule 9 of Order 8 fails to present the same within the time permitted or fixed by the court shall pronounce judgment against him or make such order in relation to the suit as it thinks fit. Rule 10, then your lordship sees the italics part. This is the amendment brought in. Rule 10 thus governs both the situations where a written statement is required under Rule 1 of Order 8 or where it has been demanded under Rule 9. In both the situations, if the written statement has not been filed by the defendant, it will be open to the court to pronounce judgment against him or make such order in relation to the suit as it thinks fit. It is to be noticed that if the written statement is not filed, the court is required to pronounce judgment against the defendant. The words against him are to be found in Rule 10 of Order 8, which obviously mean that the judgment will be pronounced against the defendant. This rule also gives the discretion either to pronounce judgment against the defendant or make such order in relation to the suit as it thinks fit. These words are of immense significance in as much as they give a discretion to the court not to pronounce judgment against the defendant and instead pass such other order as it may think fit in relation to the suit. There are thus two separate and distinct provisions under which the court can pronounce judgment on the failure of the defendant to file written statement. The failure may be either under Order 8, Rule 5, Sub-Rule 2, under which the court may either pronounce judgment on the basis of facts set out in the plaint or require the plaintiff to prove any such fact. Or, this is where we are coming, my lord, or the failure may be under Order 8, Rule 10 CPC, under which the court is required to pronounce judgment against the defendant or to pass such order in relation to the suit as it thinks fit. So, my lord, Order 8, Rule 10 is merely an enabling provision like Order 12, Rule 6. It does not make it mandatory that judgment has to be pronounced. And this, my lord, and I'm sorry, my lord.
Yes, continue.
This analogy has now been drawn also in this case. My lord, kindly see now paragraph 17, where a decision of the Jammu and Kashmir High Court is noticed with approval. Or on the authority of these observations, Rule 10 can be taken to relate to Rule 1 of Order 8, and on the defendant's failure to file written statement of his defense when so required, the court has the power either to pronounce the judgment against him or make such order in relation to the suit as it thinks fit, depending. Now, my lord, kindly say, depending upon whether the suit was for the final disposal or for the settlement of issues only. Now, today, my lord, it is before your lordship for final disposal. In the latter case, the court has ample discretion to grant more time for filing the written statement or to proceed to hearing of the suit without such written statement. My lord, in this case, in our case, discretion is not there because it is a commercial suit. So your lordship cannot extend the time even if your lordship thinks it is appropriate. But I cannot seek extension, my lord, because it is a commercial suit. So I cannot do that. Then kindly see, the discretion cannot, however, be exercised arbitrarily in determining which course to adopt. The court will always be granted. So we are not concerned with this. Now kindly see next, where the court decides to proceed to hearing of the suit without the written statement. This is what they have asked your lordship to do. That would not debar the defendant from taking part in further proceedings. His participation would, however, be hedged in by several limitations. He will not be able either to cross-examine the plaintiff's witness or to produce his own evidence with regard to any question of fact which he could have pleaded in the written statement. He will, however, be competent to cross-examine the plaintiff's witnesses in order to demolish their version of the plaintiff's case.
Correct.
So, my lord, I had the right to cross-examine his witness. He shied away from the witness box, my lord. He said, I will not lead any evidence.
Correct.
So he has prevented me, my lord, from cross-examining his witness. So he has not adduced any evidence. And his state is that you please pronounce judgment whichever way on the plaint case. So then your lordship kindly see the next judgment also, which is noticed with approval. Allahabad High Court. And all the other courts I'm not troubling your lordship with. And I'll just show your lordship paragraph 24, please, my lord. Where, my lord, the parity with Order 12, Rule 6 is drawn.
Yes.
In Razia Begum versus Sahibzadi Anwar Begum,
Which
it
paragraph?
was
Which paragraph?
paragraph 24, please, my lord.
Yes, Razia Begum, yes.
Yes. In Razia Begum versus Sahibzadi Anwar Begum, it was held that Order 12, Rule 6 has to be read along with the proviso to Rule 5 of Order 8. That is to state, notwithstanding the admission made by the defendant in his pleading, the court may still require the plaintiff to prove the facts pleaded by him in the plaint. So, my lord, even if there is an addition, it has to be read in conjunction with Order 8. Then kindly see paragraph 25, please, my lord. I'll take some time on this judgment because this is the lead authority, my lord, on Order 8, Rule 10.
Okay,
Kindly see 25. Thus,
just a minute. Huh? So other matter is fixed at 3:45. So you have to stop here. How much time take in this?
my lord, should I complete this judgment or
Yes,
come back, my
you
lord, on the
complete this
next stream?
judgment. You complete this judgment.
Then, my
Yes,
lord, may I come
continue.
back? I will complete this only. Kindly permit me to complete
Yes,
this, my
yes,
lord.
yes.
Paragraph 25, your lordship says.
Yes.
Thus, in spite of admission of a fact having been made by a party, in spite of admission of a fact having been made by a party to a suit, the court may still require the plaintiff to prove the fact.
क्या हुआ?
Wi-Fi gone.
Facts admitted need not be proved. No fact needs to be proved in any proceeding. Section 58 is noticed. Then kindly see 26. The proviso to this section specifically gives a discretion to the court to require the facts admitted to be proved otherwise than by such admission. The proviso corresponds to the proviso of Rule 5.1 Order 8 CPC. In view of the above, it is clear that the court at no stage can act blindly or mechanically while enabling the court to pronounce judgment in a situation where no written statement is filed by the defendant. The court has also been given the discretion to pass such order as it may think fit as an alternative. This is also the provision under Order 8 Rule 10 of CPC, where the court can either pronounce judgment against the defendant or pass such order as it may think fit. In paragraph 28, your lordship will make a note. I'm not placing the entire paragraph because it shows the parity between 12.6 and Order 12 Rule 8. Then kindly see paragraph 29. As pointed out earlier, the court has not to act blindly upon the admission of a fact made by the defendant in his written statement, nor should the court proceed to pass judgment blindly merely because a written statement has not been filed by the defendant, traversing the facts set out by the plaintiff in the plaint filed in the court. In a case especially where a written statement has not been filed by the defendant, the court should be a little cautious in proceeding under Order 8 Rule 10. Before passing the judgment against the defendant, it must see to it that even if the facts set out in the plaint are treated to have been admitted, a judgment could possibly be passed in favor of the plaintiff, now kindly see, without requiring to prove any fact mentioned in the plaint. This I lay great stress on, my lord, because his entire cause of action paragraphs, all his paragraphs which say cause of action, all of them depend on facts being proved. It is a matter of the court's satisfaction, and therefore only on being satisfied that there is no fact which needs to be proved on account of deemed admission, the court can conveniently pass a judgment against the defendant who has not filed the written statement. But if the plaint itself indicates that there are disputed questions of fact involved in the case, regarding which two different versions are set out in the plaint itself, it would not be safe for the court to pass a judgment without requiring the plaintiff to prove the facts so as to settle the factual controversy. Such a case would be covered by the expression so and so. And then, my lord,
Mr. Thakkar, on this, in this paragraph,
yes, please, my lord.
Their contention is that while earlier when this court has disposed of the interlocutory application, this court is of the view that the interpretation of one of the clause of the partnership deed is required.
Yes, please, my lord.
The portion with regard to the 42, that okay, preliminary issue, and the issue is to be decided during the trial.
Yes, please, my lord.
And with regard to your, what is your objection, that is not on record.
Yes, my lord.
And the amount which the plaintiff intend to give to the defendant, the other two heirs are already accepted. And
yes, ma'am.
He has even in the communications also, he has not given any details what is his right or what is your contention, what is his contention with regard to the if that contention would have been there, then it can be said. But there is no item of document in the plaint or saying that this is my objection, this is considered so as like having my 20 lakhs or that is not in the, so how you
I follow what is troubling your lordship, my lord. I have made a note of this, my lord. Today I'm out of time. Let me consider this and address your lordship tomorrow, please, my lord.
Correct. Please come on that, because they have argued only on the point that this court has held that the interpretation of the clause of the partnership deed.
My lord, they have argued that, but I don't think, my lord, that is the correct.
I will take care of it. I will
Yes.
What is the argument? No, I am not. With regard to, okay, the court can go for the evidence or whatever it is. But the question is that what is your objection? Okay, you have not filed the written statement, but what are the communication made by you with the plaintiffs, with the defendants? You with the plaintiffs, you have not stated anything. No, this is not correct. This is the calculation, and this agreement says this, the partnership this says this, and I am entitled for this.
I follow, my lord. Now, may I just give one indication, my lord, of what one of my arguments to that will be? Just one indication, my lord. Kindly permit me. My lord, none of those correspondence which my learned friend wants your lordship to refer to, none of that is on record. There is no evidence. There is no evidence. So today, my lord, we only have the plaint.
Plaint. Correct.
Nothing else.
That's
No-
I'm telling you. Because today this court is only having the plaint. Correct.
Yes.
You have not filed the written statement.
Yes.
Correct. Now you cannot develop your defense. You cannot develop your defense.
I
only-
bow down.
You can take only defense with regard to the plaint case.
Yes, my lord. I will. In other words, my lord, I have to show that the plaint case cannot succeed.
Correct. You
Yes.
Okay.
Yes. I will do that, my lord.
So
I will restrict my arguments to that.
So and so offering for the plaintiff, so and so offering for the defendant. Counsel for the defendant has argued at length, but due to paucity of time, hearing could not be completed. Let the matter. Let it be remain in the list. It will be available tomorrow.
And on virtual mode, I can do, my lord, but this matter, my lord,
okay.
I'll leave it to your lordship, my lord. My learned
When you
friends
will be
will
back?
object.
When you are coming back?
My lord, on Monday, my lord. 17.
Let the matter appear on 18th under the same heading.
But 18th, my lord, can't it be, my lord, anytime before that if it's possible, my lord?
Kindly keep it tomorrow, my lord. I'll do virtual, no difficulty, my lord.
He's coming on 18th.
Very well, very well.
No,
my
no,
lord.
I will do it virtually, my lord. No difficulty. My learned friend.
Very well, very well.
18th.
Grateful, man. Deeply obliged. Deeply obliged.
Picture 345, file number 33 of the commercial.
Yes.
ভুলভাল দিকে কেন তুমি পিটিশনে তুমি আমি তো ওদিকে ছিলাম নির্মল জায়গায় ঢুকে পড়লে আছে এটাতে আছে
What hearing? GA3.
সরি GA3 value. Kindly, Section 8 application, kindly take up the application, I mean, the affidavit in support of my lord, the master summons.
Section 8 application GA1.
GA3. GA1 is the plaintiff's application for injunction. GA2 was, my lord, the defendant's application for extension of time to file written statement, which I understand has been, my lord, dismissed by your lord.
Your disposal. Yes.
The time has not been
And
extended.
GA3 is for
Section 8.
Section 8
Yes.
for revocation of the leave. Yes. Revocation of leave.
It's a, my lord,
Referred to arbitration revocation. Yes.
combined application, my lord, which prayers are, according to me, my lord, maybe I am wrong, my lord, are mutually exclusive. If your lordship is pleased to look into the prayers once in the master summons.
That's why I was confused. Yes.
If your lordship is pleased to look into the, my lord, the prayers, prayer A, the dispute between the parties be referred to arbitration in accordance with the terms of the arbitration agreement between the parties. Kindly see prayer C. Leave under clause 12 of the latest patent granted to the plaintiff by order dated such and such, passed in such and such, be recalled, and the suit be dismissed as not maintainable before this honorable court. That means, my lord, the civil suit is maintainable but not before this court. That is, my lord, prayer C. But I proceed on the basis, possibly, my lord, the argument was also advanced before your lordship on Section 8. I was not there on the last occasion, but I am proceeding on the basis that, my lord, they are pressing, my lord, the Section 8 application only and not the prayer C. Right?
Continue
Alternative.
with both.
They have to choose them. They have to choose. They cannot, my lord, say.
I would.
No, I will
No,
address your lordship
But
accordingly.
see, if your case is that maintainable, so the court cannot refer.
Then civil court has no jurisdiction, whether this court
Not
or some other court.
maintainable. So Section 8 application cannot decide this court.
Now, my prayer A, my principle with this sort is that this is referable to arbitration.
Correct.
Now, I have also said, my lord, the relief has to, my lord, seen in the context of the pleadings. It cannot be seen in isolation. Now, yes, probably could have been worded better. That's our fault. But be that as it may, my lord, I have also said in my application as many words that even otherwise, this court does not have jurisdiction because any and every dispute that arises out of in connection with the contract is referable. It has to be entertained by a competent civil court at Bokaro because that's a forum selection clause. So if I get A, then my lord, entire thing, my lord, is really.
No. If this court is not, if the selection
Lordship.
forum selection clause is there,
Lordship.
so the suit is not maintained. How this court can pass an order?
If the arbitration, lordship would kind.
And how this court can refer the parties to the arbitration if this court is not having the jurisdiction under the forum selection clause in your agreement?
Now, I have, my lord, in my petition, I have said, my lord, I bow down, my lord, I have said that this suit is not maintainable before this honorable. I have said in my petition that this suit is not maintainable before this honorable.
So whether which prayer you are pressing, A or C?
Now, if I get, my lord, either, if I, my lord, get
No, it can't. It can't.
Can't be.
You cannot say no. You refer. If you not refer, the section 12 to be revoked because the jurisdiction. So first is the jurisdiction point.
There is no bar, my lord. My prayers are already there. Relief shall be sought.
Prayers is there. So that's why. So which prayer you are pressing for?
Oh, my lord, I am not conceding to this. I am not. Whatever consequence would follow, lordship would decide that. Consequence follow, my lord. Lordship has made my lord's view clear. Consequences are there. I accept the consequences.
That's it. Because when I taken your file in the prayer portion, not prayer portion, in paragraph page 11, page 11, paragraph 28 of your application. It is submitted that in the facts and circumstances as stated here in above, it is just necessary and proper. This honorable court may kindly please to revoke.
Yes.
Para 28.
Now, my lord, revocation of leave, my lord, I say that because the cause of action, because of that particular forum selection clause, and also otherwise the cause of action has arisen within Bokaro, which gives that court jurisdiction. My lord, clause the leave should have been revoked. Leave should be revoked. But as far as the arbitration agreement is concerned, which stares in the face of it, that remains. Now, today, my lord, I come before your lordship. I say that this suit is an action which is covered by an arbitration agreement. Irrespective of, my lord, whether this court decides as to whether this court has jurisdiction or not, your lordship can refer it lock, stock, barrel, if I may use the expression. But your lordship finds that there is in fact an arbitration agreement which covers this action. Now, under section 8, your lordship can refer that. Your lordship can keep that question open.
What?
As far as the jurisdictional court is concerned.
How? If the court is not having jurisdiction to entertain
this
your...
is my, I understand. Now, to a different angle. Now, my lord, this court is entitled to receive a suit, receive any action, not because any agreement between the parties, but because of section 9, clause 12, all this. Section 9 of code and clause 12. Now, so there is neither, my lord, I am not saying there is an inherent lack of jurisdiction. I am only saying...
Forum selection.
Yes, there is an ouster of jurisdiction.
Correct. Ouster of jurisdiction, also the jurisdiction.
Ouster of jurisdiction, my lord, which is, my lord, from the agreement between the parties. If it's agreement between the parties and not an inherent lack of jurisdiction as such, my lord, then, my lord, probably, lordship would decide on this and I would try to assess, my lord. A and C are not mutually destructive. If it would have been case, if it would have pleaded the inherent lack, then, my lord, I understand what is. But this probably, my lord, are not mutually destructive. I will try to assess, my lord. But I am not, my lord. In fact, my lord, Mr. Basu was there who had pleaded this. Now, Mr. Basu had pointed out to me, my lord, on the last occasion, Mr. Dasgupta on the other side has taken this issue. Probably he had also made this suggestions. I've considered it, would have been happier, worded happier, but my lord, I am not.
Okay.
My lord, in that event, subject to my lord, it's entirely on your lordship, my lord, to take the.
Yes.
Now, according to me, my lord, they have to take the call first.
That's
Today, yes, has fell from your lordship for the simple reason my learned friend says forum selection clause. Very well, forum selection clause, my lord, that implies if they want to invoke that, my lord, that implies that a civil court has jurisdiction. On the one hand, in prayer A, they are saying that no, civil court has no jurisdiction, it has to go before the arbitrator. On the same breath, my lord, they cannot say that, my lord, not this civil court, but some other civil court has
That's
jurisdiction.
what the forum selection.
That they have to take the call, my lord. This is my
Then,
understanding.
then you proceed with the matter.
No,
what you want.
I am not, my lord, conceding to this that I have to.
No, you have to choose.
No, you have to then argue the matter. Then the court has to decide first.
Yes, of course.
Whether this court is having this jurisdiction or not.
Of course.
And my lord, whether this
it can
mutually, my lord, exclusive prayers can be, my lord, considered without, my lord, lordship is aware, my lord, normally. In pleadings also, my lord, on occasions, my lord, we take, my lord, mutually exclusive, my lord, defense, but before, my lord, going for trial, we have to choose one.
That's correct.
That has to be done here.
But the problem is that in the original site rules, you are making filing a general application, G application, combined prayer,
Yes, but those are
combined
not
prayer.
mutually exclusive. Receiver plus injunction, neither of it, my lord, can be said to be mutually exclusive. When mutually exclusive, my lord, this, according to me, my lord, is again. Because while reading, my lord, it struck me that this possibly cannot happen. Prayer C, my lord, presupposes that civil court has jurisdiction. Not this court, but by some other court. If that is, my lord, allowed, then, my lord, the arbitration prayer A goes.
एक सिमिलर एक मैटर डिसाइड किया था ना, सीनियर गुप्ता अपेयर किया था, क्या था उसमें? You decided one matter. You got the order, Mr. Dasgupta. Have you got the order?
Yes, my lord. I think it is one of the desk.
Apropos the submission advisement and senior friend, only one thing may I clarify, not on the law, but only on
দুটো পয়েন্টই ছিল।
Now, if I understand correctly, my lord,
paragraph 14.
Mr. Mitra's submission is this, that these prayers, the reliefs as it's framed right now, it shows that I am either saying it has to be arbitration or a civil court would proceed. But that's not the purport of my pleadings. Even if they're worst, so to say. The purport of the pleadings is that all dispute in connection with the agreement, touching upon the agreement, it may be arising from in connection with the arbitration procedure.
Is it DASCON matter, my lord? I really do not.
Let me see. I will not remember.
No, definitely it's not possible. Yeah. No, I don't think, my lord, this is the one.
Not this. Another,
This is on a different point.
not this. Another one is.
No. Because my noting is, my lord, on other point. I would be relying on this, but on other point.
No, not this. Another one judgment.
Can't be.
I will check. Yes.
No.
So you wanted to proceed with the both the prayers. So in that case, okay, you continue with your regard C prayer.
Yes.
That is.
Now then, Lordship would kindly allow me, because Mr. Basu already made his submissions, but I will try to, my lord, with a very
Yes,
short.
Basu, I have taken all the notes.
Yes,
I have
yes,
taken notes. No
that's
problem.
why I would not try to, my lord, repeat it, but make it within very short compass. Now, Yes. May I not proceed?
Yes.
Suit, the claim filed in connection with the suit, there is no reference to the arbitration agreement at all. Now, I say that the dispute is covered by an arbitration agreement, that there is existence of an arbitration agreement between the parties. The fact that there is existence of an arbitration agreement between the parties is not disputed. What is disputed is this, as I get, my lord, from the opposition as also from the
This is not coming under the expected matter.
accepted matters. This is the only difference. Second, it is also said, and to be fair to my learned adversary, that even in the interim order, ad interim order stage, this submission was made that this is mutually destructive.
Correct.
So it's a couched in a different form, but it was made. Now, first, my lord, I say that as far as Section 8 is concerned, once the court finds that there is an arbitration agreement between the parties, the existence of and validity of which is not disputed, the court has to, the positive mandate, court has to refer the dispute to arbitration. Now, as far as accepted matters are concerned, Lordship would kindly see the concerned provision.
Yes,
The
page
clause.
76, 49.
Page 70, Lordship.
Clause 49.
Lordship. Now, clause 49 says, may I may not place only the first paragraph. All questions, claims, disputes, or differences of any kind whatsoever arising out of or in connection with or concerning this contract at any time, whether before or after the determination of this contract, other than questions, claims, or differences for the decision of which specific provisions have been made in the foregoing clauses of these conditions, hereinafter referred to as accepted matters, and decision on which accepted matters according to the said specific provisions shall be final and binding on the parties to this contract, and shall not be reopened if attempted to reopen on the ground of an informality, omission, delay, or error in the proceeding, or any other ground whatsoever, shall be referred by the parties hereto for the decision by a sole arbitrator to appoint as hereinafter mentioned. So even this clause, arbitration agreement, now I'll come to the judgment referred to my learned friend. Even this clause says that all these accepted matters, if the issue is attempted to be reopened by any party, this would be subject to arbitration. In other words, my lord, if the party is one or any of the parties is entitled to maintain a civil action, regular civil action like a suit, in any of these matters, then instead of a suit, it has to be an arbitration. Now, as against that, now Lordship would consider the judgment that has been relied upon my learned friend. 2014 9 SCC 246. Now, Lordship would kindly straight away.
2014?
2014 9 SCC 246.
What is the name?
Harsha Constructions versus Union of India. Lordship would kindly straight away come to page 249.
Yes.
At the top, clause 63.
Yes.
Page, clause, paragraph 3, continue.
Paragraph 4. Paragraph 6. 249. Paragraph.
This is continuation of paragraph 3. They're at the top of that page, clause 63.
Harsha Construction versus Union of India. Acha, you are referring from which citation?
SCC online.
SCC online. That's my SCC.
May I, my lord?
ये पानी डालने वाला अच्छा लगता है.
Yes. This. Top.
That is paragraph 3.
Yes, continuation paragraph 3, clause 63.
Oh, clause 63.
clause 66.
Yes.
All disputes and differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of the work or after its completion, and whether before or after the determination of the contract, shall be referred by the contractor to the railway, and the railway shall within a reasonable time after receipt of the contractor's presentation make and notify decisions on all matters referred to by the contractor in writing, provided that the matters for which provision has been made in clauses 18, 22, 5, 39, which is relevant in this case, of the general conditions of contract, or in any clause of the special conditions of the contract shall be deemed as accepted matters, and decisions thereon shall be final and binding on the contractor. Provided further that accepted matters shall stand specifically excluded from the purview of the arbitration clause and shall not be referred to arbitration.
Correct.
So here, clause 39, which is relevant and page just before quoted. Here, the accepted matters, clause 39, there is a positive mandate that it shall not be referred to arbitration.
Correct.
As against that, our case, my lord, clause 49 at page 76, that's a positive mandate is that shall be referred by the parties hereto for decision by a sole arbitrator.
Correct.
So,
no. Provided provisions have been made in the foregoing clauses of this condition herein after referred to as accepted matters, and decision on which accepted matter according to the said specifications shall be final and binding of the parties to this court and shall not be reopened.
Yes.
Shall not be reopened if attempted to be reopened on the ground of infirmity, omission, delay, or any other group shall be referred to the
arbitration.
Arbitration. Okay.
So they have sought to reopen it. Now, Lordship would kindly see the relief sought. The plain. Page 51, running page 51. The right. A. Decrees or declaration that the entire banning process of the defendants in Australia banning the said business dealing with the plaintiff number 1 is null and void ab initio, contrary to law, illegal, invalid in nature, and contrary to the guideline of the banning of business dealings. B. Decree for declaration that the purported banning order dated so and so is illegal, unreasonable, null and void, liable to set aside.
Yes, banning order. Yes, challenge the banning order.
Yes.
Correct.
So now, if Lordship kindly comes back to page 76. This judgment was cited by Mr. Dashgupta on the last occasion. I am just trying to distinguish it. Now, page 76, clause 44, at the top of that page, if any of the staff of the contractor is caught in a theft case or in unauthorized movement of materials or in any activity which is punishable under law not authorized by the plant, the contractor will bear full responsibility for the loss or other consequence which may result to the plant, which is illegal unauthorized acts. Besides the action to terminate the contract with the plant, the contractor shall also be liable for any act leading to banning of business with him and follows the guidelines and everything is there. There is no dispute. Now, I have taken steps under guidelines. Now, they are trying to, instead of filing an appeal, preferring an appeal, I am not on that, whether they should prefer, they can. Instead of preferring the appeal or instead of taking my decision to be final, now they are reopening it. This is the purport of the suit. I am not saying they can't do that. All I am saying is,
yes,
the first paragraph of clause 49 shows that if it's reopened for any other any of the parties seek to reopen it for any other ground, any of the accepted matters, it has to be referred to arbitration. Paragraph 19, okay?
Yes. Then,
now, Lordship will also kindly consider in that judgment paragraph 19, which I believe was cited by my learned friend. Paragraph 19 at page 251. If a non-arbitrable dispute is referred to an arbitrator, and even if an issue is framed by the arbitrator in relation to such a dispute, in our opinion, there cannot be a presumption or a conclusion to the effect that the parties had agreed to refer the issue to the arbitrator. Now, here the parties had in fact agreed to refer the dispute to arbitrator.
Yes.
That's all. Now, another issue has been also raised, both in context of forum selection as also the arbitration agreement, as to whether the ad interim on injunction, order of ad interim injunction passed by your lordship, my lord, constitutes res judicata. Lordship would kindly take up my lord's order at page 13, 1-3.
Of the same?
Yes, yes. Sure.
Affidavit in opposition?
No, petition. I have announced the order.
Page 13.
13, 1-3.
Yes.
Lordship would kindly come to page 13. 13. Lordship would kindly come to internal page 3 of that order.
14, yes.
Yes, it should have been 15 anyway. The bottom, at the bottom. Par contra, the learned counsel for the defendants raised the issue of maintainability of the suit and draws the attention of this court to the terms and conditions of the notice inviting tender, particularly clause numbers.
Internal page 3 of the order.
Sorry,
yes.
I hope there's a missing instance in my learned senior principal. Not. Par contra, the learned counsel for the defendants raised the issue of maintainability of the suit and draws the attention of this court to the terms and conditions of the notice inviting tender, particularly clause numbers 14 and 50 of the said NIT. By referring the said provisions, counsel for the defendant submits that there are provisions of arbitration as per clause 50. There is a forum selection clause, and thus this court does not have the jurisdiction to entertain the suit. Counsel for the defendants has also drawn the attention of this court to the guidelines on banning of the business dealing by sale, wherein as per clause 10 of the guidelines, there is a provision of appeal within 30 days, but the plaintiffs have not invoked the provision of appeal prescribed time. Counsel for the defendants press for dismissal of application. This, my lord, I am not really pressing as far as appeal is concerned. Now, third, learned counsel for the respective parties produce the materials on record. Counsel for the plaintiffs has referred the judgment in the case of Perkins, wherein the Honorable Supreme Court has held that in a case where only one party has the right to appoint a sole arbitrator, his choice will always have an element of exclusivity in determining or charting the course of dispute resolution. Naturally, the person who has an interest in the outcome of decision of the dispute must not have the power to appoint a sole arbitrator. Then Lordship would kindly come to page 5, internal page 5, next page. The third paragraph from the top.
Yeah.
Learned counsel for the plaintiffs has also submitted that clause 49 and clause 50 of the NIT are contrary to each other and mutually destructive. As per clause 49 of the NIT, there is an arbitration clause, and in clause 50, there is a clause of civil court, and as such, both the clauses are destructive in nature. As such, this court is of the prima facie view that the objection raised by the counsel for the defendants is not sustainable. So, an objection has been taken in the opposition that this finding by your lordship as a prima facie view that the objection raised by me as per both these issues are concerned has attained finality because I have not preferred any appeal, and I cannot re-agitate this issue any further. Now, my lord, as far as now there is no quarrel to the proposition that there can be res judicata and apply at various stages of the same proceeding. There is absolutely no quarrel. Now, my learned friend has pressed into service, my lord. I find a judgment reported at 2022 SCC Online SC 1460. 2022 SCC Online SC 1460.
Yes.
This S. Ramachandra Rao versus S.
Nagabhushna Rao, yes.
22 SCC Online SC 1460. Now, lordship, before everything, it's very Axiomatic, I would say, but Lordship would kindly take up section 11 once again for my benefit.
Yeah, the CPSC.
It is to cover good.
Yes.
Yes. Now, section 11, res judicata, may I only my lord place. No court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a formal suit between the same parties or between parties under whom they or any of them claim litigating under the same title in a court competent to try such subsequent suit of the suit in which such issue has been subsequently raised and has been heard and finally decided by such court. So, if Lordship is of the view today that that order constituted finality, Lordship's final view on that date, that yes, for all times to come, I have decided that yes, your forum selection and none of these issues hold any water. Then I am out of court completely. But if Lordship is not, then my lord, in a most respectful submission, that is only a prima facie view. I am not even saying that just because Lordship has used that phrase prima facie view, it's not. But the nature of finding is an order of injunction on the first day. That, my lord, cannot bar me. My lord, judgment. Paragraph second, that now, now two judgments, my lord, rely upon. The first judgment is reported at 2013 15 SCC 15 SCC 655. She would kindly consider paragraph 34. 30.
Yes.
34. No. 31. My lord, my noting was incorrect. I was just 31. 31. No, sorry. After so stating, No, sorry, my lord, I 39. Because all these judgments I have read, also the judgments, I'm sorry, my fault. 39. 39. I also 39, yes. May I, my lord, please? From the aforesaid authorities, it is clear as crystal that to attract the doctrine of res judicata, it must be manifest that there has been a conscious adjudication of an issue. A plea of res judicata cannot be taken aid of unless there is an expression of opinion on the merits. It is well settled in law that principle of res judicata is applicable between the two stages of the same litigation, but the question or issue involved must have been decided at earlier stage of the same litigation. Now, here, the next judgment I want to rely upon is reported at Bombay there. 2018 SCC Online Delhi 29650. 9650. 2018 SCC Online Delhi 9650.
Same res judicata. Res judicata.
Yes.
Res judicata.
So should kindly consider paragraph 23 at page 7 of this judgment. It starts from page 6, that paragraph. So should kindly consider page 7. The third line from top. Supreme Court in so and so, the judgment I just cited, held that across the doctrine of res judicata, it must be manifest that there has been conscious adjudication of an issue. A plea of res judicata cannot be taken aid of unless there is an expression of an opinion on the merits. It is well settled in law that principle of res judicata is applicable between the two stages of the same litigation, but the question or issue involved must have been decided at earlier stage of same litigation. An order on an application under Order 39 Rules 1 and 2 of the CPC is not an order delineating on the merits of the respective contentions. It is only a prima facie view of the matter. So leaving aside all these judgments, the simple fact is, Your Lordship on that day found that yes, they have an arguable case, private is a case, and therefore, for the time being, this issue is left open. So that, my lord, that order, my lord, greater stress test, my lord, cannot be a bar me raising these issues now today. Any day.
That's all.
A little more.
What little more?
A little more. On the both these mutual, whether it's mutually destructive or not, that also have to. 15 more minutes.
Oh, না না আমরা বলা শেষ করে নিই জজের থেকে বেটার কেউ জান কি জানতো কি করি ওদের কথা তো বললো
Sensations suffering for the plaintiff, sensations suffering for the defendant. Counsel for the defendant has argued at length, but due to paucity of time, hearing could not be completed.
6 নম্বরেও যাতা করে
Then the matter fixed tomorrow. Let it miss tomorrow in the list, if time permit.
Can a time be fixed,
Yes,
my lord?
any day, any day.
Any day convenient to the court, my lord.
Fixing of time is the only difficulty.
My lord, I shall be very candid, my lord. Otherwise, my lord, I have an obligation to be present when the matter is called on.
17th March, 3:45.
Indian mode to extend.
Interim order.
Oh, there is an interim order till tomorrow, my lord.
Counsel for the plaintiff submit that interim order granted earlier is going to expire tomorrow and prayed for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 21st of March 2025 or until further order. Yeah.